Yes, sir, I do.
All right, you may be seated. While speaking to the microphone, please state your name and spell it for the report.
I'm Detective Matthew Principe, MatthewHewPrincipe.
Good morning, Detective Principe.
Good morning.
Where do you work?
I work for the South Fulton Police Department.
All right, and how long have you been there?
I've been there for 3 years tomorrow.
And prior to that, where did you work?
Prior to that, I worked for the City of Forest Park Police Department in Clayton County.
Okay, and so in all, how many years of law enforcement experience do you have?
Since summer of 2016 when I was an intern.
Okay, and so that would be about 9 years.
Yes, ma'am.
Okay. And what unit do you work in?
I work for what is now the major case division unit of the Criminal Investigation Division.
Okay, and back in 2024, July 2024, was there a different type of structuring at your agency?
I was a part of the homicide unit.
All right. And since then, it's just general investigations?
Correct.
Okay. So let's talk about the time that you were in the homicide unit.
Yes, ma'am.
How is that unit structured?
This was comprised of 4 detectives that made up the unit as a part of the major case section of the Criminal Investigation Division.
All right. And name the people that were in that unit.
It was myself, Detective Kelvin Thomas, Detective Dambrielle Thomas Walker. She got married around that time, and I don't remember during that time she had changed her last name, and Detective Unger.
Unger. As Sergeant is with Thomas Walker, would that be Sergeant Walker?
Yes.
Okay. And out of those people that you just named, how many assisted you in the investigation from July 4th, 2024?
Detective Thomas and Sergeant Walker both assisted me on that incident.
Okay. Now, when we say assist, do you guys work in a team or do you do isolated events or how does that work?
We work as a team. How we allocate responsibilities is contingent on the case. But there will be a primary detective which rotated through each detective of the unit, and the rest respond and support and conduct investigative responsibilities as needed that pertain to the case.
Now, how are you assigned to a case or a homicide?
It is through rotation, and then we get contacted by our supervisor and dispatched to an incident location.
Okay. And so on July 4th, 2024, who was up?
I was up next as primary.
You were up next as primary.
Yes, ma'am.
And it rotates back down.
Correct.
After that. Okay. And when you're up, are you on call? Do you have a specific shift?
The entire unit, it was in a 24/7 on-call capacity specifically for homicides and aggravated assaults where the patient is critical.
Okay. And so on July 4th, 2024, how were you notified that there was a homicide?
I was contacted by my direct supervisor that the homicide unit would be responding to the incident location of 4155 Pittman Road.
Okay. And back to my question, as working as a collective or working as a team, was it just yourself responding to that?
No, ma'am. Detective Calvin Thomas and Sergeant Walker both responded as well.
Okay. All right. Thank you for telling me how the unit is set up. Also, can you tell the jurors any experience or training that you have up until this point, including hours of and certifications?
Sure. Every detective that's part of the homicide unit, in addition to basic law enforcement academy and various scheduled trainings, we all have specialized training specifically in homicides, notably homicide investigations through the Georgia Public Safety Training Center, as well as I have received extra training from all over the country, including the New York State Police annual homicide seminars, as well as the Los Angeles Sheriff's Office homicide training course, which is a 2-week course as well.
Now, have you had any certifications as far as it relates to criminal street gangs?
I have also received specialized training from the Georgia Public Safety Training Center in gang identification and recognition, as well as gang prosecution. It's two separate training courses offered by the state of Georgia. And in addition, I'm also a member of the Georgia Gang Investigators Association.
Okay. Now, as far as experience, I understand that you were on the homicide, or you were on the with South Fulton for 3 years, but in total 9 years. How many scenes have you responded to in your career?
Hundreds of death scenes.
Specifically, death scenes.
Yes, ma'am.
Okay. And in those, in that, what capacity were you in when you responded to those homicide scenes?
Throughout my career, I've participated in almost every capacity from a new responding officer charged with securing a perimeter to all the way up to being the lead detective investigating the homicide.
Okay. And in those different capacities, do they have separate roles?
They do.
Okay. And briefly, can you explain the role of a responding officer as it in distinction with being a homicide detective?
Sure. Initial responding officers, their first priority would be scene security and rendering aid to any victims that may not be deceased or in need of any medical attention. Then it's securing a crime scene, isolating witnesses, and getting general statements from those witnesses. From there, the patrol supervisor will contact the detective supervisor, who will then contact a detective to respond. I responded to this location. It was around 1:15 a.m., which is now July 5th.
Right. Now, in distinction of the responding officer, what are the roles and duties of a homicide detective?
The duties of the homicide detective will include reviewing evidence that is located, contacting any sort of CSI technician to respond to assist, collection of evidence, interviewing witnesses, and taking further investigative actions that those initial steps may lead to.
Okay. And so is it fair to say that the role of a responding officer sets the foundation for the homicide detective?
Absolutely.
Okay. All right. Now, I know you stated what time you arrived to the scene. You said it was what time?
I was around 1:15 a.m. on July 5th, so it was after midnight.
Okay. What time, do you recall what time the call came in?
We received the 911 call at 11:29 p.m. on July 4th.
Okay. And when you arrived to the scene, what did you do?
So I initially confirmed that the scene had been secured by patrol officers, and then I conduct an immediate walkthrough and take note of any pieces of evidence that are visible to me.
Did you make contact with any of the officers that were already on scene?
I did.
Okay. Did you do a walkthrough with any of those officers?
There were several officers present. I don't recall which one specifically, but normally when I respond to scenes, including this one, the initial responding officers will provide me with an overview of the information that they've collected up until this point, as well as locations of where any bodies or evidence they have already located, and any sort of statements that they have received from witnesses.
Okay. And so let's talk about that. When you arrived to 4155 Pittman Road, what did the walkthrough entail? What was pointed out to you?
Yeah, so as I approached the residence, which is around a long driveway, officers showed me where the first victim was located. That was Mr. Corey Leonard, which was in a gravel wooded area away from the dwelling on the property, as well as some spent shell casings that they observed near the body. And they also documented certain pieces
Can you
of.
pause one second?
Sure.
I'm sorry.
right there.
Right, it's on. You're good. I'm sorry about that.
Yeah, they also noted things like um, the victim's contents of his pocket were next to him, believed to have fallen out during EMS's assessment and initial attempt to render aid, as well as what appeared to be some sort of textile cloth used to apply pressure by individuals who are on scene and rescue personnel in an attempt to save the victim.
All right. Um, outside of the victim or the decedent's body, were you directed to look at anything else or be in any other areas of the scene?
Not initially until we learned of a second victim. While we were responding to the scene, we learned of a second gunshot victim who is identified as Mr. Joshua Houston, who was pronounced deceased upon his arrival to Southern Regional Hospital.
Okay. And how did you know that you say second victim, how did you become aware that this victim was even associated with your scene?
The victim was transported to the hospital from the incident location, and that individual provided that information to medical personnel at Southern Regional, who then contacted us.
Right. And when you arrived at the scene at 1:15, was EMT already there?
They had been there and left already.
And was there any pronunciation by the time you arrived?
The EMTs noted that there was no signs of life, but the official pronouncement of him being deceased came from the responding medical examiners, investigators.
Okay. And were they on scene?
They did respond, yes.
Okay. So after you discovered that there was a second victim at Southern Regional Hospital, what did you do?
We then treated the vehicle that was driven to the hospital as a secondary crime scene, and I asked Sergeant Walker to respond to that crime scene.
Okay. Now, before we talk about that crime scene, I want to go into detail about the first crime scene, which is at 4155 Pittman Road.
Sure.
Was crime scene technicians or crime scene investigators called out to that scene?
They were.
And who called them out?
That would be the Criminal Investigation Division Supervisor, which was Lieutenant Dickerson at the time. When he dispatches us, he also dispatches Crime Scene Investigation Unit to respond.
And who did you make contact with from the crime scene investigations unit?
I believe it was Crime Scene Technician Reeves and Newton responded.
Okay. And who was the lead of the two of them?
That was Reeves. I believe Newton was in a training capacity at the time.
Okay. Now, what is the role? You explained the role of responding officers. What is the role of a crime scene technician?
Yeah, so their role is to preserve, collect, and then submit evidence to any agencies that would then do an analysis of that evidence, as well as take photographs and digital scans of the crime scenes.
Right? Is a crime scene technician to make any analysis or to analyze evidence in any kind of way?
It is not. Their responsibility is to submit that evidence to other agencies that will then conduct the analysis. For example, shell casings may be sent to the ATF for NIBIN analysis.
And so when crime scene tech Reeves arrived, what areas did you walk her through that you wanted to be photographed and items to be collected?
Yeah, so I instructed crime scene technician Reeves to take photographs of the crime scene. They take photographs in 3 different capacities, from a wide overall perspective, a intermediate range, and then up close on specific pieces of evidence. So that way, when the photos are shown and reviewed later, you have a overall story of what those photographs depict.
Okay. And do you ever or have you worked with crime scene technicians previous to this time?
I have on just about every call that I get sent out on.
Okay, so over 100?
Yeah, not the over the 100 wasn't always in a primary detective capacity, but every call out that I've had as a primary detective with the homicide unit always had crime scene investigations responding as well.
Okay. And so what you've just described to the jury of their role and limitations, has that been consistent over the 9 years that you've worked
It has.
in this capacity?
Yes, ma'am.
Okay. Um, Now, did you observe casings on the scene?
I did.
All right. And where were those casings in relation to other items of evidentiary value?
They were positioned between the body and the nearest point of reference would be the pool area of the residence, um, all near the body.
Okay. And did you instruct the crime scene technician Reeves to collect these casings?
I did.
Why?
Because at the time, I believe that, the casings would have evidentiary value.
Okay. Um, was there any reason to believe that they wouldn't?
One of the casings that I observed, specifically 22 caliber casing, appeared to be submerged into the gravel sand, like it had been there for an extended period of time, potentially unrelated to the incident.
But you collected it anyways.
Yes, at crime scenes, we don't get a chance to go back and collect evidence and redo it often. So I am a firm believer of collect everything on scene, whether it is relevant at the time or not, because I will not have a chance to go back and recollect it.
Okay. Now, in your time at South Fulton Police Department, are you familiar with 4155 Pittman Road?
I am, yes.
And has your units responded to that scene prior?
Yes, multiple different units with the South Fulton Police Department have. It is what I would consider to be a high call volume in residence.
And what types of calls would you get?
Um, Shootings, shots fired calls, noise disturbance calls, you name it, there's probably been a call at that location for.
Okay. And 4155 Pittman Road, that is in the city of South Fulton?
Yes, ma'am, it is.
Okay. And is the city of South Fulton in Fulton County?
Yes, ma'am, it is.
Okay. Now, when an item is, I just want to make sure I understand about this item being submerged in dirt. Um, what what gives the appearance that a casing has been there for a minute or is worn or something like that?
Uh, Specifically, the factors would be in this specific case, with it being submerged into the gravel lot, which has lots of foot traffic, vehicles going through. But it was notably different than the 40 caliber casing, which was lying on top, freshly on top of the ground. It wasn't sunken in. And so that change in elevation is what led me to believe that it had been there for an extended period of time, apart from it, being covered by gravel, which would protect it from the elements and scratches and dirt, like extra dirt and debris, because it's fully submerged and protected.
Okay. And so if it was exposed like the other caliber that you saw, um, would the elements be able to discolor it over time?
I believe so.
Okay. But you can't make can you make a definitive uh, statement as to which one may be included and which one's not?
You mean included in that specific incident?
Yes.
I would say that the 40 caliber casing was a fresh casing involved in that incident because it was lying on top.
Okay.
The other casing was not and appeared to have been there for an extended period of time.
Okay. Now let's talk about the area, the location itself.
Sure.
What was, I understand you said it was gravel, it was in an open lot, and you said it was 1 o'clock in the morning. How was visibility?
Not great. It is a secluded residence near a lake with heavy foliage and lots of trees. Um, and given that it was, after 1 o'clock in the morning, it was almost entirely dark out there, with the exception of the light that was coming off of the patrol officers' vehicles, as well as the detectives and crime scene investigators responding vehicles.
Now, in your review of your case and in preparation for trial, um, did you have the opportunity to go back to the scene?
I did.
Why?
I wanted to collect photos of the incident location in daylight to show the contrast of what it looked like on scene compared to how it looks in the daytime.
Okay, and we're gonna get to those photos in a minute. I just want to make sure I go through the rest of your investigation. Now you said that when you learned, now that we, are at 4155 Road, and you learned of a second, victim, did you leave the scene and go somewhere else, or did someone else do that?
I stayed at scene. The initial crime scene, Sergeant Walker responded to the secondary crime scene at the hospital.
Okay, and did she provide a follow-up to you?
She did.
And what
Yes.
was that?
She had made contact with an individual named Deshante Asbury,
Mhm.
who stated that he had driven the victim that was at the hospital, Mr. Joshua Houston, as well as the initial victim, Mr. Corey Leonard, to the party initially. He stated that he and Mr. Houston left to go get food and then later returned to the party to pick up Mr. Leonard.
All right, and, um, did he provide a statement as to what led to him getting to the hospital?
Yeah, he stated that while he was parked near um, where the parking gravel area of the residence meets the long winding dirt driveway, where they were waiting for Mr. Leonard, an individual that is known to him at the time as Tizzy, opened up the rear passenger side door of the vehicle he was driving and requested a ride. Um, he said that he agreed to give him a ride, but stated that they were waiting on Mr. Leonard. At that point, he said he heard two gunshots and saw Mr. Houston in his passenger seat slump over and yell, "Go."
Okay. Um, and did did you also speak with witnesses on the scene at 4155 Pittman Road?
Yes, detectives did.
Okay. And do you recall how many witnesses were there?
I would have to refer to my report to get an overall number.
Okay. And if you need an opportunity to review your notes to refresh your recollection, you can do that at this time. Look up at me when you're done.
There was 9 additional party attendees that officers and detectives made contact
You
with.
said 9?
Yes, ma'am.
Okay, and did you notate their names?
I did.
Okay, can you please slowly for us tell
Sure.
me their names?
Yeah. First, there was Mr. Martez Dukes, goes by the nickname Rolo.
Okay,
Then there was Mr. Daryl Gibbs,
that's 2.
Mr. Quinnell May,
Quinell May, that's 3.
Mr. Philip Grimes,
Mr. Philip Grimes, that's 4.
Miss Jamita Taylor,
Jamita Taylor, that's 5.
Miss Shadea Killian,
Miss Shadea Killian, that's 6.
Mr. Cedric Brown,
Cedric Brown, that's 7.
Mr. Kaiser Smith,
Kaiser Smith.
and I apologize, I included Mr. Asbury in that total number. It was 8. When I said 9, I included Mr. Asbury. I apologize. I meant 8 that were still on scene.
Okay, so 8. Did you mention Miss Tamika Myers?
I did, but I did not speak with her.
Right.
Um,
But was she on scene?
Miss Yasmin Myers was inside the house.
Right. And her mother, Tamika Myers, was she on scene or is it not noted?
It's not noted
Okay.
whether or not she was on scene at the time.
Okay. Did you have an opportunity to review, Officers Castor's and Officer Fullerton's body camera?
I did.
Okay. And on that body camera footage, were you able to identify Miss Tamika Myers as being on scene as well?
I believe it was Miss Tamika Myers, but I did not see her at the scene myself.
Okay, understood. Is it common for investigators to review the body camera footage of responding officers in preparation for their case?
It is
Okay, and so you've named 10 people, correct?
correct.
All right. Now, out of those 10 people, did we get a full statement from any one person at
We did.
4155?
We did.
Okay, and who was that?
That was Mr. Martez Dukes, goes by the nickname Rolo.
Okay, and did you have an opportunity to review that statement of his?
I did.
Okay, what evidentiary value did Rolo or Martez Dukes provide to assist in your investigation?
Mr. Dukes stated that he observed just prior to the shooting of Mr. Leonard, he observed someone that he knows as Tezzy get into a altercation with Mr. Leonard. He indicated that the altercation took place because Mr. Tizzy had accused Mr. Leonard of disrespecting him in front of a female party attendee.
Right.
He said during the altercation he heard 2 shots and saw that Tezzy had shot Mr. Leonard. He then confronted Tezzy and striked him, and then Tezzy fled the area towards the driveway of the residence where Mr. Asbury stated his vehicle was parked and fled that location.
Okay, and so did this provide you some assistance on what to do next as far as identifying Mr. Tezzy?
It did.
Okay. Did it also assist you in looking, did it also assist you in looking in that secondary area where Mr. Asbury vehicle may have been?
It did.
Okay. And did you find anything of evidentiary value there?
We did not. That area was even heavily wooded or with a lot of grass and, heavy growth.
Okay. All right. And so how were you able to work towards identifying who Tezzy is?
Miss Yazamin Myers stated that she knew an individual that was at the party named Tezzy and provided an Instagram account for Tezzy.
And what was that handle name of the Instagram account?
It was facecard_Tezzy.
Okay. And did you look at that Instagram account?
I did.
Okay. And did you find anything of evidentiary value on that Instagram account?
Yeah. So Instagram post to that account's story showed an individual matching the physical description provided by Mr. Dukes at the pool party. In addition, I also observed several photos where Tezzy was displaying tattoos of 6-pointed stars, the number 74, and the letters G and D, which through my specialized gang training, I identified as known monikers and identifiers of the Gangster Disciples criminal street gang.
Okay. And so at that point, did you reach out to anyone else to assist you?
I did. I then contacted Detective Manson of the South Fulton Police Department's gang unit to conduct further investigation into gang involvement into this case.
And does that also assist you possibly in identifying?
Yes, not only in identifying, but also understanding potential motives for shootings.
Okay. Now, were you able to create a bolo?
I did. Using the photograph obtained from social media, given the fact that we believe the shooter who had just killed two people was still on foot in the area, that photo was disseminated to surrounding police agencies.
Um, at what point were you, at what time, if you can remember, were you able to get this bolo out?
It probably would have been around 2 or 3 a.m.,
Okay.
maybe 4 a.m. It was still while we were at the initial scene.
But it was it was way, I would say a couple of hours after the event had occurred.
Yeah, I don't recall the exact time that we sent that out, but it was while CSI was taking their initial measurements and collecting of the evidence.
And since you knew he was on foot, I guess let's go back and for the jurors explain this area. So 4155 Pittman Road, is that a highly populated area with businesses, residents? Explain that area if you're on foot.
Yeah, so the specific incident location is a multi-level dwelling secluded from the roadway with lots of trees. It sits next to a lake and is a very beautiful property. However, Pittman Road is contains several large-scale neighborhoods and residential different neighborhoods. Yeah.
Okay. And so someone walking on foot, would they be readily available or visible to passerbys, or if they, are there places to hide in the area?
There is, yes.
Okay. And so knowing that he is on foot, the shooter, what, if anything, did the law enforcement team do to attempt to locate or apprehend him nearby or close to the scene?
Yeah, so South Fulton police officers who were on duty conducted canvasses, had set up an initial perimeter, and then surrounding agencies like the Union City Police Department, which is nearby, also assisted in attempting to locate the suspect.
Okay. Now back to your bolo.
Yes.
Were you able to get a hit?
I was.
Okay. And so from that hit, were you able to get a name and date of birth of a person that may be Tezzy or Teasy?
I did. The hit provided the name of Anthony McCoy, and I would have to refer to my report for that birthday that it was obtained with it as
Of
well.
course, go ahead.
The date of birth was July 10th of 1993.
Did you say July 10th of 1993?
Correct.
Now, what did you do once you received that name and date of birth?
Using the provided name and date of birth, I ran that information through GCIC and NCIC, which is the Georgia and national databases, and was able to obtain Mr. McCoy's driver's license, which contained a photo.
Okay. And what did you do with that photo?
I was able to compare the driver's license photo to the social media posts on the public page, and I was able to confirm that Anthony McCoy was Tezzy in the provided Instagram account.
Okay. And so after you confirmed that, what did you do with that photograph?
So I created a photographic lineup with that photograph and to be administered by detectives who are not familiar with what Tezzy looked like.
Okay. Now, before we go into the detectives that administered the photo lineup, please explain to the jury the concept of suggestibility when compiling a photo lineup.
Yeah, so when we create photographic lineups, we want to make sure that one photo stands out more than others. We want to try and, to the best of our ability with photos that are available to us, match things like complexion, the background of the photo, um, certain identifying facial features like potential tattoos, piercings, facial hair, things like that, just to make sure that all those photos are as similar as possible and not one would stick out, suggesting that it would lead a witness to pick that photo over others.
And is that how you were trained?
It is.
And did you employ that training when compiling this photo lineup?
I did.
Okay. And who did you provide that photo lineup to?
Sergeant Walker.
Okay. Now, Sergeant Walker, was she aware of the identity of Mr. McCoy?
She was not.
Was she provided photos of what he looks like?
She was not.
Okay. Who was with Sergeant Walker?
Detective Calvin Thomas was with her when she presented the photographic lineup.
Okay. And Detective Kelvin Thomas, did he know the identity of the shooter?
He did not to my knowledge.
Okay. And so you gave this photo lineup to them and they administered that photo lineup to who?
They had administered it to Mr. Asbury. This would be around 7 or 8 a.m. on the 5th now, who positively ID'd Anthony McCoy as the individual he watched shoot Mr. Houston.
All right. And in preparation for this case, where you had an opportunity to review that footage of the administering of that photo lineup,
I did.
did you, in your training, knowledge, and experience, see any forms of suggestibility in the way it was administered?
I did not.
Okay. More specifically, did you observe Sergeant Walker step away from the photo lineup and allow Mr. Asbury to review it?
I did.
Okay. Did you observe Kelvin Thomas step away from or stay away from Mr. Asbury as he provided that?
He did. Detective Thomas's only role was to hold the camera, which was positioned behind Mr. Asbury. I did not observe Mr. Asbury turn around and look at Detective Thomas for any sort of guidance or suggestion or anything like that.
Okay. And in your background, in your experience, how many photo lineups have you compiled over the years?
Dozens, if not 100.
Okay. And in your experience and background, how many photo lineups have you administered over your years in law enforcement?
Probably about the same.
Okay. And based on your training, knowledge, and experience, the compilation and the administering, was it as you were trained?
It was.
Okay. Was Mr. Asbury able to identify anyone?
He did. He positively identified Anthony McCoy as Tezzy.
Okay. What did you, there was Rolo Dukes, correct? Did you ever present him with the photo lineup?
We attempted to, but he was not at the incident location. By the time we had compiled the photos, generated the lineup, administered one to Mr. Asbury, he was no longer at the incident location or responding to attempts of communication.
All right. You did have his phone number at that time,
We did.
and you attempted to contact him?
Detective Thomas did.
Okay. All right. Have you had any communication with Rolo or Martez Dukes since that time?
I have not.
Now, sorry. All right. After getting that positive identification from Asbury, what did you do next?
I then obtained warrants for Mr. McCoy's arrest.
All right. And after you obtained warrants for Mr. McCoy's arrest, were you able to arrest him pretty immediately?
We did not. No.
Okay.
So after the warrants for Mr. McCoy's arrest were obtained and signed by a Fulton County Magistrate Court judge. In accordance with the South Fulton Police Department's policy due to the violent nature of the warrants that were obtained. The case was referred to our fugitive unit as well as the U.S. Marshals Fugitive Task Force for location and apprehension.
All right. And briefly, can you explain to the jurors what that unit does specifically in locating a person?
Yeah, that unit is tasked with one responsibility, and that's locating and apprehending fugitives who are wanted for crimes, specifically South Fulton, charges in the city of South Fulton.
And are they the only, once you have one arrest warrants placed in the system, is the fugitive unit the only unit that can see those arrest warrants?
No, no. Once the warrants are placed onto GCIC and NCIC, every law enforcement official, personnel around the country has access to that national database.
All right. And when was the next time you received information as it relates to this case?
In reference to Mr. McCoy or just in general?
No, I'm sorry, in reference to the location of Mr. McCoy.
That would be November 21st of 2024.
And who contacted you?
A deputy with the U.S. Marshals Fugitive Task Force contacted me and informed me that Mr. McCoy had been located and taken into custody on the active arrest warrants.
And how many months is that after July 4th, 2024?
Over, 4 months.
Okay. And where was Mr. McCoy located?
He was located in Rome, Georgia. If you'd like, I can refer to my report for the exact address.
Yes.
He was taken into custody at 100 Marble Way, Rome, Georgia. That is in Floyd County. And he had been driving a 2015 white Jeep Cherokee at the time he was taken into custody.
All right. And so what did you do after you received that information?
Yeah. So in addition to the information that he had been taken into custody, they also stated the vehicle he had been occupying was impounded to the Rome Police Department headquarters, which is located at 375 Technology Parkway, also in Rome, Georgia, Floyd County. I then responded to that location with crime scene technician Latoya Campbell.
Right.
And I obtained a Floyd County search warrant for that vehicle.
Okay. And with what items were you able to recover from the vehicle?
Yeah, so inside the vehicle, while the search was conducted in accordance with the search warrant, there was a 9mm Glock 19 handgun that I recovered. It was located under the driver's seat, had an extended magazine, and was loaded with 26 rounds, one of which was actively chambered.
Okay. And briefly explain, what is an extended magazine?
It's a oftentimes purchased after where it holds more bullets than a normal standard capacity round magazine. So it sticks out past the end of the handle of the gun.
And is that a common fixture on firearms that you see?
In my unit, it is.
The homicide unit?
It is, but not generally speaking.
All right. And did you obtain anything else from that encounter with Mr. McCoy? Any
I-
other devices?
Yes, there was a additional search warrant that I obtained in a Floyd County search warrant to conduct a search of Mr. McCoy's property, which was located at the Floyd County Jail. and I executed that search warrant, obtained Mr. McCoy's cell phone that was in his property at the time.
Okay. And after that, was Mr. McCoy taken into custody?
He was taken into custody prior to my arrival in Floyd County.
Okay.
He was already at the jail.
Okay. All right. Now, did I miss any portion of your investigation that we've done so far outside of collecting evidence? Any further evidence that I have not mentioned?
Not that was conducted by me. There was an autopsy that was conducted in between those points and other investigative steps,
Right.
but none that I had was the primary.
And you did collect, you did hold within your custody, firearms that was collected from the vehicle as well, right?
Yes, I removed the firearm from the vehicle, and then I released it to crime scene investigator Campbell, who was on scene with me, who then submitted that gun into evidence at the South Fulton Police Department's Property and Evidence Division.
All right. Now, so out of the three guns, there's one that has not been admitted. I am going to present that to you. At this time, the state was previously been marked as State's Exhibit 393. It's made safe. All right. And what am I showing you? Look at the label. South Fulton label.
Say South Fulton Police Department evidence label marked with the case number of this incident.
Okay. And does it say when it's collected?
Not on the label, if I'm looking at it correctly. It says the label was printed on July 22nd of 2024.
Okay, and what type of firearm is it that you're holding?
It is labeled Glock 42.
All right, and where was this collected?
This was collected during the search of the Lexus vehicle that Mr. Asbury had been driving at the time of the incident. It was located in the back seat under a mat.
And then can you open up the box? And outside of the gun being made safe for court, is it in the same condition at the time when you received it?
Yes.
All right. All right, at this time, the state moves to enter in State's Exhibit 393.
Objection, Your Honor.
Admitted.
Now, I am going to present you with State's Exhibit 108 and 109 that's already been admitted. Let's start with 108.
Where would 108?
I'm
appear?
sorry, it's the State's Exhibit sticker at the bottom left,
Got it. I
or is
see.
it right?
No, it's bottom right. I got it. Thank you.
Okay. And what is the description of this firearm?
This is a Springfield Armory XD5 9mm handgun for the South Fulton Police Department and the case number matching this incident.
All right. Now, if you could open that box, and outside of it being made safe for the court, is that also the firearm you recognize?
It is.
Okay. Tell the jurors 108, where was that located?
This handgun was located by Sergeant Walker at Southern Regional Hospital. And then she subsequently released it to crime scene technician Reeves, who then submitted into evidence at the South Fulton Police Department.
Okay. All right. Thank you.
It should also be noted that this gun was collected from underneath the front passenger seat.
Yes, that was going to be my next question. So, now between those two guns, 393 and 108, were both of those guns found inside of the vehicle that was driven by Mr. Asbury?
They were.
And the locations of the guns, did it have any significance to you?
Both locations did, yes.
And what did you determine based on the locations of the guns?
So for State's Exhibit 108, the Springfield Armory, where it was located was where victim Mr. Houston had been sitting inside Mr. Asbury's vehicle, which was consistent with blood spatter on the dashboard and glove box of the vehicle.
Okay.
State's Exhibit 393, the Glock 42, which was located under a mat in the back seat of the vehicle, where, to my knowledge, the last person to be seated in that position was victim Corey Leonard.
All right. And so, did you have any information as it relates to the security of the party?
Yes, I was told that prior to this incident, there was security present for the event, but at the time of the shooting, the party had been over and security was no longer on scene.
Right. But did you know what the rules were as far as firearms at this party?
That there was no firearms allowed.
Okay. And so, finding the gun in the back seat under a mat and finding the gun under the seat in the front passenger, is that consistent with putting a gun up while attending the party?
Absolutely.
Okay. And so based on your investigative knowledge and experience, did you make any conclusions of who had what gun belonged to who?
Yes, I believe that the Springfield Armory XD5 9mm handgun belonged to Mr. Houston, and the Glock 42 handgun was owned by Mr. Leonard and was not on him at the time of his death.
Because it was in the vehicle.
Correct.
All right. Now, was there a gun near or around Ashbury?
Not to my knowledge, no.
Okay. And you thoroughly examined that vehicle with crime scene tech?
I was not present for the execution of that search warrant. no.
Okay, my apologies. But you reviewed the photographs and the evidence from that crime scene
Correct.
investigation of the vehicle?
Correct.
Okay. And at any point, when your detective spoke to Mr. Asbury, did he ever mention owning a gun or having a gun?
Not to my knowledge, no.
Okay. All right. And was it your understanding that Mr. Asbury was sitting in the driver's seat?
It was.
Okay. All right. And based on the supplement submitted by crime scene technicians and other investigators that assisted you in this case, did any of them mention a firearm being near or around Mr. Ashbury?
Not to my knowledge.
Okay. Now, Mr. Asbury himself, did he appear to be forthcoming when speaking to your team?
He did. And the footage I reviewed of interviews with him by responding officers and detectives, as well as the administration of the photographic lineup, he did appear to be open and honest with detectives.
Okay. And in reviewing the statement provided by Mr. Rolo Dukes, did he appear to be forthcoming at the time that he was interviewed at 4155 Pittman Road?
He did.
Okay. Got that. Now, earlier, you stated, we actually listed out 10 people, including Mr. Asbury and Rolo Dukes, right? Leaving 8 additional people. Out of those 8 people, did you personally interview or your team interview any of them individually?
I did not personally know,
Why not?
because we had obtained written statements from them
Okay.
prior.
And did it provide much information?
Not not at the scene, no.
Okay. Did that surprise you?
No.
Okay. Um, and why doesn't it surprise you?
Especially incidents like this where there's other people around. Oftentimes it is not popular to be seen talking or providing information to police officers.
And you said there were about 10 of them around each other, correct?
Correct.
Right. And you say it's not popular. What does that mean?
People are hesitant to come forward with information, especially at an event like that. Um, and I was not shocked when none of them wanted to come forward with information. Later on body cam, I was able to see that they had been conversing with each other and talking about the incident, but did not come forward with that information at the time.
Right. So in reviewing the responding officer's body cam, Officer Castor, Officer Fullerton, and Officer Brunson, you were able to hear them engaging in communication in the background of the body cam?
I was.
And was that communication about what they saw inconsistent with what they wrote down on the paper?
It was.
But you didn't follow up with them?
Correct.
Okay. Did you feel like you had enough witness statements to identify the person that you believe had committed the shooting?
I did.
Okay. Is in your training and experience, not speaking to police officers, would that also go to avoiding any retaliation?
Yes.
Okay.
Absolutely.
And based on your information and knowledge, these people knew the shooter?
They did, at least by a nickname basis.
Okay. All right. What's the state's exhibit number for that? 392. Thank you. 3. Okay, I see. Again. Not one. Yeah, 2 numbers. Thank you. Cell phone. 299. The extraction is 390 to 392 because it has the full extraction in it. Okay. All right. I am now presenting the witness what has been previously marked as State's Exhibit 299. And I am also presenting the witness with what has been previously marked as 390 to 392 with the cell phone extraction. What have I shown you at 299?
299 is the cell phone that I obtained in accordance with the search warrant of Mr. McCoy's property at the Floyd County Jail that I submitted into evidence at the South Fulton Police Department.
And how do you know that's the cell phone you collected and submitted?
Because this is my handwriting with my name on the initial bag that I secured it in.
And is it in the same condition to when you secured it?
It is.
Okay. At this time, the state moves to enter in State's Exhibit 299.
No objection, Your Honor.
Submitted.
All right. And then State's Exhibit, I handed it. State's Exhibit 390 to 392. Is that a jump drive of the cell phone extraction that you provided?
It appears to be.
Okay. After reviewing that jump drive yesterday, is it a fair and accurate representation as it was extracted and submitted to you?
It is.
Okay. At this time, the state moves to enter in State's Exhibit 390 to 392.
No objection, Judge.
Submitted.
Now, briefly, just so the jurors understand, what is a cell phone extraction?
Yeah, so once a detective or officer submits a phone into evidence, if we believe that there's further investigative evidence on that device, an additional search warrant would be obtained to download any available contents from that device. That is often contingent on the parameters the user had set to it, what is saved, what they didn't want saved, what information they may have deleted off that device. Once the search warrant is obtained, the device is then checked out of evidence by our digital evidence unit that conducts the extraction using various softwares depending on the make and model of the phone. Once that extraction is complete, that available data that was obtained in that extraction within the time frame set in the search warrant that I provided to that investigator is then brought to us in a viewing format called Cellbrite is the software that we use, where we
Okay.
can look at that information on however it's stored, whether it be on our desktops, a hard drive, things like that.
All right. And the state permission to publish that exhibit, that cell phone extraction snippets.
You may.
So what was the parameters that you put in your search warrant for the information from the extractions? I can take that.
That's okay. I can get it out of the way here. I don't recall verbatim what I wrote on the search warrant, but it often they all contain messages, any location data, statuses of the phone, any sort of applications that may be available, any contacts, photos, videos, all within the time frame. I believe the time frame for this was July 4th at 001 hours in UTC time up until August 4th, 30 days after the incident in UTC time.
Okay, so now you said another foreign word for the jurors. What is UTC time?
Yeah, UTC is Universal Time. I don't recall what the C stood for, but it is the time frame that we use when we are referring to digital evidence because it doesn't change with time zones. So at the time of the incident, UTC was 4 hours prior to Eastern time. So with the incident occurring at 11:29 p.m., that means that in UTC time, it would have been 8:29 p.m. UTC time. So that way, when we send search warrants to potential digital evidence sources, like maybe a cell phone carrier or a social media provider, there's no confusion on the time frame that we're requesting data from.
So whether you're in Mountain Time or Specific Time,
Correct.
Pacific Time or Eastern Standard Time, everyone goes by the UTC time.
Correct.
So what I have just published is State's Exhibit 391. What is what is 391?
This is a part of that Cellbrite extraction, showing data log entries specifically from the dates of, on the date of July 5th, 2024.
Okay. And what of evidentiary value did you discover in this, on 391?
That Mr. McCoy's device had interacted with the Greyhound bus app at 5:31 PM UTC, which would be around 1:31 PM Eastern Time, the day after the incident.
Okay. Now, did he just interact with it? Did he download the app?
I believe he downloaded it, because you can see to the right of the log entry, it will give a identifier.
What, let me pause 1 second. So we
Sure.
have a pencil on the TV. So we can point it out. It's kind of small, so you gotta help us a little bit. You see the pencil?
Oh, yes.
And then just use it to circle.
Yeah, so when one of these data point entries is clicked on, right here, in the right-hand side, it provides additional information as to what that log entry was in reference to. Up top, you have a identifier here. And when I went through these log entries, one of them prompted me to a download of the Greyhound bus app, which would lead me to believe that he downloaded the app at that time.
Okay. All right. And why is that significant?
Because people often use buses to flee the area after a crime scene, and Greyhound is the largest bus system that goes for the furthest and has bus stops all over Metro Atlanta area.
Understood. And now let's move to State's Exhibit 392. Can you see the undo? It's like a counter clock.
Yes.
Thank you. 392. You have to assist us because it's kind of small.
Yeah.
What are we looking at in 392?
So these are notable device events that the phone logged during that time frame that was provided in the search warrant. Here it shows 10 different entries into the significant events, all of which are being the phone powered off, which you can see here under this section right here and this section right here, which describe all these events as a power event with the phone being powered off.
All right. Now, undo. Can you circle for the jury the entry that you have highlighted here, with giving us the time that it states?
Yes, so this is the first entry in that time frame of July 4th to August 4th in accordance with the search warrant, where the device was powered off at 12:32 a.m., not in UTC time, because this was not the device communicating with a network that involves time changes. It's specific to that location of the device at that time. So it was 12:32 a.m. So that would be shortly after midnight, which would be prior to law enforcement's arrival during the pool party. And on this would be 12 a.m. on the 5th. So this is just after the event.
And, okay. And had it been UTC time, it would say like the prior entry AM UTC?
Correct. It would specify like the other result we just located.
Right. Undo. Okay, and you can go to the don't move it yet. I showed you these already. I am presenting you with what has been previously marked as 300 through 383. I'll take this and this. What have I just shown you?
These appear to be the daylight photos that were taken by crime scene technician Newton while I was walking her through the property during the daytime.
Okay, and if you could briefly, because there's quite a few there, just
Yes.
go through them, make sure they are fair and accurate. Maybe just a few of them or all of them, up to you.
Yeah, no, they do. They look accurate.
Okay. And has any alterations or changes have been made to those outside of just the exhibit sticker?
No, no, ma'am.
Okay. At this time, the state moves to enter in State's Exhibit 300 to 383.
No objection, Your Honor.
Submitted.
Okay, permission to publish.
Okay.
And let me just ask you before we get started, why so many photos? What were we trying to accomplish with this?
It's a big property, and rather have more photos than less.
All right, so State's Exhibit 300, what are we looking at?
This is the entryway to 4155 Pittman Road, from the perspective of Pittman Road.
All right, 301,
Same. Now the mailbox to the property is in view.
okay. And so that would be 301. Can you please move to 302? And 303?
All same view. and
Right,
vantage
I'm
point.
gonna, yes. And
Our crime scene technicians are very thorough with photos.
I understand. Now, let's go to State's Exhibit 304. It's up on the screen. What are we observing in this photograph next to the mailbox?
This shows the beginning of the long driveway to the residence of 4155 Pittman Road.
And is that included in 305?
It is.
All right. Now, 306, what vantage point are we seeing here?
This is from the driveway looking out
And out to Pittman Road?
towards Pittman Road. Yes, ma'am.
And is that a heavily wooded area along that road?
It is.
Okay. States 307?
The surveillance and no trespassing signs on a tree as you
Okay.
enter the property.
All right. Now, did you observe that at the time of the homicide?
I did not. The property has been in the news since this incident and several other incidents after this one, regarding violent incidents that occurred on the property. And I suspect that these were put up in accordance with all the issues that have been out there, both prior to and after this shooting.
And I don't believe I asked you, when did you case the area when you were out there that night on July 4th, 2024 to look for video footage?
We did.
Okay. And did you see any video footage or cameras?
I did not.
Okay. All right. And states 308, is this the beginning of the driveway?
It is.
Okay. And is that also in 309?
Yes, ma'am.
Okay. Now let's jump over to sorry. Let's jump over to 315. States Exhibit 315. What are we seeing in this photo?
That is a solar powered security camera as well as signs posted on the tree.
Okay. And just to affirm, did you see this at the time of July 4th, 2024?
I did not.
Okay. All right. And States Exhibit 316, where is it pointing at, that camera?
That is pointing at vehicles that would be entering the property.
Okay. Let's jump to 318. Is this heavily wooded area surrounding that entryway?
It is.
Okay. And what was your purpose of taking a photo of that?
Just to properly show how wooded that area is. And that was the direction that the suspect had fled towards to show that he could have been hiding out in the area.
Okay. And is States Exhibit 320 a further away shot of that?
It is.
Okay. Now, looking at Stakes Exhibit 322 and 323, there's several signs of private property, no trespassing, almost on every tree it appears. Was all of that there prior?
Not that I recall.
All right. Stakes Exhibit 325 and 326, is that a continuation of that long driveway up?
It is.
Okay. And Stakes Exhibit 332. What are we looking at in 332?
This is continuing along the driveway as you get closer to the residence.
All right. And is that a fence?
It is.
And were you able to look and see whether that fence opens and closes and latches?
It appears to. I did not manipulate the fence in any way.
Okay. All right, 335. What are we looking at 335?
This is as the driveway opens up to the residence.
Okay. Now let's look at 338. What type of vehicle are we seeing in 338?
That is my assigned vehicle as well as a Jeep Gladiator believed to be owned by the property owner.
It's a Jeep. Did you recognize anything that was written on the back of it?
I can't, I recall there being writing, but I can't make it out.
Okay. All right. Now, the State's Exhibit 339, what was the purpose of this photograph?
So this shows the transition over an overall photograph of the incident location showing the transition from the residence to where the pool was and the party was primarily had and where the large gravel area opens up to.
Okay. Now, were you able, from this vantage point, if you would go back that night, would the decedent's body, would Mr. Leonard's body be in this frame?
At least part of him would be.
Okay. If you could point on the photograph in the general area where he would be.
It'd be somewhere in this area here.
Okay. And then it's a little dark. So can you point to where the actual house is?
The house is over here.
And then where the pool is?
The pool area is back here. That structure that is right here, that is a Connex box that was converted into a pool bar, as well as a elevated surface where a DJ or artist can perform, as well as additional seating.
Okay. So if you could undo, and undo. All right. 343, is that a clearer picture of the residence? The front door of the residence?
It is.
Okay. And 334, what is the value of this photograph?
So this would again show a transition from where the entryway to the property was, which would be along this side over here, and then where Mr. Leonard's body was located, which would be on the other side of this tree line in this open area over here.
Okay.
Undo.
All right, let's go to 346. Is that a better vantage point to see where Mr. Leonard would have been?
It is.
Okay, and if you could point to or make a marking of where he would have been in this frame?
Sure. Mr. Leonard's body would have been recovered right here in this area.
Okay. All right. Let's move to 348. Where would Mr. Leonard's body be in relation to this pool this bar, I'm sorry, what did you call it?
It was like a Connex shipping container
A container.
where the sides have been cut and converted into a bar.
Okay. In this frame of 348, can you see where Mr. Leonard's body would have been in relation to the container?
Yeah, it would have been in this general area right in here.
Okay, all right. So fairly close to that container in area?
It's
Actually,
it's not super close to it, no.
right. If you will undo that circle and be a little bit more precise on, it's not a good
Well,
photo?
I would have to review the crime scene photos from the night of the incident, but to my best of my memory, it was somewhere around this general area would be the most that I'd be able to.
Understood. Understood. All right, 353. What is the purpose of this photograph here?
Yeah, this is a up close photo of that area that I identified as where I believe to be the general area of where Mr. Leonard's body was located.
And can you describe to the jurors what the ground is like in that area?
Yeah, it's primarily like a gravel sand texture, where you can see that weather had been eroding away. It's primarily tan and brown in color.
And in response to your last statement, would it assist you in having the crime scene photos with you as you direct us on this?
Yeah, it would.
Okay. One moment. I'm presenting the witness with State's Exhibit 15 through 38. 15 through 38. All right. So now that you have that, I'm gonna go back to. Does that assist you or?
It does,
Okay,
yes.
so let's try State's Exhibit 347. Okay, I think this is maybe the one I asked about earlier. Are you able to see the shipping container here?
I can,
Okay,
yes.
and can you point that out for the jury?
So you can see it right here.
Okay, and then is this a frame that would, Mr. Leonard's body would have been in that area?
Yes,
Okay, and so to the best of your ability, can you kind of place where he would have been?
yep. He would have been right here, due to this tree right here being visible in both, States Exhibit 22 is the specific photo that I'm looking at, where if you draw a line out from that tree, Mr. Leonard's body is visible in accordance with that structure.
Okay, and is that consistent with the statements that was provided by several witnesses of being near the structure and in that area?
It was.
Right. Now, let's go to State's Exhibit 355. Can you identify the structures and the items that we see in this photo?
Yeah, so here you can see that tree that I referenced in the previous photo, being that Mr. Leonard's body would have been approximately right here in this area. This is that large structure. And then down here is the pool. There's a large slope and two sets of retaining walls. And then the backside of the residence here. And then this is the lake with that goes all the way around to over here.
Okay. Now, you circled up my photo.
Oh,
That's okay. No,
I'm
don't
sorry.
undo it. Don't undo it. Don't undo it.
Oh.
I just want to make sure I reference the right circle. So the circle that is close, that is furthest down in the photograph that you just pointed out, what is that circle to represent?
This circle right here is representing where Mr. Leonard's body was located.
Okay, understood. All right, does 356 show a good vantage point of how far the house was from the pool area?
It does, yes.
Okay. State's Exhibit 357, is that a vantage point of the pool area in comparison to the lake?
It is.
Okay. Now, did you learn of another property that Demo or Mr. Williams has on that lake?
I did. I also learned that he owns the residence on the opposite side of the lake.
And can you see it from there?
It's kind of dark, but it's right here.
Okay. Is there a walking path from that house to the 4155 Pittman Road?
There is.
Okay.
You can see the walking path along the rim of the lake right here.
Okay. Is that consistent with Demo's, Mr. Williams' statement is regarding that he went to another residence and then walked over to the house because he couldn't get in by police?
It is.
Right. All right. State's Exhibit 358. I think that's a close-up of 357.
It is.
State's Exhibit 359, is that a close-up of the pool area?
It is.
State's Exhibit 360, what was the purpose of taking this shot here?
Just to provide further details of the area that surrounded the pool and how the change, specifically the change in elevation from the area where Mr. Leonard's body was located down towards the pool.
Do you recall watching the social media videos after the incident when trying to locate or identify Mr. McCoy?
I did.
Okay, do you recall a video being up on that elevated area?
The elevated area that I observed in the video was actually on this side of,
Okay, understood. Okay.
and there will be later photos taken in the daytime from the vantage point I believe that video was captured at.
Okay. And what video are we talking about?
It was a social media video, not from Mr. McCoy's account, from an account that one of the officers out there was able to obtain that showed a altercation between Mr. McCoy and Mr. Houston earlier in the day.
All right, at 363, is that a better vantage point of that elevated area on the other side of the container?
It is.
Okay. State's Exhibit 365. Based on the information that was provided by the witness and the responding officers, where were cars being parked during the party?
That would be up along over on this ridgeway here. However, when we arrived on scene, there was still remaining cars towards this end here, as well as around the driveway area where the DJ had been loading up his equipment.
And would Mr. Leonard's body be in this frame?
I don't know. I can't say for certain inside this
Okay.
frame. If it did, it would be near this area here.
Okay. Now, you being on the scene in comparison to this photograph, is that a pretty far distance where the cars were parked in relation to where Mr. Leonard was?
Yeah, I would estimate it at well over 50 feet. from
Okay.
The cars that I observed.
Okay. And so if a witness like Mr. Philip Grimes states, he was in the car with a young lady, didn't hear anything. Would that be consistent?
Yes,
Okay. Would it also be consistent if Mr. Asbury is parked far apart from the area where Mr. Leonard body is yelling? Is that pretty far as well?
yes.
Okay. Now, let's look at State's Exhibit 369. It- in this photograph, 369, do you see the house, the pool, and the container?
I do.
Okay. Now, at this vantage point, would you be able to see Mr. Leonard's body or the incident that may have occurred that led to his death from this vantage point?
Potentially, his body would have been visible in this area right here, depending on the height of the viewer. I'd imagine would play an effect in there.
Okay. And is that a close distance to the home or far away?
I would consider it far away.
Okay. And so, if someone was in the home, is it consistent with them finding it difficult to see what's happening outside?
I believe so.
Okay. And is that consistent with the statements that were provided of people being in the home not seeing anything?
It is.
Okay. All right. States Exhibit 374. Do you see the sign, do you see the sign that is hanging on the house?
I do.
What does it say?
Welcome to Lake Demo.
Right. Now, what was the purpose of States Exhibit 376 and 75?
Just to show how the vantage point would be facing the entryway to the property from the area near where Mr. Leonard's body was located.
All right, so for the jurors, can you please point out the entrance to the property?
Yeah, the entrance to the property would be on the other side of these tree lines, right about there.
Okay, and where would Mr. Leonard's body be if this was on the night of the incident?
I don't want to obstruct the little bubble that says this meeting is being recorded and live streamed, but it would be
And you can press the.
it would be somewhere around this area here.
Okay, and would you say that's quite a distance, or would that be close?
That would be a distance.
Okay, would it be a further distance than even the house?
It would be.
Okay. All right. Now, States Exhibit 379, is this a better vantage point of where a lot of the cars were parked in the night of the event?
It is.
And were you able to see that on the social media of the cars being parked in that area?
On the post that I did see, yes.
Okay. 380 and 381? Are those close-ups of that same area?
It is.
And can you see the entryway to the property there as well?
Yeah, it's pretty dark from my view, but I believe it to be over here, where the driveway opens up
Okay,
to the property.
okay. Now, you stated that when you were trying to identify Mr. McCoy, that you looked at social media, correct?
I did.
Was Mr. McCoy the only person posting about the party?
He was not.
Okay. Was there multiple accounts posting about the party?
There was.
And how were you able to find those accounts?
Those were provided to me by other officers and investigators that had responded to the incident location.
Okay. Got it. Read four. Should read here. This is social media.
All right, members of the jury, let's pause for 5, take a quick break. We'll be back to resume this direct examination.
Okay. I just want to make sure you understood it. There's two separate folders.
It was crazy.
We'll resume when the jurors are ready.
Social media. We're about to put up the selfie. Perhaps.
No, I don't.
Hello, how are you doing? So, yeah, sorry about that. This is my little- What is that?
I appreciate it. All right.
Actually, I was believing you. Okay, I'm like, got to the end of, hey, when you did, I was like,
What?
I'm dead.
Oh, I just turned it on. I didn't see.
I just want to check. I don't know, we might not want to show her. Right.
Oh, no.
And remember, I got the wrong number. Can you send her number to me, please?
Oh,
Let's see if
no.
she's sitting out there.
Okay. Oh, no.
Hard drive. Good. You do good. Well, come out here and take a.
Sure. You-
Well, just
Do you
don't talk
need-
to nobody.
you need her number?
Uh,
Those are her two numbers.
Thank you.
I don't know which. Which one, so. No.
There you go. You were there. Sure.
You wanna give him these all? I've been in I've been like a summer legal intern since every year since 2022. And this is my first time seeing mountains in the fall. No, I'm a senior in associate.
When is graduation?
This December for me. I'm graduating a semester early, so I'm excited. I'm ready to be done.
Then you go to law school or?
Yeah, that's the plan. Well, for lunch, he will stop at like, he'll stop around 12:30, and then, I mean, 5, like, sometimes it'll bleed over to like 5:20 or something, but it doesn't go past that usually, so, yeah.
The dentistry, how, I was up above, I called my contact. Yeah, I want to be involved. Yeah.
Oh my gosh. I should have brought my hand.
Did you get there in any other units?
So I actually used to be in the juvenile division up until like this is, I started in the gang unit in August. So I was in the juvenile division, which was very interesting. I didn't expect to like it there, but I did. And then Madam D. Willis has like summer legal interns do case intake work along with like whatever division we're in. So it's like I technically have case intake experience too, so which was very interesting. Got to write indictments and do all that, and it was fun. Yeah.
So you still something where, oh my God, they got like people. Still something? Ask them if I get one for the next 9 days.
This might be.
No, you're good.
Thank you.
Need water?
That'd be great. I was just thinking like, man, I should have ran downstairs while I had the time. Thank you so much.
You're welcome. I got extra just in case. It was just in case. It's not cold.
It's perfect. Thank you.
It's just, he's been doing this.
You don't. This is it.
I'm at 384 and 389. So. I would say I need coffee, but I don't think I should. I think I should just chill coffee. Thank you. I don't know. Need a little more structure. I thought about that too. Is the table okay?
Yeah.
Um, I'm not gonna
You
forget.
cracking me up.
I'm telling Brett. You know, this woman told me my table didn't look good.
You know how many times Brett told me that I need to clean up my.
The number that it should be. Yes.
You have any blank? Oh, yeah. Need these staples.
They do. But just for now,
That's fine.
they don't have to be actually. No, they're fine.
Here.
Correct, Judge.
Thank you, Deputy Scott. Please be seated, everyone. State may resume their direct examination.
Thank you. So. I am now presenting the witness with what has been previously marked as State's Exhibit 384 and 389, which is on a thumb drive and hard copies of the same. Detective Prince Pay, what am I showing you?
These are screenshots of the Instagram account facecard_Tezzy that was provided for Tezzy by partygoers and later identified to be Mr. McCoy's Instagram account.
Okay, and did you have videos as well?
Yes, ma'am.
Okay, and where you had an opportunity to review that, is it fair and accurate as the same screen recording that you placed into your case file?
I did.
Okay. At this time, the state moves to enter in State's Exhibit 384, 389.
No objection, Judge.
Submitted.
All right. Permission to publish.
May.
All right. Now, what are we seeing in State's Exhibit 384?
This is the screenshot of Mr. McCoy's Instagram page.
Okay. And what, if anything, is of evidentiary value when attempting to identify Mr. McCoy?
From this would be primarily the same nickname used, as well as certain gang identifiers here in the bio section of the account.
Right? Do you see anything that actually identifies his name?
Other than the Tezzy, as well as the last name McCoy depicted here.
Okay. Now, did you make an attempt to extract or sorry, to get a search warrant for Mr. McCoy's Instagram?
I did.
And what happened to that?
At the time the warrant was submitted, Instagram was unable to provide any records due to the account being deleted.
Okay. All right, let's go to State's Exhibit 385. All right, and pause. Oh, is it playing now? Okay, don't play yet. Were you able to locate a social media account at 4_D.I.A_ that displayed images from the party?
I did.
Okay. And at this time, we're going to push play. Now let's pause. Now that we've got a good lay of the land with your daytime photos, the person that's taken this video, where are they located in relation to that hill area that you spoke about?
Yeah, so they would be on the opposite side of the pool, looking up at the hill, as well as that storage shipping container bar that was made.
Okay, so multiple people captured and actually posted the incident involving Mr. McCoy.
Correct.
Okay, and based on your view of the social media, does this go consistent with the statement that a witness provided that Mr. McCoy was tried or disrespected?
It does.
Okay. And in this video, do you see people laughing? Well, I guess we could push play. Let's push play.
Yeah, people in the background appear to be smiling and laughing.
Okay. All right. All right. Anything you notice about Mr. McCoy's demeanor?
He appears to be the primary aggressor for the commotion depicted in this video.
And can you use your pencil? Well, I don't think you can use your pencil. So can you turn around and identify Mr. McCoy on the video?
Sure, I can use my
You
pencil.
can use the pencil?
But
Okay.
this is Mr. McCoy right here.
All right. And if we could undo. And then push play and let me know when you can identify the decedent, Mr. Houston.
Right there, you can, and then he's out of frame now. If you can go back
Right?
and
We're go-
pause,
Okay, pausing.
Mr. Houston can be seen right here wearing the white tank top and the headband with the beard.
All right. Okay, you can continue to push play. And can you scroll over the timestamp? And at the 40-second mark, is there someone pulling Mr. McCoy away from that scene, that
Yeah,
area?
the individual wearing the white shirt with the green stripe appears to be pulling him away from Mr. Houston in an attempt to de-escalate.
Okay. Now let's move on to State's Exhibit 386. Please don't push play, just pause. All right. Now, this is a separate Instagram account, correct?
Appears to be, yes.
And you were able to locate footage of the pool party that happened July 4th, 2024.
Yes,
And is this Instagram account A_tangible_experience?
it is.
Okay. And if we could go ahead and push play. Let's pause that 1 second. So unshare it. Stop share. Share again. Click both of these buttons first and now share. And can we go back to 385 to verify if there's any sound? I believe there was.
Niggas always want to wrestle this shit at the food though. Boy, this some real Friday shit, man. He got his shit took from Debo.
Can we pause? And did you hear he got his shit took from Debo?
I did.
All right. And when that was said, was the camera still on Mr. McCoy?
It was and currently is.
Okay, push play.
Glock at? Where your stick at? Where your bump stop? Where your switch at? Nigga, where your hoe at? Huh? Where your bitch at? I can tell you she right here coming out good neck. Where your today's money?
And now can we move to State's Exhibit 387?
Yo, Glock.
All right, and is this a still image
It is.
from Mr. McCoy's Instagram story?
Yes, ma'am.
Okay. And in this photo, is it consistent with the description the witnesses provided that
is.
night? Okay, let's move to 388. All right. Now, this is a different Instagram. Is that correct? This is, I'm sorry, is that correct?
It is.
Is this at Randy Rock, RANDYROC?
I believe so, but it is on the screen.
Oh.
It is.
No, it's okay. It's okay. Just move that bar down. All right, can you see it now?
Yes.
All right. It'll eventually go. And then can we, that's a still image. Okay. Now, this is a this is a fourth Instagram account picturing the pool party. Now, is this a post or is this stories?
This is a story.
And how can you tell that it's stories?
Based from the bar up top here. If I may. Right up here is showing that it's an Instagram story that runs for a finite amount of time and before proceeding to the next clip.
Okay. And how long is an Instagram story available?
24 hours.
Okay. And so, in this story, it's capturing, is it capturing anyone significant in this case?
Yeah. Right here, you can show Mr. McCoy interacting with a female party attendant, which would be consistent with Rolo's statement that at some point he was disrespected in front of a female. So he was conversing with a female subject at the party prior to the incident.
Okay. Now in State's Exhibit 389, is that a close-up of that same?
Yes, it is.
Okay. Now, after you investigating this case and after you making an arrest on Mr. McCoy, have you become familiar with who Mr. McCoy is and what he looks like?
I have.
And are you able to identify him if you were to see him again?
I can.
Just get this. At this time, I ask that you look around the courtroom and if you see Mr. McCoy, point out a piece of clothing.
Yeah, Mr. McCoy is seated to my left, wearing a blue button-down shirt and glasses.
Let the record reflect that the witness has just identified the defendant, Mr. Anthony McCoy.
The record will so reflect.
No further question.
Good morning, Detective.
Morning, sir.
Um, Since you've just seen the video, I was going to ask you a question about that first, so I'll walk backwards a little bit.
Sure.
In the videos that you were shown with Mr. McCoy, where you described Mr. McCoy as the primary aggressor, in those videos, did you see Mr. McCoy putting his hands on anyone?
I did not know.
Did you see Mr. McCoy pushing anyone?
I did not know.
Did Mr. McCoy hitting anyone?
No, sir.
Did you see others putting their hands on Mr. McCoy?
In an attempt to break it up, yes, he was pulled away.
Did he seem to be resisting that?
He did not seem to be going on his own accord, and he was still facing and confronting Mr. Houston in that video.
Okay. You didn't see Mr. Houston just lead him down the hill?
Mr. Houston was on the top of the hill at the time he was being led away.
So someone led him down the hill, though?
Correct.
But did you see that?
I did, yes.
Did you see him resisting? Did he just go?
I wouldn't call it resisting, no. No, he wasn't resisting.
Was he fighting with that person in any way?
He was not.
Did he even appear to be arguing with that person?
He did not. He appeared to be continuing an argument with Mr. Houston.
Did you see Mr. Houston put his hands on Mr. McCoy at the top of the hill?
They were close face to face. I don't recall, but I'd have to rewatch that video.
And did it appear to be an attempt from Mr. Houston to get him to go down there where he could throw him in the pool, throw Mr. McCoy in the pool?
I did not appear to see Mr. Houston go down towards the pool in that
I
video.
understand, but was that not what the encounter was about?
I do not know what that specific encounter was about.
Okay. There is an encounter, though, that has audio, correct?
There is.
All right. Have you seen that one?
It said something about having his keys snatched.
Okay. Have you seen an audio that refers to Mr. McCoy being thrown into the pool?
Not to my knowledge.
Okay. I just wanted to do that first because you just had the opportunity to view that a while it was fresh on your mind. But I have some other questions for you, Detective. You testified about the involvement of your detective, Mr. Thomas, in this case, K. Thomas. His first initial is K.
Yes, sir.
At the time, now Sergeant Walker was also Thomas, correct?
Correct. She was married around that time. I don't know the exact date. Her maiden name is Thomas and has since become Walker.
I understand. And both have preceded you in testifying in this trial. You may be the last police department or detective to testify.
Okay.
And you are the lead detective. In Kate Thomas's testimony, he was asked if his involvement ended after that evening, after the investigation, and I believe his reply was that it did. So he didn't stay involved in the investigation, did he?
He did remain involved. He obtained the search warrant for the Lexus vehicle that was being driven by Mr. Asbury at the time of the incident.
Okay. And besides yourself, as a lead detective, you named a few others. Detective or Investigator Brunson, I guess, was one.
Yes, he was one of the responding officers. I don't recall the rank he held at the time of the incident.
Okay. Now, firearms.
Sure.
Mr. Houston's car, inside Mr. Houston's car, the Lexus, or the car that
Mr. Asbury's car?
Mr. Asbury's car. And was it your understanding that was a rented car, rented from an individual or a friend?
It was.
It was in someone else's name. In that car was located a weapon, and that was the gun you described as not the Glock 42, but do you remember how you described that car?
It was a 9mm Springfield XD5, if I believe that's the weapon you're referring to.
I think so. Springfield?
Springfield, yes.
Got it. And that was discovered by the crime scene investigator, is that right?
It was discovered by Sergeant Walker. She obtained it while the vehicle was at the hospital. That was turned over to her when she collected up Mr. Houston's clothing and other personal items.
So the CSI didn't discover it, it was Sergeant Walker.
Correct.
All right. And that was in the parking lot of Southern Regional Hospital.
I believe it was closer to the drive-up drop-off, like where for the emergency room. I don't believe it was in an actual parking spot.
Yeah, that makes sense. Now, have you read then Investigator Thomas's report?
At some point I did, yes.
And that would be her narrative, correct?
Correct.
And it's rather short.
Relative.
All right.
I mean, it was a couple pages, if I remember correctly.
Do you remember the part where she describes the weapon
I do not off the top of my head.
that was located in the car? Do you remember that she indicated that Mr. Asbury advised that the weapon was belonged to him?
I don't recall if that was a statement that she said that Mr. Asbury made or that she inferred that it was his gun due to being recovered in the car.
Okay.
She did not have any knowledge of Rollo's interview with Detective K. Thomas that provided additional information.
Okay. Now, Rollo, I think you're referring to Polo?
No, sir.
Okay.
Polo is Mr. Houston and Rollo is Mr. Dukes.
Okay. But regarding the gun, I believe that she was just interested in who that gun belonged to, the one that was in Asbury's car.
Oh, if you say so, I don't recall what her
Well,
report
I mean,
said,
I'll ask
so.
you. You had Asbury in the car. He drove Mr. Houston to the hospital. Mr. Houston was shot in the car.
Correct.
There were no other witnesses other than Mr. Asbury. Is that correct?
For this second shooting?
Yes.
Correct.
Okay. For when Mr. Houston was shot. So, again, then Investigator Thomas was interested in determining who that gun might have belonged to. And in her narrative, she indicates that Mr. Asbury said it was his.
I don't recall reading that on the report, or I would have to rewatch that interview.
Did Mr. Asbury ever tell you that it wasn't his gun?
No, I did not speak to Mr. Asbury.
Okay.
You, but that's not his report.
That's my question.
Oh, okay. All right.
Which may I approach?
I'm looking at this and seeing if that might be what you read. Don't read it out loud, but I've seen that before.
Yeah, this appears to be a segment from her report, her supplemental report.
This I've seen before.
Yes.
Does it appear to indicate that Mr. Asbury claims the gun?
You mind if I read through it? In the first paragraph here, Detective Sergeant Walker. Sure, I believe she's referring to When she said belonged to him in her previous statement, she's referring to Mr. Houston and Mr. Asbury describing that gun as Mr. Houston's. Is that what you were referring to?
So you believe that it was the then investigator Thomas saying that the gun belonged to Mr. Houston?
From that excerpt that you gave me, that's what I understood that
that's fair.
sentence.
So if investigator or Sergeant Walker testified that was Asbury she was referring to, she would have been mistaken?
Potentially. It should be noted that as Sergeant Walker was not the primary detective, she only had a segment of the portion of the investigation at the hospital. She was not at the crime scene with us. And then she also then re-met with Mr. Asbury to administer the photo lineup. She was not privy at the time to all the information that I had received as far as all the guns that were located. And if she did believe that gun was Mr. Asbury's, I could see how she could infer that from it being located in his car at the time that she came into contact with him.
Okay. Does she appear to be quoting Mr. Asbury though?
It appears to be some sort of summary of it. I wouldn't call it a direct quote.
Okay. The gun, after it was retrieved, is now in evidence. Was that gun ever test fired?
I believe it was.
Were the munitions associated with that gun compatible with the munitions or the shells found at the crime scenes?
They were not.
So that gun wasn't involved in this incident at all.
No, sir.
All right. Now, it wasn't directly discussed, but I know that you've got some certifications in gang investigation experience, and you testified to that when asked. Is your department notified when there's going to be an event at that 4155 Pittman Road property?
Not to my knowledge. If there has been any notification procedures put in place, I'm not aware of any.
You testified that that is a high volume call property, and that was a property already known to you, even though you hadn't been on in the department very long at that point, right?
Correct.
You suggested, or you said that there had been shootings and other kinds of incidents there, right?
There has.
Okay. Holding an event like that, where you have a lot of traffic in and out, is there any requirement from your department? And when I say your department, I mean code enforcement, because let me back up and ask you, your department actually handles code enforcement, does it? Code enforcement, your police department.
They're their own division. I don't believe in our administrative structure. They fall under the chief of police. I believe they may fall under a different, but I don't know for certain.
But you have a code enforcement division in
The city of South Fulton does have code enforcement, yes.
Are you aware of what their policy is about getting a permit of some kind for an event like that?
I am not.
Do you know if there is one in place now?
I do not. Since my time of employment with the South Fulton Police Department, I have been with the Criminal Investigation Division as a detective. I've never worked in a uniform capacity with the city of South Fulton, where I would have been responding to public order crimes with the code enforcement officers.
Okay. So the event that day, in hindsight, you know to be a day, you've seen the promotional material?
After the incident, not prior to.
I understand. And you know what kind of day it was. You know what they were really promoting, correct?
I do.
And rather than just talking around it, it was a gangster day event, wasn't it?
That is what my belief is, yes.
And it said G Day on there, right?
It did.
And in some of the fonts, do you recall that you had a big G, a big D, small a, small y?
I don't recall the specific details of the font.
What does GD stand for generally, just in your?
In this capacity, Gangster Disciples.
Is there really any doubt at this point, and after your investigation, that that wasn't just an event to celebrate a day that was really a gangster disciple day?
That is what I believe it
Not
to
a
be.
birthday party or not? Birthday parties and things like that might have been incidental to him, but
Correct.
G-Day event, correct?
Yes, sir.
And what is the significance of the letter of 7/4? It was on 7/4. It was on July 4th. What's the significance
Yeah,
of 7?
7474 is a common identifier of gangster disciples because G is the seventh letter of the alphabet and D is the fourth letter of the alphabet.
And is this a day that really is kind of revered and recognized?
It is.
So it's not unusual to have a gathering like that in celebration of GD Day anywhere in the country, I suppose, right?
I wouldn't see why not.
You ever known of a GD Day celebration, so to speak? Is this your first experience with one?
It is, yes. Outside of training that provided identifying information for the gangster disciples and common customs.
So is it fair to say that everybody attending that event probably had some kind of knowledge of gangster disciples, or that they, if not some affiliation with them, that they were aware that it was a gangster disciple event?
I don't believe that every single person at that party knew it was the event. I know party invitations get, people get invited to parties all the time, and it's a pool party in July. Who wouldn't want to attend?
But did you say GD Day or G-Day?
Depending on how they receive the promotional or the material or the invitation, but I wouldn't assume that everyone there is affiliated with a gangster disciple criminal street gang,
So some could have just been guests or going along to get along.
potentially, or attended with a friend.
And among those folks that were there participating in GD or Gangster Disciple Day event, what are some of the commonalities among people that are part of that gang? Would they have a gun, for instance?
Depending on the situation, yes.
Do they normally have a gun?
I would assume so.
And your understanding was that the event itself forbid guns to be brought in, so they would have been locked away somewhere else.
They would have been instructed to lock them away. Whether or not they did, I don't know if there was any protocols in place to pat people down or conduct searches of people's personal property.
Okay. The two shell casings that you are aware of that I think you either found or was found at your instruction to the CSI tech, one was older. It was a 22, I believe you stated. You thought it was older.
Yeah, I would have to confirm that was, I believe it was from memory, I believe it was the 22 caliber casing that was submerged in the earth.
And the other one would have been compatible with was it I'm sorry, say that again. It was a 22 that was submerged? Or?
If my memory serves correct, it was the 22 caliber casing that was submerged, appearing to have been there for an extended period of time.
Okay.
And the 40 caliber casing was lying on top of the ground surface.
All right. So you expected it would have been a 40 caliber weapon that would have been used to kill Mr. Leonard?
Due to the spent casing appearing to be fresh, yes, I would.
That casing that you think is older and perhaps it's been there a while, how far away from Mr. Leonard's body was that?
A couple feet, I would estimate.
Okay, so it's maybe feet, if not inches, correct?
Well, it'd be consistent with the standard length that most casings eject from without being obstructed by another object or structure.
Well, I'm referring to the one that you don't think that was ejected that evening.
It was feet away,
So arm's length, maybe?
potentially, depending on the arm.
All right. And you, as part of your investigation, you've pretty much dismissed that could have had anything to do with this case.
I believe it is highly unlikely for that case, the casing to be involved in this case.
Mr. Leonard had 2 bullet wounds, correct?
I believe he had, I would have to refer to the medical examiner's report. I remember the primary wound being to the neck. And I also remember there being some evidence of old injury, but I would have to refer to their report.
There's a lot of testimony, or there's a fair amount of testimony on direct examination about cell phones, and the cell phone in this case was, I guess, the one you recovered in Rome, Georgia.
Yes, we did recover Mr. McCoy's phone in Rome, Georgia.
Prior to that, and closer to to July 4th, did you contact carriers about cell tower pings?
I did not know.
In a case like this where you've got a suspect that's at large, or you want to know where the suspect was at the time of the incident, would you normally look for that?
If I had a phone number for the suspect at the time, which I did not for Mr. McCoy.
Well, you can get cell phone pings and actually work the other way, can you not?
Potentially, but the tower would provide hundreds and thousands of phone numbers pinging off that tower, depending on the time frame that was set.
Okay. It was late at night or early in the wee hours of the morning. The investigations do work that way, correct?
It can, depending on the
backwards.
circumstances of the case.
Because often you don't have a cell phone number, but you're looking for a suspect, correct?
At time, yeah,
All right.
there are cases that work that way.
And of course, everybody has cell phones, so if you had a number of people with cell phones, it wouldn't make it easy, but you can start sorting some things out and eliminating folks, right?
Potentially.
And is it not true that just the technology is highly sophisticated now, right?
Real compared to what?
Well, I mean, the pings can zero in just on, I mean, longitude and latitude of an individual.
Depending on how the phone is interacting with the tower as well as geographical data in the area. I mean, cell phones drop signal all the time. There's a lot of circumstances that go into how much information and how reliable that information is.
But that's one, isn't it? That cell phone pings can identify the very global location of an individual. So if you know the global location of the incident, you can work backwards that way, correct?
Correct, but what I'm trying to say is based on all the other factors and generally speaking, it would affect the accuracy of that location. It could be a 5-foot radius. It could be a 500-foot radius. You know, that accuracy is going to be contingent on a lot of factors.
It could be, but you didn't attempt to go that direction, correct?
No, I did not.
And if you had, you might have found, say, Mr. Asbury's phone, Mr. Houston's phone, and the assailant's phone, if the assailant had a phone.
On the records? Is
Yes.
that what you're referring to? Like the evidence of the phone being in there and not the actual phone? Yes, potentially.
And what you would have known, the part of the equation you would have known was where the incident was, correct? The global location.
Yeah, and I do know the incident location. I wouldn't be able to speak as to which tower would correspond to that location.
Right. And there are ways to even narrow down and take the incident location and just obtain the very latitude and longitude of that place, right? Where you're standing.
Are you asking if I would be able to learn the latitude and longitude of the crime scene?
Yes.
Yeah, you can do that through Google.
So in terms of working backwards, that would have been one way to determine who was there. You know, 2 people were there, and well, you know, 3 people were there: the assailant and Mr. Asbury and Mr. Houston.
No, I know several people were there.
But I'm talking about right at the crime scene.
Correct.
Okay. The phone that was recovered from Mr. Houston, was there any DNA analysis done on that phone? I'm sorry, the gun that was in the car, the Lexus. Was there any DNA analysis done on that gun?
I believe CSI swabbed them for DNA. I don't know if there was actually any usable DNA recovered from the firearm.
And is it your testimony today that there was not?
I'm saying I don't know if there was or not. I know that it was swabbed for DNA. I don't know what the GBI results to that were.
Okay. Do you know if that would be integral to your investigation?
I don't believe so.
Why is that?
Due to it being under the seat at the time he was shot, based on Mr. Asbury's testimony.
How about fingerprints?
Same answer.
Do you know if they were tested for fingerprints or compared for fingerprints?
I believe that CSI attempted to pull prints. I would have to refer to their report whether or not they were able to obtain any usable latent fingerprints.
But it has nothing to do with the conclusions you came to in this investigation, right?
Correct.
Of the 10 people or so that were there, and I know you were counting Mr. Asbury, were you able to speak to each of them at some point that evening?
They were all spoken to by a member of the South Fulton Police Department, not me specifically.
And I believe you testified that you remained on the property.
I did
What until sun came up, I guess?
until the crime. We concluded processing all the evidence.
But it was a long night, correct?
It was.
When my client was arrested, he was, let me ask you this first. Later, you obtained a cell phone number for my client, didn't you?
I did.
Did you track that phone?
A search warrant was submitted to T-Mobile, which was the carrier of that device, and the phone number was obtained. That information was provided by the South Fulton Police Department's digital evidence unit after I submitted the physical phone into evidence. The search warrant was submitted, and T-Mobile responded that that number, they had no records of that number being active at the time.
Does it have to be?
Not necessarily. It can be connect to Wi-Fi and the device could still show activity and network connection, but it wouldn't be maintained by T-Mobile records at that point.
And that's not the way that my client was found, was it?
I wasn't present when your client was located. I wouldn't be able to speak to how he was found.
Okay. You don't know anything about this?
I know that I was contacted. I know the address he was located at and the car that he was driving, the property on him at the time he was taken into custody.
Okay. And you don't know that, or didn't know that, maybe don't know today that he was attending the second probation meeting that he had in Floyd County in Rome?
I know that the location that with U.S. Marshals provided was a government building containing probationary offices, but I'm not super familiar with the details as to why or how many times he had been there.
Did you take a look at what kind of probation my client was on at that point?
I did not.
Would you have been interested to know whether or not it was, say, a violent offense or one involving a firearm or
Well, sure, but
Something similar.
I don't believe it'd be relevant to my investigation.
okay. Can I ask why?
Because aside from potential charges of a felon being in possession of a firearm, I'm not going to let someone's criminal history dictate the course of my investigation. I'm going to let the physical evidence and witness testimony do that.
All right. And Mr. Leonard's gun was found in his car, is that right?
Mr. Leonard,
Gun
the gun I believe to be owned by Mr. Leonard was found under a mat in the back seat of Mr. Asbury's car.
Oh, Mr. Asbury's car.
The car Mr. Asbury was driving was
there were
not
two-
registered to him.
Okay, I'm sorry. So there were two guns found in Mr. Asbury's car?
There was one at the initial processing of the secondary crime scene by Sergeant Walker. That was the Springfield recovered from under the front passenger side seat. And then the car was impounded to the South Fulton Police Department's Property and Evidence Division, where Detective K. Thomas had obtained a search warrant for the search and processing of that car. During the execution of that search warrant, a second firearm was located from inside the car under a mat in the backseat of the car. And that was the Glock 42 cal 380, chambered in 380.
And you have reason to attribute that, the ownership of that gun to Mr. Leonard, right?
Correct.
And in fact, just last question about that, but that's really not integral to your investigation in one way or the other, right?
No, it's extremely integral.
Then tell us how.
Because it shows that Mr. Leonard did not have his gun on him at the time he was shot. He had put it up in the car consistent with attending a pool party where firearms weren't allowed.
I see. Of course, that was pretty evident that that was the case just because one wasn't found with Mr. Leonard when he was shot, right?
I'm sorry, can you repeat the
There
question?
wasn't a gun found with Mr. Leonard or his body when he was shot, so.
That's true, but it would take away the possibility of maybe someone removing it from the crime scene.
You also called attention to the fact that other witnesses have that it was dark when you got there, like the area was very dark.
It was.
And even though this property is used for events and overnights and so on, and that area doesn't provide any light for like the parking area.
Correct. The property lights are primarily directed at the pool and residence, not the area where the incident occurred.
Okay. And you said it was just the lights of the other cars or police cars that gave you the illumination you needed to.
Yeah, the patrol vehicles and the emergency light bars in our police vehicles have a illuminate button where it will shine a non-flashing white light to illuminate areas, similar with high beams or someone turning on their brights. So we illuminated it the best that we could at the time.
You saw the video with Rolo Martez Dukes. You commented on that.
Are you referring to the body cam video of the interview? Yes, I did.
Is there any other than that you know of?
Not that I know of. I just want to make sure that I was referring to the correct video.
Yes, sir. And it would have been your investigator, Kay Thomas, who was whose body cam that came from?
Correct.
It was kind of lengthy, correct?
Not as far as interviews go with witnesses.
Well, I mean, it wasn't a 5-minute thing.
No, but I have interviews that spanned hours
Well,
sometimes.
I don't doubt it, but this was more of a just talk and,
Yeah,
get the video than it was an interrogation or a
Correct.
sit-down interview, correct?
Yes.
And on it, you don't really hear Investigator Thomas asking a lot of questions, do you?
No, Mr. Dukes was doing most of the talking in that video.
Was your impression that Mr. Dukes when he was talking, was probably intoxicated?
I wouldn't be able to, it's a possibility, but I wouldn't be able to say for certain.
I understand you would be able to say for certain, but was his behavior what you expected to see?
I didn't expect to see any sort of specific type of behavior. I didn't interact with him. I don't know what a sober versus drunk baseline for him would be. I wouldn't be able to observe any odors of any alcohol to try and determine level of intoxication.
So in your view, he didn't act intoxicated?
I mean, he could have been, but I wouldn't be able to say for certain.
Did he act like he was in your professional view, did he act like he was under the influence of something?
Again, I don't have a baseline for Mr. Dukes to be able to determine what substances he may or may not have been on.
Does that mean you don't know anything about any other conditions he might have been?
I know he was attending a party all day, and I could make educated guesses as to what he may have partaken in. But as far as his ability to communicate, he appeared to talk in complete sentences, form complete thoughts. He was coherent in his ability to provide accurate information.
You didn't think he rambled a lot?
I imagine he spoke as much as anyone that may be rattled up just observing someone they know get shot in the neck.
Do you have any interaction with Mr. May?
I know that he was one of the party attendees that officers made contact with, but I did not specifically know.
Let me refresh my notes, but I believe that's all I have for you, Detective. Video cameras, let me ask you about that.
Sure.
The photos that we saw and the jury saw entering the property call attention to 24-hour surveillance. So those were installed later.
I believe so. I do not recall seeing them on the property.
Do you know when those photos were taken?
Yes, I was present when they were taken.
About when would that have been?
They were taken on the 3rd of October in preparation for this trial.
Okay, so well after the
Correct.
incident date. Did you talk to the owner of the property, Mr. Demo Williams?
Yeah, officer, I did not directly. I talked to him, but we did talk to him at the scene.
Okay. Did you ask him about video surveillance at the property then?
I don't recall any specific questions. I recall, are you referring to cameras at the residence or in the wooded area?
Well, any that he would have known about having on the property, whether they were the residence or in the wooded area?
I don't recall any specific questions about cameras. That he was shot was near the trees where there was no cameras visible.
With your experience, you'd be looking around for stuff though, right?
Correct.
Did you see any video cameras anywhere?
I did not.
And again, in your experience, Mr. Williams would have been the party you'd want to ask about that, being the owner of the property, correct?
Correct.
Do you know if any of your other folks asked him about it, about cameras?
I don't recall. Not from any of the supplement reports that I read.
I believe that's all I have. Thank you.
Thank you.
Any redirect?
Yes, very briefly. The published states Exhibit 6. Oh, come back. Okay. Look for 2 buttons. Okay. Give it a minute before you push play.
Dip him! Dip him! Dip him! Stop being drunk. Hey, little ass nigga! Little ass nigga! I just had to nigga. I'm not going nowhere.
Do you recognize the people in this video footage?
I do.
Right, and is this a different vantage point of the previous video footage on social media that you discovered?
It is.
Okay, does this one include sound?
It does.
And at the beginning of this video, who had who in a bear hug? Or their arms wrapped around the other person?
Yeah, I believe it was Mr. McCoy that had Mr. Houston in a bear hug, but if you can rewind it. Yeah, it was Mr. McCoy had his arms around Mr. Houston.
Okay. And what does Mr. Houston do?
It appears that he breaks away and gets separation from Mr. McCoy.
Right. Now, was Mr. McCoy facing Mr. Houston or was he behind him or something else?
Initially in the video, he was behind him. At this point where the video stopped, they are more face to face.
Okay. Now I just want to play it from the top without stopping.
Sure.
Dip him! Dip him! Dip him! Stop being drunk. Hey, little ass nigga! Little ass nigga! I just had to somebody, nigga. I'm not going nowhere, nigga. The biggest. This shit come from I'm not going nowhere, nigga. I'm just standing there, boy. You're on the hill. You small. Stop playing with me. This shit. You want to go in there now, nigga? You want to go in there now, nigga? Take them off, like I told you the first time. Take them out like shoes, nigga. Take them out like these ain't nothing but some shoes, nigga. Let go. These ain't nothing but some shoes, nigga. Now we playing. We playing. You know what I mean? Man. You know what you need, nigga. You know what he need, nigga? No, he's sparing you. Come on the mall. That's on GD, he's sparing you. Look at that twist. He's sparing you. He mad. What they do? I ain't gonna count. Everything we see, he's sparing you. I'm sold. Hey, look, I ain't talking about that.
And so now with sound, do you hear and see everyone laughing around him?
I do. It was more of a play fight.
But was it in reference to him being small compared to Mr. Houston?
Correct.
Okay. And when they pulled Tezzy or Teasy away, I believe they said Teasy. So when they pulled Teasy away, did you hear Teasy say something about sparing Mr.
Okay.
Houston?
He was spared on GD,
He was-
or on GED, he was spared, one of those two.
Spared on GD?
Yeah.
Right. Towards the beginning of the video, did you hear someone say, Teasy, stop being drunk?
Yeah.
All right. Now, did you review all the videos and body cams in this case, including those that were provided by Detective Walker or Sergeant Walker now?
I did.
Okay. Did you see in any of those videos where Ashbury states that the firearm belongs to him?
I did not know.
Okay. And as you testified on defense, could Detective Walker be mistaken?
Certainly is possible.
Okay. But you stated that possibly an assumption since it came from Ashbury's vehicle?
That would be my belief of it.
Okay. And so just to reiterate, who's the primary on this case?
I am.
Okay. And so was Detective Walker's role small in comparison to the larger investigation you had?
It was.
Okay. Was she privy to any and all things that included into the full investigation?
No, she was not.
Was she limited simply with the, providing the photo lineup to Mr. Ashbury and receiving his statement?
Yes, and collecting his property initial evidence as well.
And collecting Mr. Houston's property?
And she also impounded the car to our property and evidence division for further processing.
And impounded the car. Did she hear the statements from Rolo or anybody else involved, that witnessed the event?
She did not.
Okay. In fact, you wanted to keep her separated from the entire investigation, correct?
Correct. I requested that she goes and handles the secondary crime scene while I was handling the initial crime scene.
Right. Now, in the video prior to this, the other vantage point of this video here, where the person said he got his shit took by Debo, what did you understand that to mean?
I believe they were referring to a previous incident where McCoy had allegedly taken another party attendee's keys.
All right. So there was two incidents of taking, and so we have the keys incident and then Mr. McCoy's firearm being taken earlier in the day.
Yeah, I don't know if one was incident to the other. The keys incident resulted in security taking away a gun from Mr. McCoy in the day, or if they were just entirely two separate incidents. I wouldn't be able to say.
Okay. Now, you talked a little bit about CDRs or cell phone data records or cell phone pinging towers. How long does that process take?
Can take several months depending on the amount of data being collected, requested, and what's available,
So you could've-
and by the carrier.
Okay, so you could have done a search warrant to the tower to acquire everybody that was at the location, right?
And in the surroundings several mile radius, any phone, whether it be on a nearby highway or just someone driving along,
Right. And
any
those
phone or any computer system in a modern car that connects with a network, any Wi-Fi router, anything that may connect to a cellular network would show pinging off that tower and it could potentially be thousands and thousands of data points.
Did you need help locating or identifying who was at the scene?
I did not.
Did you know who was at the scene?
I did.
Did we name all 10 of them in your report?
We did.
Okay. And did you need help with cell towers to identify who was your shooter?
No, ma'am.
Okay. Did you know who your shooter was?
I do.
And did you know that fairly quickly?
I did.
Okay. And you did a fugitive packet how soon after you arrived on the scene?
It was right after the warrants were obtained.
So a couple of days?
The next day, maybe, I'd have to refer to my report to get that
Okay.
exact.
But it was
time.
pretty quickly.
It was.
And with CDRs or any tower dumps been back by that point?
It would not have.
Okay. And did you need well, the testing like GBI testing, latent print testing, as it relates to the firearms that's in the vehicle? The firearms that were in the vehicle, did you see any shell casings in the vehicle?
I did not.
Did it appear that those firearms got shot or were shot at any time within that vehicle?
No, ma'am.
Were the firearms appear to be in the same condition to where they were tucked and left before the party?
Yes, ma'am.
So would that help you would that help your investigation on determining who killed Mr. Leonard?
Sure would.
I'm sorry?
Well, the fact that where they were located in the car would help me determine who would have been a primary aggressor and to confirm that Mr. McCoy was the primary aggressor.
Right. No, I guess what I'm asking, I'm talking about Mr. Leonard. So
Okay.
would the guns in the car help you determine who shot Mr. Leonard
No,
at the
ma'am.
scene?
No, ma'am.
Did you already know who that was?
I did.
Okay. And the guns in the car, would they have inside the vehicle would have helped you determine who shot Mr. Houston in the shoulder, chest?
They would not have.
Did you already know who did that?
Yes, ma'am.
No further questions.
Just briefly, Judge. Detective, you only had one suspect then, right?
Correct.
And you never had another suspect,
Correct.
and you never looked for another suspect.
The witness is only advised of one shooter.
Okay, so you've got Mr. Marquez, who you don't know, you don't have any idea what he said so far that evening.
At the time that the warrants were taken out, Detective Thomas had already conducted his interview with Mr. Dukes.
So you know what confirmation bias is, correct?
I do.
You got one person's name, end of the investigation, right?
No.
That's all I have, Judge.
All right, can this witness be excused?
Yes, Your Honor.
Sit down, sir. All right, members of the jury, it's time to take our break for the afternoon. I do still believe we're on track to begin closing arguments today. And so if I could ask you to be back, let's just say 1:10, and we'll go with, continue with the evidence from there. All right, please don't discuss the case amongst anyone, including amongst yourselves, or do any research. We'll see you back at 1:10.
I released from subpoena.
Yes, you
So I can be present.
You can be present for the rest. Yep.
Get you. Yeah. Like, I know I'm sure, like, can it be any in the 200s?
Like them to jump.
All right, before we recess, I plan to give you a working copy of the consolidated charges that we will be using and going through for the charge conference. And once we're through at the charge conference, this is the copy that'll be cleaned, the headings will be removed, and the jury will get a copy of it. But this is just something for you to be able to review during the lunch break, so we know what to expect and what to discuss during the charge conference themselves. So I have that along with a potential, and again, rough draft verdict form for the parties as well. Anything else we need to take up before the recess on behalf of the state
No, nothing from the state, Your Honor.
or the defense?
No, Your Honor.
All right, we'll see you back at 1:10. We're off the record. If you want to retrieve your copies. There they are.
Okay. So
Are we high? So I'll do 501.
yeah.
Okay.
Can I get you anything during this break while you're working on your
Do you
closing?
have $1? I'm always.
I actually am out of dollars.
It's okay.
Thank you.
I will find $1.
Okay. You have $1?
I don't.
No.
I have one.
I actually literally just.
Oh, that would be amazing.
Oh,
I just need one. I'm sorry.
that's hilarious. Okay, I'm gonna put this on your laptop so that you know that this is the verdict form and the charge.
Okay. All right.
Deputy Scott, can you come back when you're done? The podium is off.
Just in the way, right?
Good, thank you.
You go.
Keelan wanted to know if you had more. Perfect.
Any particular colors you think are appropriate? I brought all the primaries.
Where you blue? You know, I'll be black. Come back.
You don't want to black. You can take, Your Honor, would you like to witness on the witness stand?
That's fine, yeah. If we're ready, I know I need to check in with the jurors, so I don't know if we have them all.
Even publishing.
I guess they might have turned the light on.
Good of, oh, yeah.
You have it. I mean, like,
No,
you have.
oh, yeah, no.
Yeah, okay.
They'll see it in the back.
Mhm.
So we're live. Thank you.
Thank you. I always forget that.
We're not saying anything.
See who we got?
Can we flip over our exhibits now?
Mhm.
Okay.
Didn't even think about that.
No, I just need to get back on Zoom.
What do you mean?
The link is in your.
Well, because I see you start writing. And
Thank you for
so I
getting
just
the
think,
link.
wow,
Demetrius. Thank you for getting
stealing
them.
my thunder.
Demetrius saw me like freaking out about like how I could get this.
Right.
So.
You need me to do it now? I'll do it now. He's lining them up. We're back on the record. All parties in council are present, ready to resume evidence. And we will now bring in the jury when they are ready.
That's what adjourned.
This is my home. Yeah. Okay.
Just a present, Judge.
Thank you, Deputy Scott. Please be seated, everyone. Stay, may call its next witness.
The state calls Detective Manson.
Swear from.
Ma'am.
Help you?
I do.
Wait, see it? I'm speaking to the state. Board.
Yes. My name is Detective Kenya, Kenya, last name Manson, Manson.
Good afternoon, Detective Manson. Where are you employed?
I am currently employed with the City of South Fulton Police Department Gang Unit.
And are you post-certified?
Yes, ma'am.
And how long have you been a post-certified police officer?
I've been a post-certified police officer. This is my 19th year.
And what unit are you currently assigned?
I'm currently assigned to gangs and narcotics.
And how long have you been assigned to that unit?
I have been assigned to that unit since 2018.
And prior to 2018, what was your assignment?
I started my career in law enforcement with the Atlanta Police Department, started in 2004. I left in 2014 and went trucking a little. Didn't like trucking, especially when it got cold. So I came back into law enforcement and started working with College Park Police Department. I stayed there 22 months. After leaving College Park, I came to South Fulton, where I have been with the gang and narcotics unit ever since coming on board.
Okay. And so how many years is that with the gang and narcotics unit?
I have been with them. It's going on my 7th year.
Okay. And what is your background training and experience that qualifies you to perform the duties in your role?
My duties in my role, we take courses. We start off with simple courses like identifying, trying to learning how to identify what things to look for. Then we go into the investigation role. We learn how to not only identify but also learn how to investigate and write it up through social media documentation, learning to work with confidential sources, CIs.
All right. And have you gotten any certifications?
Yes, I have gotten certifications. I was certified with basic gang awareness and advanced gang awareness. Like also we do just primary investigations, also homicide investigations. I've also was certified in blood splatter. So I try to be wide and vast because with you learning with being a gang detective, you may see various things of how they commit crimes.
All right. And how often do you attend training?
Usually we have a meeting. We actually have training at various locations at least once a month. Each agency, whether it's Cobb County, recently, 2 years ago, the Fulton County schools, they started putting on the training because they start seeing things in their schools. So we at least try to go to training at least once a month.
And is that common to have training so often?
Yes.
Why so?
Trends, patterns, children, everything changes. Social media, 1 minute you may see things on social media that may, go with an individual that was deceased. And then next minute, if that person deceased, they'll stop following that person and they'll end up going with another group. So trends and patterns are constantly changing. And we just need to stay abreast and be on top of everything.
And you mentioned social media. Have you had social media investigations?
Yes.
And what does that entail?
That shows us how to critique of doing the preservations online, writing thorough search warrants, also getting the information, uploading, sending it to the companies, getting the records and how to go through the records and efficiently get your evidence.
Okay. Is it fair to say that your gang experience and training is ongoing?
Yes.
Okay. Now, have you been qualified as an expert in criminal street gangs and criminal street gang activity?
Yes, ma'am.
And how many times have you been certified in court?
I have been certified at least 10 times in court, here in Fulton County and in Douglas County. I had a case there that bled over into Douglas and fed as well.
Okay. Now, you stated that you stay current on gang trends, rivalries, and alliance customs and habits. Do you do that just with your training, or is that field work as well?
It's field work as well. We're constantly going out doing search warrants. We're also working hand in hand with patrol. So in case we need to jump out there, talk to individuals that are in fear of their life and bring them to a safe haven, we are oftentimes plainclothes officers. So it makes them comfortable to want to talk with us, sit with us, and get the information we need.
So with all of this training, certifications, and experience that you receive, have you developed a familiarity with criminal street gangs, their activities, customs, and behaviors across the United States and in Georgia?
Yes, ma'am.
And are you a member of any professional organizations related to criminal street gangs?
Yes, I'm a member of the GGIA. That's going to be the Georgia Gang Investigators Association.
Right. And briefly, what is that? How does that assist you?
That is it. The GGIA is a professional organization for law enforcement officers in Georgia. It focuses on identifying, investigating, and preventing criminal gang activities.
Can you roughly provide an estimate of how many gang members you have come in contact with or interviewed over your time as a gang expert?
I've interviewed close to and approximately over 5,000 individuals.
And when you come in contact with those gang members, what is the purpose of speaking with them?
It's to gather intel, it's to gather information. Like I said, we're constantly trying to update our system, make sure our system is accurate, we're getting the right information.
Now, are gang members always forthcoming when it comes to giving information about the gang?
No, no. Of course, some gang members, they're gonna deny it because, as you know, Georgia have one of the toughest gang prevention act laws. So a lot of times it's not too many people that's gonna say, yeah, I'm a gang member.
Are some people proud of it, boastful?
Oh, yes, we have some people that are boastful, very proud to be in a gang. And a lot of times those are your older individuals.
Now, when you receive this information from making contact with gang members, do you share it?
Yes, so that's the beauty of being a member of the GGIA. It's a big network. So things that an investigator may see, they may share it through the network, through that professional organization that then sends it out. Like, have you all seen this? Because they may have not seen it, and then there may have been individuals or other officers that have seen information and that can input and give more information to what I've already gathered.
And so on the other end, do those agencies share information with you as well?
Yes, ma'am.
Okay. And is that shared through task force, electronically, what?
Yes, we have electronics. Sometimes we go pick up evidence. They may have a book. They may have a book of knowledge. And for those that don't know what a book of knowledge is, just the gangs, what quote unquote Bible, their book of knowledge is the gangs insight, the structure, and how it is organized.
So is it common for sworn law enforcement officers to seek out your expertise in identifying gangs and gang members?
Yes, like I said, crime bleeds over often in other jurisdictions. It's just not in South Fulton. Crime bleeds everywhere. So I may be familiar with a person, or someone from another jurisdiction may be familiar with a person. We often contact one another to see if anybody have came in contact with these individuals.
And in addition to that, what about like actually inside your agency, like in this case with Detective Principe?
Yes, so CID and gangs have to work hand in hand. It's impossible to do a case that, especially if it's a gang case, we must have the detective, the lead detective, because they have to take out the predicate charge. That's the main charge. I'm responsible for the gang charge. That's the enhancement charge.
Now, have you received any awards or recognition for your law enforcement service?
Yes, ma'am, I have.
And what are those?
For 2 consecutive years here in South Fulton, I have been Investigator of the Year.
Um, Now, how many years have you investigated the Gangster Disciples criminal street gang?
So with Gangster Disciples, we started investigating as soon as we got into South Fulton. South Fulton originally was full of Gangster Disciples, and that was mainly in the early 2000s, mid 2000s. We had a lot of FBI came in, they did a big sweep, and they kind of, like filtered out. However, we do get them every now and then. So that was like our main introduction to the gang component when we came over to South Fulton.
Okay, and out of the times that you've testified about Gangster Disciples, how many times would you say that was for Gangster Disciples? I apologize.
For Gangster Disciples, I've testified at least on 2 trials. Like I said, it's not like a whole bunch of them that came into South Fulton. By the time we came in and the gang unit formed, the FBI had already came in and dismantled a great deal of them.
Okay. And have you had contact with Gangster Disciple members?
Yes, like I said, it's not a lot, but we do get in contact with a few of them but they always affiliated with other street gangs.
Now, approximately how many members would you say you've come in contact with?
In South Fulton, like I said, it's not a lot, but we come in contact at least 25 members.
Okay. How familiar are you with Gangster Disciples, strongholds, and territory?
I'm familiar, especially back in 2021, we had a very big case that bled into Atlanta. So I learned a little bit more with that case. That was also a homicide case.
Right.
Which may we approach?
1, 2, 4, 5, 6.
All right, State, why don't you,
Yes,
we'll ask the
Judge.
next question.
Um, and do you gather intelligence related to the Gangster Disciple criminal street gang?
Yes.
Okay, and how do you verify that intelligence?
Through police reports, identifiers such as tattoos. Sometimes you have a good bit of them self-admitting. Talk with other agencies that may have had encounters with these individuals as well.
And is that also social media?
Social media is a big part, if I'm able to find it.
And does that sometimes include jail calls?
Yes, ma'am.
All right, and so are you familiar with the Gangster Disciples identifiers?
Yes, ma'am.
All right. And I understand you said it's not a common occurrence in South Fulton, but how often do you investigate gangster disciples and the criminal street gang gangster disciples on social media?
Like I said, we're constantly on social media, so we're looking at various gangs. So I often come across gangster disciple members, as well as blood gang members and hybrid gang members.
And would you agree that maybe daily?
Daily, very often, especially the Instagrams that belong to those in prison.
Um, and did you prepare a curriculum vitae of your training and experience?
Yes, ma'am.
All right. Approaching the witness with State's Exhibit 442. Is that a fair and accurate copy of the resume or curriculum vitae that you provided?
Yes, ma'am.
All right. And has any alterations, just look through it real briefly, any alterations been made to that?
The only alteration that would be made to this is my attendance with the 2025 Georgia Intelligence Gang Association Conference this year.
Okay, you're saying that's not on there?
No, that's not on there.
Right, but is that document altered in any way? Have I changed your document?
No, ma'am.
Submitted to me. Okay. At this time, the state moves to admit State's Exhibit 442.
No objection, Your Honor.
Submitted.
And at this time, the state tenders Kenya Manson as an expert in street gangs, criminal street gang activity, criminal street gangs investigations as it relates to the gangster's disciples.
Of order, no objection, Judge.
Thank you. Proceed.
All right. Now, Ms. Detective Manson, did you also prepare a PowerPoint presentation to assist the jurors in the testimony you're going to provide today?
Yes, ma'am.
All right. And did you submit that to my office?
Yes, ma'am.
All right. I'm now approaching the witness with what I've already shown to the defense as State Exhibit 441. Just look through that briefly. And is that the same PowerPoint, just in printed version that you submitted to me?
Yes, ma'am.
All right. So at this time, the state moves to admit State's Exhibit 441, the PowerPoint presentation as a demonstrative aid to the jury.
No objection, Judge.
Submitted.
All right. And permission to publish. All right, Detective Manson, you titled your PowerPoint, How to Make a Gang Case. Why, how so?
The reason why we do this is because we just don't want to put any case together, or just because if it's a crime, we can't just say that because a person is a gang member, it wasn't a gang related crime. So what we try to do is we're not trying to just put any and everybody in a category to say that every case is a gang case. We want to educate the jury. We want to show them this is how we make an effective case.
All right, so let's move to the next slide. What is a criminal street gang?
So the first thing I try to do is educate the juror, anybody, to let them know what is a criminal street gang. According to our OCGA, a criminal street gang is any organization, association, group of 3 or more, in fact, whether formal or informal, which engages in criminal gang activity. Now, the second part of this definition is the existence of such association or group of individuals and how we establish them and consider them to be gang members. We look at common identifiers such as signs, symbols, tattoos, graffiti, attire. Now, social media, behavior, characteristics, customs. So we're just not categorizing you just because you got on black. I can't just say you're a gangster disciple. It is so much more to entail before we get there.
Now, Ms. Manson, just so for your assistance, the computer in front of you does have a pointer. Do you know how to use it? I just want to show it to you just in case you decide you want to highlight something on your PowerPoint. So when you touch the screen, you see that pencil?
Okay.
We touch the pencil and then you see it shows up. And then to undo, you see the undo button? It's like a counterclockwise. You can undo it. So if there's something particular, you can use that tool. All right. So what is criminal street gang activity?
So criminal street gang activity, of course, we go into OCGA. Our code of annotated is defined as commission, attempted commission, conspiracy to commit. So you have solicitation, coercion, or intimidation of another person to commit any criminal offense. And when I say the criminal offenses, I mean offenses related to our RICO statute.
Okay, and is this, when you say OCGA, just so the jury understands what OCGA means, are you talking about the Georgia statute?
Yes, these are our criminal offense codes that we use to make charges.
And so what type of evidence supports that a gang exists?
So things that we use police reports. You may be arrested with other gang members. You may have committed a crime that we see that is a continuation. We have field interview cards where you may talk to an officer and you may admit to that officer that you are a gang member, or that officer may just come in contact with you and may see a tattoo or a symbol that he may suspect that you are a gang member. So sometimes we do field contact. Correctional records. Sometimes we contact our correction officers and see if they have them documented. Sometimes they do document them when they come in the door. Sometimes it may be a little bit more complex for them because of the manpower that they have. We use social media, intelligence reports, and these are reports that, of course, we get from other agencies and, through GGIA. Documents and books of knowledge. These are, like I said, if you come across a book of knowledge, it is that book that entails and gives great in-depth coverage of what the gang is all about.
Now, I'm gonna clarify some of these. The book of knowledge, who creates and keeps that book of knowledge?
These will be gang members, older head of gang members that have passed down this information. And this is information that younger or members of this criminal street gang have to know.
Does a book of knowledge include what the hierarchy is of the gang?
Yes, ma'am.
Would a book of knowledge also include the code of conduct amongst its members?
Yes, ma'am.
And would a book of knowledge also entail violations and what would happen or retaliation for violations?
Yes, ma'am.
Okay. Now I'm gonna jump back up to the correctional records. You stated that when they come in the door, are you talking about when they're in intake at the jail or prison system?
Yes, sometimes they're able to, when they first get there, they're able to document them. Sometimes it may take a while if they get into an incident where they have been fighting or involved in a fight with a rival gang.
And does, based on your training knowledge and experience in the prison system, are in intake, do they ask that question? Do they ask that question of whether they have an affiliation for multiple reasons or just to see if they're a gang member?
It's for multiple reasons. It could be for their safety. If that particular gang isn't the most dominant gang, and if they have the rival gang or that particular adversary over there, they want to put them in a place where they won't have issues. We know sometimes it works, and we know sometimes it does not work.
Does it, in your training knowledge and experience, does it sometimes lead to a unit or area being a dominant gang, them all being put together?
Yes.
Okay. Now, what types of gangs are there?
We have four different types of gangs. We have traditional gangs. Traditional gangs are gangs that have a hierarchy. They follow the rules, regulations. There's no deviating from that. You have non-traditional and what I like to call hybrid. These are usually our neighborhood gangs per se. These are the gangs that if you're from a specific street or specific area, they will all come together. With non-traditional, they don't have a hierarchy. They kind of go with the flow per se. You will not see just one solid color or one solid symbol. You may have like a rash of everything, but they may call themselves one name. You have prison gangs and gangs that's in the prison. These are gangs that may started out in GDC and remains there.
When you say GDC,
Georgia Department of Corrections, sorry.
Okay.
And then you have your motorcycle gangs.
Now, what are the 6 criteria used to determine if a person is a gang member?
So we use arrested with members, for gang, criminal street crimes. You have associate styles and effects. You have other associate. You have self-admission. You have reliable informants. Sometimes we do get reliable informants that's like he's a gang member. And then we have untested informants that would say he may be the adversary and he may say, yeah, he a gang member, but we also verify it with either Styles and Associates or social media.
Okay. Now, the second one, association styles and effects. Can you explain to the jurors what you mean by association styles and effects?
You may have a tattoo. You may wear specific colors of clothing. You may, stand a certain way, get your hair cut a certain way, that all of y'all doing the same thing, and all y'all committing these crimes together.
Okay. If you decide to use an emoji on your social media, are you automatically a gang member?
No.
Okay. And so, how do you use this 6-point criteria to determine how to verify that a person is a gang member? Do you just use an emoji? Do you just use styles and effects? How do you use it?
You use all of it. You can use 2, 3, all of it. You can use reports whether he may have gotten arrested on more than one occasion with a gang member. You may see on social media where he constantly throwing up a specific hand sign and he has a specific tattoo that symbols that everybody in that gang often use. He may even advertise it on social media. Hashtag, GD, hashtag brother of the struggle. Little things like that you are able, but it's you collecting evidence. It's just not one thing.
Right. So this is a little tiny, but let's see if we can explain to the jury what a criminal street gang activity is.
So criminal street gang activity came from our racketeering act. So the criminal street gang activity, it can go anywhere from racketeering to stalking to sexual offenses, violent offenses, human trafficking, narcotics, entering autos, burglary. You even have so much as fraud. So any of the offenses that fall under that racketeering act, which we adopted, those offenses are considered criminal criminal activity, criminal gang activity. Now you just need the gang.
Right. Now, and in relation to this case, so most of these don't apply. You put at the bottom 42 predicate offenses. Does that include murder?
Yes.
Does it include, I'm sorry, does it include malice murder?
Yes.
Does it include felony murder?
Yes.
Does it include criminal damage to property?
Yes.
Does it include aggravated assault?
Yes.
And does it include possession of a firearm during the commission of a felony?
Yes.
Does it include possession of a firearm by a convicted felon?
Yes.
Okay, so all of those crimes I just listed are codified or on the statute as criminal street gang activity.
Yes.
Okay? What is a nexus?
So our nexus is what is required to connect that crime to the offender to the gang. So the requirement satisfied by evidence that the gang received the proceeds from or otherwise benefited from. So sometimes gang members would do a crime such as robberies, and sell illegal narcotics. You could show, as long as you could show how the gang benefited from this crime, it is considered a gang crime. Evidence showing retaliation. We get this a lot. You have a lot of retaliation where one person, especially if they've lost a member, they're going to retaliate against their adversaries who may have caused that member's death. Evidence show crime was committed in a highly visible manner as to allow witnesses and victims to discover that a particular gang committed it. Some gangs like to do stuff to show more of an intimidation, more like an arrogance to show, look, we are the baddest. Not all the time we get witnesses that are willing to come forth. Evidence that purpose of the crime was establish, reinforce, and enhance the gang's reputation. And so we have everything. We have the gang member, associate, crime, criminal street gang, criminal gang activity. And that plus a nexus equals a gang case.
All right. So look under point 2, evidence showing retaliation or an insult. Can you explain the or insult committed against the gang or any of its members?
So if a gang member feel that that person maybe reprimanded them or said something out the way and they felt that it was disrespectful, they have a tendency to want to retaliate. And that retaliation could even be a deadly retaliation, but they just want to show that you can't disrespect me in front of everybody.
All right. Now, on this slide, you said there's 3 types of gang crimes. Can you explain?
So we have the intra gang, that is the gang victimizes own members. So sometimes, you get a violation or someone is killed because they're scared that they're going to turn state evidence and they're in the gang. That's an intra-gang crime. Then you have an inter-gang crime, the gang victimizing their rival. Again, this back and forth shooting, beef going on. Those are often intra-gang. The most infamous is intra-gang. People that often get hung up in the crossfire, innocent individuals that's probably just there doing shopping or just day-to-day living, and they end up being victimized in the crossfire.
And which one of these would apply to this case?
I would most definitely say extra gang.
Okay. So what is an iron triangle?
So this is what we use to make a gang case. Like I said, we do not try to put every case as a gang case. We effectively try to make sure we do it the right way, per se. We have the crime itself through the commission of enumerated offense. We have the offender participates in criminal gang activity, and we have the gang, the offender being employed by or associated with the gang. Once we connect all sides, we have what we call the iron triangle.
And do you need all sides to apply a gang charge?
Yes, ma'am.
All right. So let's talk about the criminal offense in this case. Now, what did you know at the time of getting that information from Principe that he requested your assistance on his case?
So, of course, like I said, I have to work with CID, have to work with the Criminal Investigation Division. So, of course, when the call comes out, I get a call. So I let the lead detective get on scene, and he usually say, I need gang detectives. I need their assistance. Of course, he's on scene and he's getting information. Once he get the information, he called me, let me know that we have two deceased. Witnesses are saying that this occurred because the assailant is saying the assailant was being disrespected. Of course, with the social media, we seeing where that some individuals at the party was advertising this day as GD Day. In the PowerPoint later on, you'll see why it was advertised as being GD Day. So during the preliminary investigation, the lead detectives are seeing that this particular incident may be gang related. And if they strongly feel that it's gang related, they notify gang detectives, and we immediately start looking at social media, getting police reports, things of that nature to see if it is a gang-related homicide.
And so did you assist in using social media to provide the lead detective information regarding the shooter in this case?
Yes, ma'am.
Okay. All right. Let's talk about gangster disciples. Now, before I move on to the next slide, what are we seeing in this slide?
So in this slide itself, it's the introduction to the history of Gangster Disciple. But there's some things that you see that is significant that I wanted to just bring out. Gangster Disciples use the number 7 and the number 4, 7-4. G being the 7th letter of the alphabet, and D being the 4th letter of the alphabet. So that is the significance of the 7-4. They like to use the 6 pointing star, which they call the Star of David. The reason why they use the Star of David is because one of the founding members of the Gangster Disciple, when they all formed together, was David Barksdale.
Okay. And the one more thing, the reference of it being a nation.
It's been so when they first band together, Gangster Disciple plus Black Gangster Disciple, well, Black Disciples, they band together and formed a nation.
All right, give us a brief history of the gang.
So of course, we know that the Gangster Disciple is an African American street gang that formed on the south side of Chicago around about 1960s. We know that Gangster Disciple leader was Larry Hoover. He had the Supreme Gangsters, and David Barksdale leader had the Black Disciples. The two joined together, and that's how we end up getting the Black Gangster Disciple Nation, the BGDN. They later split and so into two fashions. we have the Gangster Disciples and the Black Gangster Disciples. And I know if you ever heard of the rapper King Von, King Von, he was the Black Gangster Disciples. So that's how you know they split. You have the Gangster Disciples, you have the Black Gangster Disciple of the BGs.
And King Von, this is a famous rapper.
He is a famous rapper.
And what area is he from?
He's from O Block in Chicago.
Now, what is the reference on the right of Murder Mob?
So here on the right, on both sides, you see the Star of David. You see the trident, or what they call them forks, the pitchforks. And the pitchforks is paying homage to the folk nation. You have people nation, you have folk nation. People nation is usually Bloods. Folk nation is usually Crips and Gangster Disciples.
All right, and so Gangster Disciples would fall under the folk nation of Crips?
No,
I'm
Gangster
sorry.
Disciples is its own entity. It is its own entity. It's just fall under the folk nation. Crips is its own gang. Gangster Disciple is its own gang, but it just happens to fall under the folk nation.
Okay, People's Nation, you said is the Blood Gang?
It's a blood. So again, it's a big, huge part, but usually that's gonna be your Bloods and your Latin Kings.
Okay. All right, and what is the structure of the gang?
So the structure of the gang is just like, we can say kind of like how our government is. You have the chairperson, which is the head. You have the board of directors, and you have two board of directors. You have one for the prison, you have one for the outside, which we call the state. You have your governors. Your governors is gonna collect the dues and have everything in order. He's the branch to the board of directors that then contact the chairman. You have your regents, you have your street enforcers, and then you have your soldiers and your non-members.
Okay, and you're making hand gestures in an up-down movement. Is this more of like a hierarchy from, I'm sorry, a hierarchy from high to low?
Yes,
All right, and how many tiers on this hierarchy?
you have your chairman, you have your board, which is 2, your governor, 3, regent, 4. You have your soldier, 5, your street enforcers, 5, soldier, non-member. So I'll say 6.
Okay. All right. Oh, I missed this. On the right-hand side, what are we looking at with the hand?
So that is an infamous, he's throwing up the pitchfork, so it's hard to do. Every time I try to do it, I end up having to get some little Bengay to rub in my hands because my hands cramp up. But that is a infamous hand sign, and they call that, when they say throw up them rakes, you throwing up the pitchfork.
Okay. What are some common identifiers for gangster disciples?
So again, we're going back to the Star of David, and remember, it's not, the Star of David is for David Barksdale. This is a common, very common sign that they like to use. And then, of course, the pitchforks because of the folk nation, or the trident. You have the heart with the wings. This is a common symbol. And you have the devil horns. They like to use the numbers, again, 6, and 6 is for the folk nation. You have 7 and you have 4.
And the 6, is that in reference to the 6-pointed star?
The 6-pointed star, as well as the 6 for the folk nation. People nation use the number 5. Folk nation use the number 6.
Right.
And so we're getting into the day that we saw the advertisement the day of the incident itself.
Okay, so right, so we're gonna now shift to the gang identifiers that we saw in this case. On the left-hand side, what are we looking at over there?
So on the left-hand side, you seeing he's saying happy 7/4 day. So 7/4, GD's like to claim that Independence Day, July the 4th, is their national day, 7/4, July the 4th. So that's why July the 4th is very, very important to them. You have a person wearing all black throwing up the forks. What they say, throwing up them forks, they throwing up the rake. Or we know the trident. In the back of this sweater, there's a 6-pointing star. Also, you see folk for the folk nation. And you see in the folk nation is their founding member of the Gangster Disciple, which is Larry Hoover. 1613L, 1613L is PML, and P being the 16th letter, M being the 13th letter, and 12th. It's Prince Minister Lord. This is just like a if somebody they gave somebody this, they calm down. This could be a title that someone get. So they can earn this title whether it's in the free world or they earn this title in prison, but it's their specific title.
Prince Minister Lord, is that reflective of the hierarchy or the structure that the Gangster Disciples hold?
Yes.
Okay. And so when you get a title like that, does that show status or?
It does show status and it does show strongly show your affiliation to that particular criminal street gang.
So where'd you get this image from on the left-hand side?
This image actually came from Mr. McCoy's Instagram on July the 4th.
All right.
So
Oh,
also from Mr. McCoy's Instagram, I'm able to see where he was once in prison and he actually, no surprise to anybody but me, he has a phone in prison. And so he's able to take pictures and he's also able to show his affiliation with these pictures. So of course he proudly had them on his Instagram, which I was able to get. And I started looking, especially when he's saying showing the 7/4 tattoo. He's in a picture with other individuals in prison. And they have to be Gangster Disciple. You see this guy throwing up the 6-pointed star, but he's doing it with his hands. And you see the 6-pointed star emojis at the bottom. And you also see Mr. McCoy, he's in the picture as well.
And did you present these photos to the detective Principe in the case file?
Yes,
And then those turned over to the state?
yes.
All right. And have you had an opportunity to look at those photos with the state, and are they in the same fashion as you saw them on the social media?
Yes, ma'am.
Your Honor, the state now moves to enter in State's Exhibit 400 to 402.
Objection.
Admitted.
All right. And is this a good time to point out some of the identifiers on Mr. McCoy? You want to do that at a different time?
We'll do that as time progresses.
Okay. All right. And were you able to point out some of the hand signs and symbols that we see in the prison photo to the right?
Yes. And like I said, the main one, like I said, these guys right here throwing up this like the star. This is how you make the star with your hands. Usually they'll just throw up this. It can either be 7 or for loyalty. And of
And-
course, I'm sorry.
I'm sorry, that was my fault. Go ahead.
And of course, we have the 5-point star, the 6-point star that he has 3 times at the bottom on the emoji.
All right. And what was the dates that these images was posted on social media?
You see May 31st, 2023, and both was in the 2023 range when it was posted, but it was posted on his highlight.
And is highlight a story that it maintains on your Instagram profile after the 24 hours?
Yes.
Okay.
Again, these are additional pictures that was on his Instagram. You have him displaying the 7-4. And then again, over here, he's displaying 7-4 again. Both pictures appear to have been taken in May. This one for sure, May 3rd, 2023.
All right. And what are these gang identifiers as it relates to Mr. McCoy?
So these are older pictures he had. Well, I can't say pictures in the highlight area showing where on separate years he paid homage to the GD Day, G Day, 7-4 Day. And then of course, I think this was 2021. I can't see because of the live, but since 2021, he on July the 4th, he was like happy G Day 7-4 till the world blow G6 GB the reason. And sometimes they'll use the 6 for the B. But as you can see, they're gonna use that 6.
And just to clarify the record, I know it's an obstruction on that screen. The date posted is July 4th, 2023 on the black one. Now, what about the blue side?
So the blue side, this was posted July the 4th, 2018. It's a happy 7-4 day to all my Larry, guys, PML, and NEL.
Now, did we talk about what NEL is?
NEL is another word for I can't remember right now, but I know L is the loyalty for loyalty.
Okay. Okay. And so he has been celebrating, according to his own social media, he's been celebrating 7-4 Day or GD Day since 2018.
Yes, ma'am.
Okay. All right. And what are we seeing here?
This is actually his Instagram, just to show you guys, like this was his Instagram before he wiped it, before we could ever get everything. And sometimes when they know they're on the run or whatever, if I can get the Instagram first, I like to do like a little recording just to show you guys this Instagram did exist. And I have to show it to Instagram too, because once they wipe it, sometimes they can't find this particular account. So I like to take a picture, record, do whatever I need to do to prove like this account did exist. You gotta unmute it.
Did this video have sound to it, Detective Manson?
Yes, ma'am.
Okay. All right. So can we pause it and unshare and then? Okay. 1 second.
Hey, card, no cut, man. Happy G-Day to my motherfucking gangsters and my sisters, man. We out there with Southside shit. Yo, shit to the night, man. We lit all night. Yo.
Now in that recording we just heard, did he say Happy G Day?
He's saying happy G-Day to all my brothers and sisters.
All right. Now is G Day and GD Day synonymous?
They're two are the same thing. It's gangster disciple. He just abbreviate gangster disciple GD. He let you know happy GD day.
All right. And what are you showing the jury in this clip?
In this clip, it's actually a video.
Mm-hmm.
So in this clip, you're gonna see him playing around with one of the decedents, and he's also gonna repeat. He's going to tell you like on GD, I spared you.
And what does that mean?
On gangster disciple, he's claiming that he's a gangster disciple. He's showing you he's a gangster disciple. He's his self admission. Everything is saying on GD, I spared you.
And what does that whole statement mean? I understand the GD part. On GD, I spared you.
He spared him from doing something dangerous or doing something to him or committing an offense to him.
Dippy! 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 Stop being drunk. Little ass nigga! Little ass nigga! Somebody, nigga! I'm not going nowhere, nigga! The biggest! This shit comes I'm not going nowhere, nigga! You out there standing there, what? Look on the hill! You small! Stop playing with me, this shit! You wanna go in there now, nigga? You wanna go in there now, nigga?
Take them off, like I told you the first time.
Fuck DJ, these
Take
ain't
them
nothing
out
but
like
some shoes, nigga.
Take them out like
These ain't nothing but some shoes, nigga.
Let go.
These ain't nothing but some shoes, nigga.
Now we playing. We playing.
You know what I mean? Man. You know what he need, nigga. You know what he need, nigga.
No, he's sparing you. Come on the mall. That's how GD he's sparing you.
A little bit of ass twist. He's sparing you. He mad.
I ain't gonna count. Everything we see, he's sparing you. I'm sold. I'm not there.
So the most significant, so of course, I'm gonna slow it down. Initially, we had to take out warrants and get fugitive involved because we could not find him. He remained on the run, meaning McCoy remained a fugitive of justice until 2024.
Unshare. At this time, the state presents the witness with what has been previously marked as 403 through 440. If you could just look through those briefly. Have you had an opportunity to look at the photos?
Yes, ma'am.
Do you recognize him?
Yes, ma'am.
How do you recognize him?
These are photos that I had my crime scene take at the jail. I end up getting a search warrant for his tattoos.
Okay. All right. And do you recall around about the date of you taking these photos?
I know it had to be early December because
Okay.
he was arrested in November
Right. And that's 2024?
2024.
Okay. Um, and have they been altered in any way?
No, ma'am.
All right. At this time, the state moves to enter in States Exhibit 403 to 440.
Protection.
Permission to publish. All right. Let's start with 403. Now, were you present as the crime scene technician is taking these photos?
Yes.
And are you directing the crime scene technician on what to take?
Kind of, sorta.
Okay.
She's pretty good, so I don't have to do much directing, but I am present because I am the individual that filed the warrant.
Right. And don't you also know what to look for?
Yes.
All right. Now, is it fair to say that Mr. McCoy is tattooed from head to toe?
Yes, ma'am.
All right. And are there a lot of tattoos throughout his body?
Yes, he even directed us as to where to take the pictures. He was like, "You want me to take off my jumpsuit?" I was like, "Sure. We're gonna get pictures, might as well get pictures of everything."
And how would you describe his demeanor during this time?
He was very arrogant.
All right. So States Exhibit 403. We're seeing an overall photograph of Mr. McCoy.
Yes.
Okay. And now States Exhibit 404. Tell me what we're looking at in this photo.
We're looking at basically chest up, just looking at a lot of the tattoos. He has, the cancer symbol because of his birthday being in July, day after 4th of July. Um, Basically a lot of personal tattooing, you know, kind of like on the level of little bit demonic. You have the skulls and the demons.
States Exhibit 405.
It's just a Photoshop of his face. She
Okay.
likes to get face shots and then work our way down to the other tattoos.
All right. And 406. Is this a close-up of his torso?
It's a close-up of the torso.
Is there any specific identifiers that you would like to point out to the jury
Not really.
here? Okay. State's Exhibit 407. And what are we looking at in this photo?
In this photo, we looking at a lot of stars. And if you pay attention to the stars, they are mainly 6-pointing stars and not 5-pointing stars. So it's just little things that you notice on the tattooing.
State's Exhibit 408. Is that same arm at a different angle?
Yes, it's the same arm at a different angle.
Okay. State's Exhibit 409.
It's
Is this the left arm?
yes, that's gonna be the left arm. Only thing significant, a lot of times gang members like the laugh now, cry later mask. Why? It's just, I guess, show, you know.
All right. State's Exhibit 410. Is that a closer shot of the left arm?
Yes, the angry bird and the laugh mask.
Okay. State's Exhibit 411.
It's gonna be his back tattoo.
Okay. And we're gonna get closer on that. State's Exhibit 412. Okay.
This is a more in-depth picture of the back tattoo. And this is where the significant comes with the identifiers. You see the imprint of the bandana. You see the 7-4. You see the 6-pointed star, the wings, the devil, the horns, and him holding the trident.
And in preparation for trial, when you were looking at this tattoo, did you would you use this tattoo or this photo to show identifiers in the all the identifiers in one place?
Yes, this was the main tattoo that I would look at.
State's Exhibit 413. And is that 413 is a close-up of State's Exhibit 412?
Yes, it's just a closer.
Okay, State's Exhibit 414. What are we looking at here?
It's just the other side of the arm, and the lighting and the complexion is just not very good. So that is, yeah, we took the pictures, but this is not one of the photos I would just say that I
Okay.
see identifiers.
Okay, State's Exhibit 15. What about this one?
It's not a good photo where
Okay.
you would show identifiers.
Okay, State's Exhibit 416. We have more lighting here, but it appears to be blurry.
Yes.
State's Exhibit 17, 417. I believe we could. Can you see the identifiers on this, in this photo?
Not really.
Okay. State's Exhibit 418.
That's a little bit better. It's that right arm. Of course, you have the hockey mask for Jason, being, Friday the 13th, and the hush signal, like we don't tell. Snitching is forbidden.
Is there a consequence according to the code of conduct with gangster disciples? Is there a consequence for snitching?
Yes, it's a direct violation of the code, and that violation can force you out of the game, or you can be violated to death.
Okay. 419.
I don't see any identifiers that stick right out.
Okay. 420.
So on his hand, he does have a dice. And like I said, because of the lighting, it's just not the best. But there is a dice, and on that dice, it's a 6. There's the dice count 6.
421. Is that a better?
It's just a more in-depth, but you'll kind of see the dice at the top.
State's Exhibit 422.
Nothing of significance.
State's Exhibit 423.
On his legs, there is a lot going on, but honestly, because of the lighting and his complexion, I couldn't find identifiers like that.
State's Exhibit 424. And 425. 426. 427. Any significance on the back of his legs?
Yeah, the NFL, the astronaut with the NFL. Never forget loyalty.
That was the NFL we were discussing earlier.
That was NEL.
NEL. Okay, sorry. All right, 428. That's blurry. 429.
And it's a closer picture
Of the same.
of 428.
Okay. 430.
You can see the NFL, but it's just a picture of an astronaut, and maybe that's the world, but it's still kind of dark.
431. There you go.
Okay, a little bit lighter. So you see the astronaut, the NFL.
And 432. 433.
You have the wording stepper coming down the leg.
And Ms. Detective Manson, if you could just project a little bit on State's Exhibit 433, what did you say?
He has the stepper. If you pay attention, it's STEPP going down his leg. And of course, on the other leg, let me see if I can use the pen. Stepper is going down this leg. And then you have bricks here. And bricks usually mean that they've served time in prison.
State's Exhibit 434. Okay, if you could do the undo twice. And that's just a closer view of the stepper's tattoo.
Yes.
435. Right, and that's the closest close up of that same tattoo. 436. And it's 436, a close up of the brick tattoo you just mentioned.
Yes.
Okay, 437. 438. 439. Now, let's talk about the end of your interaction with Mr. McCoy that day. Were you done after the last photo that I showed?
Yes, after the leg tattoos, we was done. So, I was like, well, we're done. And he was like, yeah, don't forget my eyelids. And I was like, you got tattoos on your eyelids? And he was like, yeah, don't forget my eyelids. So he ended up closing his eyes because I wouldn't have never thought to look at his eyelids. So he ended up closing his eyes and let us get the pictures of his eyelids that he have tattooed.
And were able to make out what's on the eyelids?
I know one of the eyelid has money, but I really wasn't able to make out the other one.
Okay, and let's go to the last one, 440. Just a little bit closer. Okay, and is that the right eyelid with the one with money?
Yes.
All right, and if you could unpublish that and then publish this slide right here. All right, Okay, so now let's talk about all the aspects of a gang case put together as it relates to this case. Please explain to the jury the significance of this slide.
Yeah, so we go at the end, we going back to the nexus. We going back to our iron triangle to show how we came up with this case is a gang related crime. We have the murders through the commission of enumerated offenses. We have murder. We have the offender who is a proud member of Gangsta Disciple. And we have the gang itself, Gangsta Disciple. So he's employed by, associated with the criminal street gang.
All right. Now, just put it exactly in the middle on top of iron triangle. Okay, now if we was to remove the top one with the murders and replace it with aggravated assault, would it still work?
Yes.
Okay, and how so?
Aggravated assault is a violent offense.
And it's one of the offenses enumerated under the statute?
Yes.
Okay, so if we remove murders and we put criminal damage to property at the top, do we still complete our iron triangle?
Yes, it is a enumerated offense.
Okay, meaning it's one of the offenses in the statute?
Yes.
All right. And if we were to remove murders and we put felony murder at the top, does that still complete your iron triangle?
Yes.
And is that also because it's an offense that is in the statute?
Yes.
Okay. Now, what if you remove the murders at the top and you add possession of a firearm during the commission of a felony?
Yes, it's a felony offense.
Okay. Not only is it a felony offense, is it a part of one of the offenses in the statute that will complete the nexus, or I'm sorry, complete your iron triangle?
Yes.
Okay. And then possession of a firearm by a convicted felon. Remove murders and put possession of a firearm by a convicted felon. Would the triangle still be complete?
Yes.
Okay. Now, what is subsection B of the gang statute?
Subsection B of the gang statute is the status, to maintain the status of the criminal street gang.
Right. And so what is required to prove that a crime was committed and to maintain or increase the status of the criminal street gang?
Can you repeat that?
What is required to prove that an act, a crime, was committed to maintain or increase your status in a criminal street gang?
The crime of any violent offense. We're dealing with murder, aggravated assault, any offense that would fall under the racketeering act.
Right, but how does these offenses go to maintain and increase Mr. McCoy's status in the gang?
It shows that he is not to be messed with. He's showing fear, intimidation. He holds his status very well. He knows that even to this day, feel as if no one would have came up and told what happened that day at that party.
And has it been effective? According to your participation in the investigation with Principe, were there witnesses that were scared to speak?
Yes, very, very much so. Some witnesses wouldn't even, it was a lot of people there that day. And it's a lot of people that could have came here and told, but in the state of Georgia, we don't have a witness protection program. So people that told, they came,
And
based
so Manson,
upon
I'm
their
gonna stop you there. So just the way it was, you understand based on the way it was committed and the people not willing to come forward, that he was effective in instilling that fear?
Yes.
Okay. How about the way it was committed? Like out in the open in front of people?
Yes, and that's part of the nexus. He made sure to reinforce what GDs are capable of doing.
Now, you've had, encountered Mr. McCoy when you took those photos and then also on his social media. Is that correct?
Yes, ma'am.
And were you able to recognize him if you were to see him today?
Yes, ma'am.
All right, well, I would ask you to take a look around the courtroom and identify a person if you see Mr. McCoy in the courtroom.
He will be sitting over to my left, directly in front of me. At the table, he has on a light blue shirt. His hair is a little bit shorter than last time, what I'm used to, what I seen. And he's a dark complected black male.
All right. Let the record reflect that Detective Manson has just identified the defendant, Anthony McCoy. Now, Your Honor, at this time, the state moves to enter in State's Exhibit 500 and 501. 500 being the certified conviction of Anthony McCoy. This is criminal action number 2018 CR 00216 for the offense of purchase, possession, and purchase and possession of a controlled substance, which is a felony, possession of a weapon during a crime, fleeing from a police officer, obstruction of an officer. And this was in front of Judge Robert L. Mack in the Clayton County Superior Court. And it was filed on January 26, 2018. It's a felony conviction.
No, Your Honor. All right, and as of admitted, Mr. Jury, I want to instruct you that these two exhibits are being admitted for the limited purpose of establishing the element, if they do, in counts 16 and 17 of a prior felony offense. And it'd be considered for you for that sole purpose and not for any others at this time.
And also State's Exhibit 501, the state moves to, it's a certified conviction of 2020 CR 00456 with the conviction of possession of cocaine with the intent to distribute, a felony, and possession of methamphetamine with the intent to distribute, which is a felony offense, in front of Superior Court Judge Robert L. Mack in Clayton County filed on September the 15th, 2021.
All right, that already having been admitted and my same limiting instruction applies.
No further questions.
Cross-examination.
Thank you. Hi, Detective Manson. Good to see you again.
Hello, how are you, sir?
Good, thank you. So, let me see if I understand, how this fits into your triangle that you described. On one side, you have a gang. This case, Gangster Disciples. Is that what you're saying?
At the bottom half, you have the.
Well, let me just ask you,
Okay.
okay? You're welcome to elaborate. Let me ask you this. On one side, you have crimes that have been alleged, right? And they could have been any of those hypothetically. You're an expert. You've been qualified as an expert, so you can answer hypothetical questions. So hypothetically, it could have been any of those crimes or any crime that's codified in the state of Georgia, correct?
That falls under the Racketeering Act.
Okay, and that would be a violent crime, correct?
Not necessarily a violent crime.
Okay. It could be a lot of different kinds of crimes.
Yes, sir.
Okay. On one side, the existence of a gang on the other, and on the bottom, the offender, and the offender's alleged involvement with the gang, right?
Yes,
In this case, you would allege that my client is involved with gangster disciples, correct?
correct.
Okay. But what that, tell me if this isn't correct, though, what that leaves out is that nothing that my client's alleged to have done, as serious as the charges are, is in furtherance of gang activity in any way, is it?
Yes, the nexus shows that it was in furtherance. He did it in front of individuals that he knew that his status would be recognized in the gang.
How does the gang benefit from that, though? How could it be in furtherance of gang activity? How would the gang?
He's maintaining his status.
Well, but you testified that the gang act itself is, and a crime under the gang act would be in furtherance of a criminal enterprise, correct?
That was one of the bulletins
Okay,
as to the nexus. Yes.
okay. But how does committing violent crimes against fellow gang members in furtherance of a criminal gang activity or a criminal gang?
I'm confused about your question. You saying that the decedents were gang members?
Well, I'm saying that you've got an event. You talked about, what it stood for. It was GD Day, right? I mean, you testified to that, correct?
I said he was there to celebrate GD Day.
You don't think the other folks were?
I can't say what the other people were. He self-admitted that he was there to celebrate GD Day.
Okay. So again, my question is, though, how does committing a serious violent act, how would committing a serious violent act be in furtherance of gang activity? How would the gang benefit from that?
He's maintaining his status in the gang so that what you're looking at is just one of the bulletin to the nexus, to show nexus.
Okay. Gangs are put together in a way, are they not, in order to somehow profit from being a gang, being all having a common purpose somehow, right?
Some of them use criminal activity to profit, yes.
I mean, they may rob a Brinks truck or something, right?
Yes, but again, that's just one of the ways that you show nexus.
So do you remember your hierarchy? You have governor, you have chairman, governors, I think board of directors. I mean, there's a real hierarchy to the gangs that you're describing, at least the several that you mentioned, gangster disciples, Crips, Bloods.
No, I purposely described just gangster disciple hierarchy because that's what this case is about, a gangster disciple member.
Okay, I understand that. But would you say that the other gangs also have a hierarchy?
Some gangs do have a hierarchy, yes.
But you're testifying that that Gangster Disciples has this particular hierarchy, the one that you described earlier, right?
Yes, sir.
All right. So in order to do that, in order to then distribute the proceeds of the gang activity, which is the purpose of the hierarchy, correct?
Yes, sir.
Where are the proceeds?
Again, the nexus isn't just about getting proceeds. You can also have a nexus that shows that he's maintaining his status in the gang. In this particular case, it's not about proceeds. It's about him maintaining his status in the gang.
Would the gang endorse that?
Can you repeat that?
Would the gang endorse that?
Would the gang endorse that?
Yes. Would the hierarchy of the gang endorse such a concept?
I'm confused.
Wouldn't that be an extracurricular activity outside of the gang? If such a thing exists, if such a thing happened?
I don't quite understand the question.
Well, if there's nothing for the chairman and then the governors, I'm sorry, it was, chairman, the governors, I believe you said, and then the board of directors, if there was nothing for them to either distribute or to punish or rule on, wouldn't any activity that left none of that for the gang hierarchy to deal with, wouldn't that activity by its very nature be something that was extracurricular outside of the gang activity, outside the gang, the very purpose of the gang?
I don't quite understand your question. Because he's doing it to maintain his status to show how bad he is and showing, you don't disrespect against a disciple. Um, I don't see why a chairman would be upset with him for maintaining his status.
You don't.
No, I don't.
Wouldn't that be in defiance of the self-perpetuation of the gang, though?
Can you elaborate?
The maintenance of the gang, wouldn't somehow that just be in defiance of the very maintenance of the gang? What if everyone exacted some kind of violent acts on others to call the member into the alleged member into disrepute? Wouldn't that make the whole concept of the gang fall into disrepute also?
And I don't quite understand what you're saying
Well,
because
I may not have, if you don't, you don't, but I may not have many other questions for you, but you do agree that a gang in itself is a criminal enterprise, correct?
so let me just inform. Being in a criminal street gang is not illegal. Being in a criminal street gang is not illegal. It's the criminal activity that one involved themselves that makes it illegal.
And you testified to that when you were asked by the district attorney. That's exactly, I believe, close to exactly what you said. But in doing so, you're not doing it for the gang, are you? You're not doing it as part of your membership in the gang, are you?
Doing what?
Whatever the
Joining?
criminal activity is, whatever the violence is, whatever the stealing or the theft or whatever it is that constitutes the criminal activity, you're not doing that to benefit the gang in any way, are you?
In this case, he is because he's maintaining status. Is what they say is the numbers are in, it's they trying to maintain status. They need the numbers.
All right. In a gathering like the one that you're aware of, happened on July 4th and 24, you talked about how there's this umbrella, I guess, where Crips might fit and Bloods might fit. Where the gangster disciples are concerned, who fits under that umbrella?
The folk nation, under the folk nation, you have Crips, gangster disciples.
Are those like subsidiaries? Are those like subsidiaries?
They're
of
their
gangs?
own entity. They're their own gangs.
But is there some coalescence? Do they participate with each other's activities?
Not necessarily.
Are they necessarily at war with one another?
No, not necessarily. It all depends on where you're. So it all depends on who's your adversary. I can't say that every blood is gonna hate a Crip because you have Crips and Bloods that are affiliated. Again, that's how we get hybrid gangs. That's how we get neighborhoods. You have gangster disciples that do business with Bloods, especially when it comes to making money. So I can't say that every gang is gonna, hate one another. It all depends on what started that beef.
Well, Detective Manson, would you agree that's very complicated? Would
What
you
is
agree that it's
what
very
is very
complicated,
what is very
what we're
complicated?
talking about right now?
Sometimes it don't have to be. That's why you have experts and people that make sure they look at social media and pay attention. It may be complex to an individual that don't know games,
Would you
but
agree? Is that-
it's not complex to me,
Would you-
no.
Okay. All right, very well. I think that's all I have. Thank you.
Any redirect?
Yes. Detective Manson, on cross, defense attorney asked, that any crime can be criminal street gang activity. Is that true?
No,
Name a crime that, a crime that cannot be that's not codified as criminal street gang activity.
crimes that aren't, some misdemeanor crimes, a traffic violation is not considered a criminal street gang. So you have crimes that are not criminal street gang that falls under this category.
The crimes that are codified or placed in the statute, are these the type of crimes that are known to be committed by criminal street gang members?
Yes,
Now, you stated on cross-examination, it's not a crime to be a gang member, right?
correct, it's not.
Okay. Is it a crime to celebrate Founder's Day, GD Day?
No, it's not a crime.
Okay. Is it a crime to host a whole pool party in celebration of GD Day?
No, it's not.
Okay. So at what point does Mr. McCoy's behavior becomes criminal street gang activity?
When he pulls the trigger and take the lives of two individuals.
And also when he damages property?
Correct,
Is it also when he carries a firearm?
correct.
Let's not use any other words but Anthony McCoy's words, okay? So on Anthony McCoy's social media, did you see the social media post that said they let GDs in the door,
Yes, ma'am.
right? And so what did that mean to you?
They let members of Gangster Disciples in the door. They let them, invited them to the pool party,
And they're gonna show up.
and they're there in droves.
What about the sparing you on GD in front of a group of people where you're being little manned or embarrassed? Sparing you on GD in front of that crowd. His words. Does that show a a motive to then commit the crime that we then have?
Yes, he's proudly displaying that he's a member of GD. He's
Okay.
gonna spare him.
And saying that loudly in front of a group of people, does that assist in the maintain and increase status?
Yes, ma'am, it does.
And using Mr. McCoy's words only, stating that Mr. Leonard tried him in front of some bitches. Is that reflective of the slide that you put up of retaliation or insult, disrespect?
Yes,
Okay. And does that go towards the motive of the criminal street gang aspect of this case?
yes.
How about antagonizing a witness while they're on the stand by laughing out loud in court? What does that say?
It's showing you, he's showing like he want to intimidate people. He want people to be fear of GDs. He wants to show y'all that GDs are powerful.
How about laughing in open court as you're showing his tattoos?
It's just another sign of arrogance, letting you know that I'm a proud member, and it's very little that anybody can do about it.
No further questions.
Recross.
No question, Shelley.
You can sit down. Thank you. Sammy, call us next witness.
state.
All right. All right, members of the jury, I've got some work we've got to do outside of your presence. That'll take at least, I think, 20, 30 minutes. We'll be back with you as soon as we can. Thank you. What's that? Thank you, Deputy Scott. Any motions on the part of the defense?
Judge, yes, but it'll be very brief. Judge, counts 1 and 2 of the indictment are violations of the Criminal Street Gang Terrorism Prevention Act, OCGA 1615 4B and 4A. Coming on the heels of the last witness, I will just state for the court that the state, I do not believe, has presented enough evidence to send those counts to the jury. I think the witness testified in circles to prove a triangle. I'm not trying to be funny there. It's just that we kept getting back to the fact that somehow killing fellow gang members was in furtherance of the act of a gang and the criminal enterprise when it could not possibly be. It'd be self-defeating. And that's what he's alleged to have done. He's alleged to have shot 2 people that are probably affiliated with the same gang. Which, if anything, would just subject him to more problems, not further the gang's activities or their goals or apprehensions or anything, Judge. For that reason, I'd ask the court to direct a verdict of not guilty on counts 1 and 2 of the indictment.
With the primary focus of yours being on the nexus element.
Yes, Judge.
All right. Ms. Green?
Your Honor, I believe the defense stated not enough evidence. The standard is for the state to show some evidence to support these claims. The witness absolutely testified. I believe that we stayed on the nexus portion of her testimony between the state and defense for a lengthy amount of time. The witness continued to repeat. I understand there was a breakdown in communication at some point, but the witness continued to repeat how the nexus is applied and formed on each predicate offense that's in the indictment and the offenses that are in count 1 and count 2. We went through them one by one: murder, felony murder, aggravated assault with a deadly weapon, criminal damage to property, and possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. She went through the different aspects of the statute, putting it in an iron triangle as a demonstrative to the jury. In addition, she went into subsection B, which is to maintain and increase the status of his membership in that gang. She established that he isn't a gang. She established that there is a gang that exists and that he is a member of that gang. And then she also established that the reason or the motive in committing those acts and what was the prequel to those acts and how that is significant in gang culture. I do believe there is sufficient evidence to send these charges back with the jury.
2 follow-up questions here, focusing on the nexus. There is a distinction in the elements between A and B, the participation and the status, and the pattern charge and our case law about the nexus seems to focus exclusively on the A violation, the participation violation. Is the nexus requirement present and has it been applied to the B violation, to your understanding?
That he committed the crimes, with
Wait,
the,
I
I'm
mean,
sorry.
essentially,
Yes.
how is the nexus applied in a B violation? If I'm making
I guess I'm
sense
not
here.
understanding. Can you help me?
So the nexus requirement comes from the word through, right?
Mhm.
But through as a word does not appear in a B violation. The word through is not there. So how does the nexus requirement exist in a B violation?
So, I'm sorry, Judge, I'm not completely I'm gonna hopefully answer your question by establishing
Well,
what
we're
it
gonna have to get
takes
to this at some point anyway, very soon here with the
Right.
charge conference. But I guess the question I have for you is times, and I think this was defense counsel's point, was that the detectives seem to be saying, as long as it's one of those offenses that is identified as criminal street gang activity, it's at the top of that triangle, we check that box. And so would it be your position that as long as a murder is charged and a gang member commits a murder, that that nexus is established?
No, you have to show more. You have to show more for the connection. I'm sorry, I understand what you're saying now. You have to show more to the connection from the crime um, and the person and the gang. And I believe that this witness went into how the crime was committed and what event the crime was committed, all the leading up aspects before the crime was committed. And I believe it shows that it is in furtherance of criminal street gang activity. And then the second one, and the display of the way it occurred in front of the witnesses, the way it occurred, and even his own words to highlight the prequel of it would show the maintaining the status that is required for B. Sorry, Judge.
All right, no, not at all. And I think I'm also, I don't have, these are some things we're going to get into in the charge conference as well. But for the purposes of the directed verdict motion, considering everything and all the evidence presented in the light most favorable to the state, I do believe that the elements for both violations as charged of the Criminal Street Gang Act should survive a directed verdict and reach the jury. So the motion is denied as to those first two counts.
Thank you, Your Honor.
And we would turn to the defense for if you anticipate presenting any evidence. There weren't any witnesses on the defense witness list. Would you be calling any other witnesses besides Mr. McCoy potentially?
Judge, I would appreciate the court giving the admonition to my client, but we've discussed it, and I believe his nation is that he would not want to testify on his own behalf.
All right, I do plan to go through with that with him, but I just wanted to make sure and see if there's anything else the defense planned to present, and if not, the expectation would be when the jury comes back in, the defense would also be resting.
That's correct, Judge.
All right. So, Mr. McCoy, we have to go through a few questions with you just to make sure you we're clear on exactly your understanding of your rights at this point in the trial, which is that do you understand you have a right to testify, and if you want to testify, no one can prevent you from doing so. All right. And do you understand that no one can make or compel you to testify? That is, you have a right not to testify if you don't want to. You understand that it's not your lawyer, but you personally, you are the one who decides whether you will testify or not. And if you do not testify, I'm going to instruct the jury that they can't hold that against you in any way. Do you understand that? But if you do testify, you'd get examined by your lawyer and you get cross-examined by the state. Do you understand that? Do you need any more time to think about whether you want to testify? All right. And do you personally want to testify or not? All right. Well, I find that the defendant has decided not to testify with a complete understanding of his rights. And so at this point, we would consider the evidence closed in this case, and we would move into our charge conference. And so as I provided the parties over the lunch break with a tentative rough draft, I'll have that marked as Court's Exhibit 1. That can be our working copy as we go through it. This already has some charges removed, that were in the initial party's requests, I'll highlight those and kind of as I run through it. But I think I'll just summarize as I go through, but either party can weigh in and just jump in as they have something they want to address, rather than me go charge by charge, requiring everyone to agree, say no objection, or however not to go through it. I just think this would be more efficient. So again, just feel free to make yourself heard if you want to address something or preserve anything. So I begin on page 1. This is of our 11-page rough draft. These are more of our preliminary counts. And again, I'll note that we're going to give them a copy of the finalized version of this charge. These are all pattern charges. I have it struck in the presumption of innocence, the part about affirmative defenses. And otherwise, it's a pattern charge, so I would give that as indicated here. On page 2, I was inclined to strike grave suspicion as it being duplicative of the previous instruction on what is reasonable doubt, and after reviewing the case law that addresses grave suspicion. I was going to strike the parenthetical on judicial notice, as there's nothing I've taken judicial notice of, as well as stipulations, because we haven't had any stipulations. I move on to page 3. Everything's the pattern charge there, really nothing to tailor. On page 4, I have some line edits on limiting instructions and defendant's choice not to testify, tailored to what has come out. Really, I don't have anything to highlight there. I get to 5. We've got pattern charges on identification, intent, and definition of a crime. And let me just pause right there, because after that, on page 6, we're going to get to criminal gang activity, and I have a lot more to talk about there. But up to this point, anyone have anything to add?
No, Your Honor.
All right. I'll also note, leading up to this point, there were a lot of requests. I think these were all primarily from the state about conspiracy, knowledge, party to a crime, everything that would, I think, be more applicable if there was evidence that it was more than one individual who committed this offense. So I've eliminated all of those. But turning to criminal gang activity, the pattern charge, this goes over the 2 pages. Using the pattern charge as the template, I have that laid out here. I have it mirroring the elements that we see in our case law. But I think what I was kind of inartfully trying to explore with Ms. Green here in the directed verdict motion was that this pattern charge is really only addressing paragraph A and a paragraph A violation. Certainly there are things that are roll over, but I would think a paragraph B violation actually has different elements. They're a little subtle, but there are different elements, and I don't think that's reflected in this pattern charge. So I'll just put this out there, how I have made some line edits up here since printing this. The first would be, in the first sentence, I was just going to go ahead and strike that offense is defined as follows. I just don't think that's necessary at all. And then getting to the second paragraph, where right now it begins, a person commits the offense of violation. I was going to instead begin that with, as alleged in count 1, comma, a person commits the offense of violation of the Street Gang Terrorism Act. And then have it read as follows. In the third paragraph, I would change it to, in order to prove this violation, so that everything that follows is kind of within the umbrella of count 1.
Your Honor, is that on our page
No,
6?
no. This is handwritten on here that I'm just trying to describe to you,
Okay.
now having thought about this here most recently, how I think this needs to be further tailored to show the distinction between count 1 and count 2. So if I need to repeat anything, feel free to ask, but so far, and I'm going to give you another copy of this when it's all done.
Okay.
But as we're editing this here in real time, I wanted to share this with you. So the main thing being in paragraph 2, it's as alleged in count 1, comma, a person commits the offense of violation of criminal street gang. And then we go through everything that's here on page 6. I was also now thinking that the very final thing on page 6, it says for the purposes basically further defining participate. I don't really think that's at issue here. I think that would be more at issue if this was a conspiracy or party to a crime episode theory. So I was going to strike that entirely. I don't think anyone's asking for a further definition of participate. And then on the page 7, as it relates to the nexus phrase, it's the paragraph beginning with lastly, defining what it means for the nexus. And the final phrase of that pattern charge is meaning proof that the crime committed was the sort of crime that the gang does. And this was recently, just looking at it here, challenged and explored a little bit further in a case earlier this year of Jackson versus the state, with the site being 321 Georgia 659. And from that case, they directly address a challenge to this phraseology, meaning proof that the crime committed was the sort of crime that the gang does. And I think they place some context on that I would like to include, which is after that I would say, comma, not simply a crime that a member of the gang may have committed in the past. And so I think that is placing that sentence in a better context, saying that just because it's murder, that's not going to be enough by itself. It has to be a crime that a member of the gang does, that the gang does, not just a single member of the gang has done. That was how it was challenged in Jackson, and that's the language the Supreme Court put in there to clarify what that phrase means. So I'll just repeat that. Where the pattern charge says, meaning proof that the crime committed was the sort of crime that the gang does, comma, not simply a crime that a member of the gang may have committed in the past.
Your Honor, and I guess because there was no evidence, we haven't talked about murders committed by the gang in the past. And so as you have been doing throughout the whole charge, is removing things that are not relevant to our case. We haven't mentioned anything as such. I understand the clarity just in case a jury was confused, and that may make sense in a case where I'm bringing up murders that the gang has committed in the past or that the defendant has committed in the past. But to add it in when it hasn't been a factor at trial at any point, I think it kind of can cause confusion. Because this is the only murder I'm talking about. I haven't mentioned.
Well, and I just use murder because that's the headline charge. It
Right.
relates to any crimes, and it's placing more context in what this nexus requirement means, which has been litigated extensively the last 10 years, and is going to, I think, place it in context. It's not just that it has to be a account that's listed as a criminal street gang activity. It has to be, even in isolation, it has to be the sort of crime that the gang does as a entity. So I would say take a look at the Jackson case, and to me that seems like language that is important as it's an accurate statement of the law. Any other, you want to be heard on that, Mr. Cowan?
Judge, I have no objection to what the court's suggesting.
And then, as I indicated, the other thing to add in here, which is a non-pattern charge, would be to throw in the distinction about the difference between count 1 and count 2. So at the very end of this, it would be almost a mirror image of the second paragraph, but instead we would say, as alleged in count 2, a person commits a violation of the Street Gang Terrorism Prevention Act when that person, while in a criminal street gang, participates, and I'm using the exact same language as that second paragraph, with the addition just being with the intent to increase or maintain his status in the criminal street gang. So it's just literally just quoting the statute. But that is a technically, I think, a different element than
Right.
the first
Is
one.
the court gonna repeat everything all over again
No.
and just change that? Or
No.
just say, okay, All right.
And so I could add in a sentence as well as, or if you, to the extent you even think it's necessary, but the the previous instructions I've given you as to these definitions apply to count two as well. If you even think that's necessary. I mean, I'm still using the same criminal street gang terminology and everything else as well.
Yeah, everything's the same except the nexus on each one is different. Okay, I guess I have to.
Well, and again, the nexus, I'm going to have to do some more research on that because I'm a little unclear at this point precisely how it applies to a B violation.
You are unclear on how these charges apply to a B violation? I'm sorry.
No, that, and I think I just need to look. I'll just leave it at that. I just need to look a little closer at some of the case law. But for this point, that's everything I have right now. Does anyone else want to add anything or say anything about this? Or any other suggestions or additions or clarifications, anything at all?
Well, can I hold mine until I get the final draft?
That's
Judge?
fine.
Okay, I'm sorry. I just need to visually see it.
Yeah, I mean, that would help. Okay, then I'll move on to page 8 and 9. These are defendant's request for voluntary manslaughter. Mr. Count, is that still a request for the defense?
Judge.
All right, well, I'm gonna need you to lay out the evidence you think supports that. And
Judge, even though words alone cannot provoke one to commit voluntary manslaughter, the video that's shown over and over in this case has to do with, well, there's two things. Video is shown with Mr. Houston, where Mr. Houston has my client, or my client has him, and they're back and forth, but there's a lot of citing language in his face, in my client's face. There is some physical contact that they have together. There's another gentleman who puts his hands on my client and drags him or leads him down to the lake. And in the case of the first homicide with Mr. Leonard, there's witness testimony that there was an argument. Even Mr. Gay, May, I believe, testified that there was an argument. Several people used the term argument. And then they heard gunshots. So I mean, that's witness testimony. So based on that alone, I would think that the argument and then the gunshots, close proximity to that might indicate a threat sufficient for that charge, given that nobody claims to have seen it.
all right, Ms. Green.
Yes, Your Honor. I thought that we addressed this at the conference, at the bench the other day, that that we would not be moving forward on the manslaughter, the voluntary manslaughter.
Involuntary. He said he wasn't moving forward on involuntary manslaughter.
Your Honor, I don't believe there has been sufficient evidence to establish the provocation that is needed to give a voluntary manslaughter charge. I believe in both situations, if you want to, starting with Mr. Leonard, the evidence that was presented by the state, several witnesses stating that not only did Mr. Leonard was not armed, Mr. Leonard was walking away. His back was turned. There was words exchanged. Mere words is not sufficient. And he was walking away with Rolo Dukes when he was shot in the head. And then as far as Joshua Houston in the vehicle, there has been absolutely no facts presented or evidence at trial to support provocation in that instance. While there were firearms in the vehicle, there was no evidence that even Mr. Houston had a firearm, shot a firearm, no casings in the vehicle, but simply given Mr. McCoy a ride, offering to give him a ride when he was shot seated in the vehicle unarmed. Your Honor, I would ask the court to not give that charge. It does not meet the statute.
Ms. Green, if you could, to the best you can, focusing on the events that preceded the shooting of Mr. Leonard, summarize, as you recall, the witnesses who claimed to see or be near the shooting, just what preceded it or what interactions were seen between the two?
Right. For Mr. Leonard specifically, I believe this is where there was testimony presented that, and excuse my language, I've been cursing all trial, I apologize. Mr. McCoy confronted Mr. Leonard for trying him in front of some bitches. And I believe Jametta Taylor, stated that right prior to him addressing, Mr. Leonard, he was, he was, aggressive. He was antagonizing everybody around the party. He was even trying to engage with her, and she attempted to calm him down. However, he and multiple witnesses stated he was elevated. He was hyped. He was aggressive. And then he goes to approach Corey Leonard where he is with Rolo Dukes. They ensue in a conversation shortly after Jametta Taylor said, "You need to talk that out with him." And then he pursues Corey Leonard. The conversation gets heated about disrespecting him in front of women. Rolo Dukes also testified, or his statement that was provided to officers was that him and Corey Leonard walked away, was walking away when he was shot from behind. So that's the evidence that I recall the witnesses stating right prior to that shooting.
Let's
Jametta
get
Taylor,
real specific. Which
Okay.
witness or witnesses said that Mr. Leonard is walking away when the shots are fired?
Rolo Dukes,
All right.
Rolo Dukes, and I mean I mean you can.
This is from the
say-
video, right? You're saying from the body cam, or there's also his in-court testimony?
Can't remember what part he was consistent because there was a lot of inconsistencies. So it was I believe it was the body camera footage where he said they turned away and that's when he heard the shot. But other than that, and then he turned around and said, "You just shot your brother." He's right there with him, within close range to the point where he can punch him. So he's standing right with Corey Leonard. But I mean, autopsy also shows that Mr. Leonard was shot from the back of the neck, and Colin, the doctor also confirmed that. Supporting Mr. Dukes in his statement that he was turning away.
Did anyone other than Mr. Dukes have a more proximate description?
I believe Mr. Rolo Dukes had the most proximate description because he was in close range to it happening. Uh,
Go ahead.
that was the closest person and the best description of what occurred.
Okay, but are there any contradictory versions in your assessment of the testimony?
There was not, let me think through my witnesses. No, there was not one witness that said he was facing him or aggressively approaching him. If the defense has one, I don't recall calling one. Everyone said either I didn't see the shooting, that was the majority of the witnesses, but I engaged with Mr. McCoy at some part of the day. But the people that actually saw the shoot, or the person that actually was close enough in the vicinity to understand what occurred, was Rolo Dukes. And I can look back and see if he said, because he said a lot of consistencies in court, and that might have been one of them, but I absolutely know he said it on body camera.
Okay, Mr. Cowan?
Judge, in the case of Mr. Leonard's shooting, I believe it was Mr. May who testified that he was upstairs, heard an argument and then gunshots. So the argument, and there was testimony from another witness, I know, that said something about an argument or an altercation. There was no physical altercation that I'm aware of. As far as Mr. Houston is concerned, we know about what's on the video. We know that that was a pretty animated, threatening sort of I don't think the threat has to involve physical violence. Very threatening kind of and menacing sort of approach from Mr. Houston earlier that day. In some of the things that he said to my client. The client didn't react in a particularly bad way, in spite of what the state's position was at the time. But that would be the provocation as to Mr. Houston. There is, as the court said yesterday, I think the standard is, the court believes the standard is any evidence. There was evidence that there was an argument between the first victim and then a shooting, folks hearing gunshots. Mr. May was one of those that heard the gunshots.
Did we ever get a estimate or idea of how much time passed between the video and the first shooting? And if so, how and where, when?
No, Your Honor. Several witnesses testified, I believe it was at least 2 or 3 witnesses, including Mr. May, that the sun was going down. Mr. Asbury stated that they arrived at the party around 4 or 5, so daylight time. I do not know at what point in that time period, but it was daylight. And then are you talking about the shooting of Mr. Leonard or Mr. Houston?
Still Mr. Leonard, the
Oh,
first
we're on,
shooting,
I'm sorry.
right?
I thought we were talking about the time between
No.
Houston. Okay. The time between what, the argument and the shooting
Right,
of Mr. Leonard?
right.
So it was at the time.
What we saw on video is, I think, what I was focusing on, because that's what counsel brought up.
Well,
Right,
that
there
would
was
have
no
been Mr.
I'm
Leonard.
sorry, that's why I'm confused. That's
Yeah.
Mr. Houston.
That is Mr. Houston.
Yes,
would
and
have
so
been-
that would be the time passed. I thought you wanted me to establish that there was time to cool off, or that's what I was.
That's what I'm
establishing.
exploring, yeah.
Oh, okay. So Mr. Houston, yes, I don't know the daytime hour that Mr. Houston and Mr. McCoy were in the video. That was daylight time. However, I do know the call came in, and I could see what time the sun goes down on that date if you would like me to, and use the latest time there. But I believe Mr. Houston is returning from somewhere else back to the property close to the 11:30 hour. So if I can look up the time to see, but I believe that would be sufficient to at least 3 hours from the sun going down in July to 11:30 at night, just putting it at the latest. And I think that's sufficient time to cool down from any provocation, if there was. But I believe in the video, it shows Mr. Houston more so jokingly and Mr. McCoy being the aggressor, bear hugging him from the back. But
Well, let me just start there. I think that the facts or the testimony presented by the state as to the shooting of Mr. Houston as he's in a car, I haven't heard and don't recall any evidence that contemporaneously to the shooting, there was any other kind of menacing. I think they're separated. And so I think the words alone doctrine would, as a matter of law, to prevent any kind of a voluntary manslaughter charge to be given as to that shooting. I mean, and it goes so far as our case law to say that just the fear that someone's going to pull a weapon or fighting, those aren't the types of provocation meriting voluntary manslaughter. Angry statements alone aren't enough. And so without any physical altercation or menacing at any point there, I don't think a voluntary manslaughter charge is appropriate. And then turning to the first shooting with Mr. Leonard, again, we've heard about an argument. We've heard about maybe some raised voices, but as to what may have actually occurred between them, the idea that this was enough provocation or to merit a voluntary manslaughter or anything else, I think would just at this point be is not based on any evidence. It would just be complete speculation. There's a complete absence of evidence of any provocation as to both of these. And so I think as a matter of law, voluntary manslaughter is inappropriate on both, for both malice murder charges. So it's preserved for the record. But I would not give then the pattern charges detailed on page 8 and 9. And as for the remainder of this packet, I didn't really have anything else to point out, except on page 10, I make a distinction between the possession of a firearm by a convicted felon counts and 16 and 17.
Page where?
This is on page 10. I essentially
Oh.
repeat the language just to show that there is a distinction between 16 and 17. And so with that, is there anything else other than that previously argued? We will consolidate this. We'll show you what we have. But anything else to talk about as it relates to the charges on behalf of the state?
No, Your Honor. I would just ask just a few, when I do get the charges from the court, that I have a few minutes to kind of update so my screen reflects whatever the court decided.
That's fine. What is the state planning to use its first opening as well as closing?
Yes.
All right. And any idea of, I know we're kind of
Kinda
ending
cut it
towards
close, right?
so how much time would you estimate to do your first close?
Your Honor, I'm gonna take my time, to be honest.
Fine.
So I intend on using my full hour and hour.
Okay. So I think the plan would be then is we will start closings at right around 4. State will just do their first opening, and then we'll pick back up with defense and state tomorrow morning at 9.
Okay.
All right.
Okay, so at 4 o'clock?
Thereabouts. We're getting you the charges. It shouldn't
Okay.
take more than a minute.
All right, thank you.
Mr. Cowan?
Judge, I'm not questioning the wisdom of the court, but I'm not so sure that I'm like the idea of bifurcating the closing. I was going to suggest that if we do that, the court let me go ahead and get my middle in, but that's not a perfect solution either, because then the state just has the floor the next day. So, I mean, I don't know that I have a objection grounded in law.
No, well, look, I mean, it's,
Tell the court that.
if we have them start fresh with both closings, we may not even make it through both of them until closer to 1 o'clock. And I don't know if that's going to be feasible for them as well.
Do you anticipate how long your closing would take?
Not near as long as yours.
Right. But
And just from experience, knowing that the state's first opening is just pretty much heavy on the law and technicalities, I don't know if
right.
that's really something that,
I'm not opposed to the defense. I do like to keep it all in one day. I wasn't gonna
Yeah.
say anything, but I'm not opposed to his position. But if my closing is 2 hours at max.
well,
And
that has to be.
right. I'm just saying, if it is, and his closing is 2 hours, that gets us to lunch. So that's the 9 to 1.
My closing won't be 2 hours.
I know, but I'm saying if he had to use his max, that gets us to 1 o'clock with lunch and then.
I know, but I
Expiration.
also still want to, I mean, there's no telling how long the jury will need and what they want to think about. So I think we need to get back,
Okay.
give that hour back to them. So I think state can use its first hour just to do their portion that usually just focuses on the law and the charges. You'll be able to be first out of the gate in the morning, and we'll go from there. All right. Okay, let's finalize these charges and we can have another look at them before we
Do I
get
have time to
started.
go outside for a minute, Judge?
Absolutely. We'll be off the record.
Okay.
Actually, let me go back on the record just for a moment. Were there any issues with the verdict form?
I don't believe there are, Judge. I looked at it. I don't see any.
1, 2.
Looks pretty perfunctory to me.
All right. And then also, before I forget, I would also ask the parties to be thinking about what exhibits go out and which ones won't, so that when we're done with closings tomorrow, you're not thinking of that for the first time. Now we're off the record.
Nice job.
Right. I'm good, I swear.
Okay. Would you help me by cleaning? Oh, perfect. Hot off the press. Just cleaning up my table. There are some things here that I was,
Those printed exhibits.
she needs her copy of everything. I thought I put everything.
I just don't want to give anything.
Yeah, if you see more than one copy, just make sure she has it. I'm not gonna let you take anything away that she doesn't have, but just make sure you can look in her tray and make sure she has everything that we have. That doesn't matter. Thank you. I really appreciate it. Do you want me to get you a
Great.
soda? I was about to say pop. I was about to. I was so close. And I was like, what is Demetrius doing to me?
Yeah.
Right.
Yeah,
I
no,
didn't
that one
have a
was
dollar
tricky.
earlier. You have a dollar? All right.
Can you email it to them too, so they can copy and paste?
Thank you, thank you, thank you, thank you.
I'm just gonna ask for. Sure.
Well, wait till she comes out, but her tray's right there.
Let me just.
Just look at it and make sure.
Okay,
You can look and see what she already has.
Nope, nope, that's not right.
Them up there, then don't add
Nope,
another
nope.
copy. Hi, Miss Williams, how are you? Wait, what they call you again, Mom? I'm using everybody's nickname these days. I'm almost forget, I keep calling them Dan and
Through the commission of any offense, blah, blah, that
I
same
can't
thing.
remember who I was talking to.
I really abbreviated it, yeah.
Okay.
And then the maintain status, that's the crucial thing. So it's in a criminal streak.
What do you need? I just want the text. Nothing, you can get me.
While in a criminal street gang.
You don't know. That's rude. I wouldn't say that.
Or sorry,
I was
actually,
gonna say
sorry,
you didn't have a
commits in the
dollar.
offense.
Oh. Jesus. Don't be so hard on yourself.
I thought that was funny, but.
Yeah.
You can't help.
Well,
me.
they
You don't have a
covered,
law degree. Right, that's awful.
Commits
Well, I mean, you gotta update the charges.
any criminal gang activity, et cetera, et cetera, et cetera.
Instead of participates in.
Yes, I'm just going by the statute. With the intent
Gang activity with the intent.
to increase or maintain his status in the criminal street gang.
Bruce.
Mm-hmm.
Pretty sworn, this kind of statute, but maybe, with the intent to increase or maintain his status
In the criminal street gang.
in the criminal street gang.
All right, so I'll just do it again. As alleged in count 2, a person commits a violation.
Any violation. But I can check that. Okay, yeah, you love this.
Well, yeah, okay, sorry, that's not the same as this. All right, I'll make it the same as this. As alleged in count 2, a person commits the offense of violation of the Street Gang Terrorism Prevention Act. That's what happens. There's no non-patent term.
Yeah.
When that person, while in a criminal street gang, commits they're different. Commits a criminal offense in the state of Georgia that constitutes criminal gang activity.
Okay.
That's
Pictures
it.
of all the, could you give me an example, like,
minutes.
On a
Any
sheet
criminal
and then
offense
just
put it
instituted
on
Georgia
the-
that constitutes gang activity.
Mhm.
And just.
Oh, and scan, you were talking about this yesterday. Okay, I'll tell her. I'll tell, when do you need it? by?
To,
Is it with the intent?
yes, sorry, with the
You need it
intent
by.
to, and actually to mirror the statute, it would
When
be
we're finished,
maintain or
I'm,
increase. I don't know why they had that flipped in the indictment.
With a trial, okay, so I'll make sure to remind her that, and I'll go talk to her.
Or
about it.
increase this status
Yeah.
or position.
Of the, I get what,
And
yeah.
actually.
Like you said on the
cut position,
photocopier,
they
like
didn't
that.
like that. With the intent to increase, this is just the.
Yeah, yeah. I'll talk to her.
Statute is maintain or increase, so let's do that. Maintain or increase his status
Judge, if we're off the record,
We are.
for some reason finishes extraordinarily early. I don't know that I would mind getting snuck in there today, but
If that's your preference, certainly I'll accommodate you.
it'll be a better resolution after all.
And I mean, in fact, if you, again, if it's 4:30 and she's done and you think you need 45 minutes, just tell me and I'll do that instead. We can go past 5 if that's your preference. And that's
I
what
don't
you
think
wanna
we'd go much past 5, Judge.
Okay. Understood.
When you get a second, would you check? What about this? We had, good job.
Right?
All right, we are back on the record. All parties in council are present, and we have emailed a final version of the charge of 8 pages in length with the additions and alterations that I'd mentioned before. And so unless anyone has any additional spots in this, this would be the charge that I would plan to give. And unless there's anything to take up, we're ready to begin the state's closing.
Yes, Judge.
All
The first.
right, then let's bring in the jury. And I'll note this time for council's attention that I'll keep track of your time on our clocks, state in red, defense in blue. And so you can be no surprises.
Thought we were moving right along too the other day, huh? We have time left over, time to spare.
Yeah,
We have time
Yeah.
to spare, Wes. Whenever that was, Monday.
Oh, then yeah, unclip. Oh, I am in the video.
Right, for the hearing.
I need to put my feet on here.
Thank you, Deputy Scott. Please be seated, everyone. Thank you, members of the jury, for your patience. The state having now rested, we now turn to the defense for an opportunity to present any evidence they would like to. Of course, defense doesn't have to present any evidence, and the burden never shifts to the defense. Mr. Cowan.
Judge, at this time, the defense rests.
All right, so members of the jury, the evidence is now closed in this case, and we can proceed to begin closing arguments. Because the state has the burden of proof, they have the right to both open and conclude closing arguments. And so we'll turn to Ms. Green and ask whether the state is ready to proceed.
Yes, Your Honor.
All right, the floor is yours.
All right. Need your help. Now, when I started this trial, I started with my A words. The defense said I was clever for it. I appreciate that. And those words are antagonizing, aggressive, arrogant, and armed. And you know that is a dangerous combination. After the state has presented all of the witnesses in this case, being over 10 lay witnesses and over 12 professional witnesses, I have established that that is what McCoy was on July 4th, 2024. He was antagonizing several people at the party. You heard from Quinnell May, who described him taking his keys and then attempting to extort him to get his own car back, threatening to rob him and shoot him. You heard him approach Tamika Myers, Stoney. I didn't have to give your boy his keys back, just because he wanted to. But he did, with a car that's now not working. Then you see him antagonizing Polo, who was there to perform and playfully bantering back and forth with him, and it getting a little bit more aggressive through that process. But as Polo maintained, unfortunately looking into the camera saying, "I'm not going nowhere," with a big smile on his face. And that's the last video we saw of him before this defendant took his life. And then finally, antagonizing Mr. Leonard. Now, several witnesses said it was over something stupid. They can't even remember what it was about. But it was simply another way to show I'm me. I'm that guy. And you're not gonna mess with me. That leads us to arrogance. The cocky attitude that he's had towards all these people, he displayed throughout this trial, if you didn't notice. He was cocky, he was laughing, he enjoyed us showing off his tattoos. He even antagonized a witness as they're on the stand. He made it very clear who he was to you through those witnesses and through this trial. Wait, don't forget to get my eyelids. And then he was armed. You heard from multiple witnesses. He had not one, but two firearms. He had one firearm taken from him at the party based on his behavior, when everybody else put their firearm up and left them in the car. And then somehow had another firearm at some point.
Run this bitch. Run this bitch just like a PC. I done fell in love with a thick bitch. I done fell in love with a rich bitch. Shawty know she pressure, talking high blood. Put two girls together like a hybrid. You know I've been trapping since the dollar. If they gon' hate, then let them hate, the money pile up. When your friend calls, say hello, pressure speaking. Tower on the door, but that pressure reeking. I done took a shroom with the 42. Shit, I done started whistling like 42. Shit. Pressure. 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 Yeah, she pressure.
I show that video one more time because after now, when you were hearing from those witnesses, you see that this party was, whether it was in the name of G-Day or celebrating G-Day, these people were having fun. But as you heard from Mr. May, Mr. McCoy was a lunatic. And I believe another witness said they felt haunted. They kept hearing firearms, they kept hearing shots from everywhere.
Run this bitch just like run this bitch just
Can you skip that to the law version? Thank you. Now, I want to thank you for your patience in sitting through trial, a trial that we anticipated being a little bit longer. I'm happy that we were able to finish up every day, but you getting in your vehicles every day and driving into the city, dealing with our construction and our traffic and laying your business aside, we appreciate it. And I want to thank you for giving me the time to present my case. And so now I'm going to go into the law aspect of the case. When you deliberate to the jury room, the court will provide you instructions. That is the law. And you will see a bunch of words on a paper. And those words are important, but what I do is a visual representation of the law that will be provided. And basically go through what the things that you need to be focused on when deliberating this trial. First, you have a duty to be a fair and impartial juror, to honestly seek the truth. You are not to look for doubt. You are not to seek doubt. Instead, you are to seek the truth, and you have a duty to follow the law as the judge charges you. You have a duty to deliberate. If there is anyone in the jury room who refuses to deliberate, I ask that you notify us. Everyone is charged with deliberating and applying the facts of this case to the law. using evidence that is exhibits, testimony, photos, videos. As a juror, everything that's inside of the box, inside of the pink circle, are things that you can consider when deliberating. So of course, consider the statements that you heard from the witnesses. Consider the expert testimony that you heard from the medical examiner and Detective Manson. Absolutely consider photos, documents, videos, and anything else that you saw that was digital. You also must consider the elements of the crime and apply those facts that you heard at trial to the elements of the crime. I believe that your notes are going to come in real handy at this point. The sequence of events, motive, and most importantly, your common sense. Use your common sense when deliberating this case. The things outside of the box, you are not to consider. Your passions, public opinion, your opinion or your unhappiness with law enforcement or police officers. Any other public feeling, sentiment, the sympathy that you may have for the defendant. That is not something that you need to consider when deliberating whether he committed these crimes or not. Any disagreement that you may have with the law. You must apply the facts as you heard them, the evidence that you received, to the law that the judge provides you. Any conjecture, you are not to consider penalty or punishment. That is not this phase of trial. You are simply to determine, did he do it or did he not do it? And any other prejudice that you may have. When the defendant walked into this case, during jury selection, there was a presumption of innocence. The defendant enters the trial with that presumption in his favor. It remains with him until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that that defendant is guilty of the offense charged. And I've met that burden. That presumption of innocence is gone. I also hold the burden of proof. And I remember telling you guys in jury selection and reminding you that I am the person, the state holds the burden in the case. And I keep that burden happily. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. There is no burden of proof upon the defendant. And the burden never shifts to the defendant to introduce evidence or to prove their innocence. Beyond a reasonable doubt, that is the standard that you must reach. The state is not required to prove guilt beyond all doubt or to a mathematical certainty. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth and using your common sense. It is a doubt. If you have a reasonable doubt, it would be a doubt that is based on common sense and reason. It's not vague, it's not arbitrary, but it is a doubt for which a reason can be articulated, it can be given, arising from considering all the evidence that was presented at trial, considering lack of evidence, and considering a conflict in the evidence. Common sense and reason. This is a good example of how we use to explain using your basic common sense. We all drive. Throughout the week, I'm pretty sure you drove from wherever you stay into the city and back. And at some point, you got to fill up the tank. How do you know that? Because there's a light that goes on in your car letting you know fuel is low. Now, did you see the tank? Do you know it's empty? No, but the light triggers you that you need to get gas. You go to the gas station, you put in your card, you take out the pump, you put it in your tank, and you begin to fuel your vehicle. And you watch the numbers go and go and go and go. And at some point, it clicks. And you know your tank is full. You don't see the gas, but you smell the gas. You can feel the vibrations in the pump. And you absolutely can see the numbers going up on the pump. And from those different aspects, you can conclude my tank is full. I have gas. You hang up the pump and you turn on your car, and what happens? It goes from E to F. But did you ever see the gas go in your car? No. But we can use our basic common sense and reason as members of society, using your previous interactions with gas pumps and how it works, that this is a full tank. And that's what we ask you to do when you're applying the evidence to the facts of the case to the law. There is evidence that is direct and circumstantial. It could be both. The law assigns no greater weight to direct evidence or circumstantial evidence. They both can be considered. Now, direct evidence may be seen, heard, or otherwise directly sensed, such as a smell or a touch. It is evidence that points immediately to the issue at question. It may be brought into court in the form of an exhibit or the testimony of a direct witness to whatever incident it is, whatever matter it is. Video footage, cell phone extractions, and eyewitness statements would be just that. So then you have proof of facts or circumstances by direct evidence from which you can infer other related or connected facts. And that's how you use the gas station and the pump example. They are reasonable and justified in light of your experience. So you had certain senses, a feel, a smell, a touch, and then you made an inference from those senses that your tank is full. And in this case, placement of the injuries on the victims. That's an inference from the facts that were directly witnessed by some, and an inference made that the shooting happened behind the person, or as the person is turned around in the vehicle, as far as Mr. Houston. The lack of injuries on the defendant and fleeing the scene from law enforcement, eyewitness statements, and the association, the evidence that was presented of the association with criminal street gang. Credibility. This is a big one in this case because you had a lot of lay witnesses. You, the jurors, must determine the credibility or the believability of witnesses in this case. In deciding this, you may consider all the evidence and testimony in the case, including the eyewitnesses' manner of testifying, their means and opportunity of knowing the facts about what they testified about, the nature of the facts of what they are testifying about, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observed it. And I would ask that you apply these types of assessments to our lay witnesses. I believe in hearing from each lay witness that outside of one, those lay witnesses were truthful and credible. That is my assessment based on their behavior, their mannerisms, the fact they don't even want to be here. They have no interest in the outcome, but they got up here and they told the truth. Their language the words they use, their demeanor, how they responded to certain questions. I think those all should go into your assessment and the credibility of each lay witness. And here are those lay witnesses. DeShante Asbury, one of the most credible witnesses out of all the lay witnesses. Straightforward, straight shooter, and has been consistent the entire time. Martez Rollo Dukes. Mr. Dukes was my first witness, as we recall. There was one statement of the statements he gave at the stand, and then the statements he gave at the time of the crime scene, at the time of the incident. They differ drastically. And so I would ask you to assess his credibility on the stand versus his credibility when he was given the statement right when it happened. Look at his mannerisms in the body camera. Look at how he's speaking freely and inhibited. But think about how he responded to me and my questions in here. Was it freely? Was it inhibited? No. But on the scene at that time, he spoke freely. And if out of all the witnesses, if there is a video that you need to watch again, request to watch that video again. If you need to assess his credibility, because you can request to watch a video if you need to. Then there was Tamika Stoney Myers. I know you remember Tamika Myers. She had to have a moment, a break, and we had to take her away and let her calm down. Assess the credibility of that. There is Yasmin Bella Myers, her daughter. She actually explained the trauma that her moms went through, which is why she has that type of response to trauma, especially shootings. Assess her credibility. She was actually the one that wrote on the paper that I didn't see anything. One line, I didn't see anything. But then on the stand, you heard her give a full account of everything that occurred. Well, assess the credibility of her in that. Jametta Taylor. Miss Taylor, what a calm, soft-spoken voice. She said her encounters with McCoy. Quinell May, one of the last witnesses that we had that were lay witnesses yesterday morning, where the defendant started laughing at him as he was testifying. Think about everything that he said, also not wanting to be here at all. Flew all the way from Detroit to be here and testify and got right back on a plane and left. He does not want to be in Atlanta. He has no interest in being here, but he came and he did the right thing. Consider all the surrounding circumstances. Mike Demo Williams, his believability is based on all the things that actually support him. So everything he said, we actually kind of showed it to you. The lead detective showed you information to support his statements, as far as there not being any camera footage. Then we showed you the property that he had, and everything that he said that happened that day, we could actually point it out in the photo. So consider those things when you're considering the credibility of Demo or Mr. Williams. Philip Grimes. I even believe Philip Grimes was credible. He absolutely saw nothing. And the only thing he heard was Miss Explicit. And I believe that that is true. Based on his candidness and being forthcoming, I believe that his behavior showed that he was very credible. Shadia Callahan. She also didn't see anything in the vehicle with Mr. Grimes. So then you have Mr. Xavier Smith, who came. He didn't see anything, but all he remembers is the stupidest argument. He couldn't remember what the argument about, but it was stupid. Over nothing, so stupid that he walked off. Kiara Wallace, you heard from her, and then you heard from Ms. Sherelle Williams. And they gave you an account of how Mr. Houston and Mr. Leonard was in life and their credibility. But one of the things I think is really important is that think about all their statements as they relate to each other. there's not huge conflicts in their statements. They're just in different places on the property and doing different things at the time. But if you put it together, they're mostly consistent. And what I promised you in opening, I did it. I brought every witness, even if it was a witness that didn't see anything. I brought them because I wanted to show you who was there and for you to assess their credibility in their statement, including flying people down. I wanted you to be able to assess. There's only I believe 1 or 2 people missing, and it was just guys couldn't find them. But out of the majority of the people are here, this is 1, 2, 10 witnesses. I believe there's 2 more though. And I was not able to get them there, but they gave a fair account of what happened that night. The credibility of the officers, Officer Kelvin Thomas, Sergeant Walker, Officer Fullerton, Officer Castor, the crime scene technicians, medical examiner, and your lead detective, Principe, an amazing witness, very credible, Kenya Manson, who has 19 years of experience and was very knowledgeable in what she had to testify about. Now, we did have some inconsistencies with the crime scene tech of whether the casing was, fresh or whether it was old. And then we also, who claimed the ownership of the gun? Was it Ashbury or was it Polo's gun? But in the grand scheme of things, those things aren't the make or break to the case. The case is an eyewitness case. Whether the casing was on top or on the bottom, not associated, there were several people that testified that Mr. McCoy was your shooter. And there was one person that was standing right there when it happened. Whether the gun belonged to Ashbury or somebody else, the gun was never used. It was just in the vehicle. There is no evidentiary value to any casings in the gun or any return fire. There was only 2 shots to the vehicle. One into Mr. Houston and one into that dashboard lockbox. Intent. Intent is purposely doing an act. Intent may be inferred from the proven facts and circumstances or by acts and conduct. It may also be inferred when it is the natural and necessary consequence of the act. You may find intent through words, conduct, demeanor, motive, and other circumstances connected with the acts related to the alleged crimes. With intent, I ask that you consider the evidence that was presented prior to the conduct that was presented prior to the event, the conduct that was during the event, and the conduct that happened after the event. And use that conduct right before the event, during the event, and after the event to determine the intent of Mr. McCoy when he committed these acts. Before, antagonizing other party goers. You got Quinnell May, Jametta Taylor, Tamika Myers, to mention 3. Embarrassed in front of women. I know this seems small to some people, but it's a big deal to others, especially when you believe you're that guy. You don't embarrass me. You don't disrespect me. And one of the words that, one of the statements that Mr. McCoy made prior to Mr. Leonard, or engaging Mr. Leonard, is that he tried me in front of, and I don't have to finish. I think I've said it way too many times. But to someone else, maybe to us, it's just like, whatever. But when you're that guy, when you think you're that guy and you're arrogant and you're being, you're being little man, or you're being embarrassed, belittled, everyone's laughing at you. That's important to Mr. McCoy, who is absolutely arrogant. And if you notice with Detective Principe, I pointed out how many different people were posting that moment. It was at least 4 different accounts of posting just that moment with everybody laughing at Anthony McCoy. Cause he's trying to pick up a 287-pound Joshua Houston to throw him in the pool, and he can't do it. The argument with Leonard. The defendant's social media. They let GDs in the door. That means something. During the conduct, you have the argument with Leonard. You have Leonard walking away. You have Leonard walking away. Then Joshua Houston, the trigger for him was, do you need a ride? Okay, we'll give you a ride, but let's go we gotta get Dan. Immediately exits the car when he hears that name. That's the conduct during, right in the moment of the shooting. That should be considered when assessing his intent level. And then consider the conduct after. Mr. McCoy did not stick around to give his statement. If he didn't do anything wrong, he didn't stick around to provide he fled the scene. And then you heard with the cell phone extraction, he downloaded and started to access the Greyhound website or application within 24 hours of the incident. The power off on his phone minutes after the homicide. Minutes powering off your phone in hopes that you won't be located. And then when arrested, he's in possession of a firearm with an extended clip. Months later, and you heard Detective Principe say, oh, that's very common in my line of work, what I do as a homicide detective. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Criminal intent is not the intent to violate the law, but means simply the intent to commit the act that is prohibited. Criminal gang activity. Now, this is a statute that is pretty lengthy. I am going to prepare you. When you receive the law, it is maybe a page and a half long of the statute of criminal street gang activity. And so that is why Manson created the PowerPoint to kind of break it down in a digestible way. The iron triangle, connecting the crime to the gang to the person. Establishing that there is a crime, establishing that he is associated with a gang, and establishing that the gang exists, which is Gangster Disciples. So a person commits criminal street gang activity when he is a member or an associate of a gang. I don't have to prove that he's an actual member. I only have to prove that he has associated himself with Gangster Disciples. That's the law. The person participates in gang activity while breaking the law. So, for criminal street gang activity for count 1 and count 2, you have 2 subsections, A and B. The thing that changes on this, between the two is the nexus. And so I'm gonna break this down into 4 parts, okay? First, you have to prove the existence of a criminal street gang. You heard history, hierarchy, structure, offenses, types of crimes committed, book of knowledge, Founders Day, all the identifiers, the Star of David, the pitchforks, the 7, the 4, of proving that Gangster Disciples is a gang. Then you have to prove that the defendant is associated with that criminal street gang. And I believe McCoy has made that very clear with his social media, with his words, his own words, with stating, I'm gonna spare you on GD. He has always repped his gang since 2018, celebrating Founders Day for 7 years now. Then that the defendant participated in the charged criminal offenses. So you have to also determine whether or not the defendant committed those crimes. And that would be murder, felony murder, criminal damage to property to the vehicle that Mr. Asbury was renting at the time, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. Just my suggestion, as a person that has to apply this all the time, start there. Did he commit the crime? And then work your way to the other ones. And then, nexus. You have to be able to establish or be able to establish beyond a reasonable doubt that the nexus between the crime and the gang was committed to further the interest of the gang. And with that nexus, there are several crimes that are several crimes that are enumerated or in the statute. These crimes being the crimes that are in that statute, and that these are the types of crimes that are committed by the gang and in further the interests of the gang, the motive behind it, the nexus, the connection to it all. And I believe there's very strong evidence that that nexus is clear. B, all the other three stay the same, but the nexus change. With the nexus on the subsection B, you must establish between the crime and the gang with their intent to maintain status and position in that criminal street gang. I think Manson was very clear on this as well. The way it was carried out, the reasons for which it was carried out. It was public. It was traumatic. It had the effect that it absolutely was supposed to have, especially when trying to get witnesses to talk. Nobody wanted to talk, even till now. Didn't Ms. Meyer say they just felt haunted? That's the whole purpose. You don't disrespect a member of the gang without consequence. And I will show consequence to maintain or increase my status in that gang. Because when you disrespect me and I do nothing, that's not maintaining your status. You maintain your status by responding. Now, an additional part that needs to be established with case law is that meaning when going, let me go back to the other slide. When considering the nexus, and I apologize, my slide is wrong. This is for subsection A, in furtherance of the crime, in furtherance of the gang. You must, there must be an establishment that proof of the crime committed was the sort of crime that the gang does. But not simply a crime that a member of the gang may have done in the past. So that's really what I want you to focus on this slide. When it comes to nexus for subsection A, ignore the rest, I apologize. Meaning that, just like Manson stated, these are the types of crimes that gangster disciples commit. Anthony McCoy is a gangster disciple, and he committed this crime in furtherance of the gang. So I have to, for the nexus for subsection A, I have to prove that the crime was committed is the sort of crime that the gang does. And she mentioned that this is the crime and is codified by statute, the types of crime that is committed by criminal street gang members. But in addition to that, it can't just be a crime that was committed by a member of the gang. Let me give you an example of this. If Anthony McCoy was married and he was upset with his wife. He killed his wife. Right? They're in a domestic dispute and he shoots and kills her. Just because Anthony McCoy is a gang member and he did a crime that gang members are known to commit, such as murder, and that doesn't mean that that nexus to the crime was in furtherance of criminal street gang activity. That's just that could be just domestic. So just because you commit a murder doesn't mean it's automatically the nexus to a criminal street gang activity. I think I'm clicking. So this is completely different. This isn't a family member. This isn't domestic. You heard from Ms. Williams yourself. This is disrespect being addressed immediately. Now, for murder, I believe this is count 3 and 4 in your indictment. The state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. Malice. I know that's not a word we typically use in our everyday life, but malice is not necessarily ill will or hatred. Rather, it's the unlawful intent to kill. You may find malice when the circumstances show express malice, which is the defendant acted with the deliberate intention to unlawfully take life of another person, or implied malice, where there does not appear to be a significant provocation and all the circumstances show an abandoned and malignant heart. I believe for Mr. Leonard, that's expressed malice. But either one of them works to establish murder. I believe it was Tamika Myers that said after he shot him in the back of the head, he started to kick him. Man, get up, you ain't dead. Stood there and kicked him as he's bleeding out the back of his head. You can consider his actions surrounding that murder to establish malice. Shooting him in the back of the head while he's walking away, doesn't even see it coming. That's expressed malice. But if you find implied malice, either way, that's murder. Premeditation. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it's murder, regardless of how briefly the malicious intent existed. And that's a good example when it comes to Leonard. I don't believe that the kicking of him was really to make him get up. He knew he wasn't getting up. But to shoot somebody and then go, oh shit, and run off, it's still expressed malice because you had it in that moment. You need it right there in that moment. No specific length of time is required for malice. Got ahead of myself. Just to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that's enough. That's enough for murder. Same with Joshua Houston, who's literally seeing is he okay? Does he need a ride? And unfortunately for him, he said the wrong name. And jumped out of the car and got shot in the chest immediately. That's malice. Because you can get out the car and go away and keep running. You chose to shoot 2 more times, killing that man before running away. It's malice. Motive. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. So all of the things that I have presented as far as why it happened, what was the purpose, what was he thinking, I don't have to prove that. But doing that, it gives you a full picture of the day and what happened leading up to it. But motive is not required, and I don't have to prove why he did what he did. I only have to prove that he did it. Felony murder. The state must prove that the defendant, one, caused the death of another person by committing a felony. There are several felonies in the indictment: aggravated assault, criminal damage to property, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. Those are all the predicate felonies. And if you determine that Mr. McCoy committed those crimes, and those crimes resulted in the death of either decedent, Mr. Houston, or Mr. Leonard, that's felony murder. He committed the other felonies, and it led to the death of another. So on felony murder, no proof of malice is required. No intent to cause the death is required. If the death occurred while the defendant was engaged in the performance of any act required for the felony, it is felony murder. But you are to examine every count in the indictment. You need to apply the facts to the murder charge and to the felony murder charge. You don't pick and choose. You assess the facts to the law that's presented to you. McCoy's behavior also fits felony murder. And he is guilty of both malice murder and felony murder. Aggravated assault. Aggravated assault, a person commits when he attempts to commit a violent injury to another. The assault was made with a deadly weapon. Actual injury does not need to be shown. However, here we can show actual injury. And a firearm is a deadly weapon as a matter of law. And the court will instruct you of that. So count 13 in your indictment is the aggravated assault of Corey Leonard by shooting him. Count 12 of your indictment is the aggravated assault of Joshua Houston by shooting him. He is guilty of count 12 and count 13. And if that resulted in the death of Houston and Leonard, he is also guilty of the felony murder for both of those aggravated assaults. And if you find that he had malice at the time, he is also guilty of murder. Possession of a firearm during the commission of a felony. A person possesses a firearm during the commission of a felony, and the felonies in this indictment is murder, felony murder, aggravated assault, and criminal damage to property. And the firearm includes any handgun. Criminal damage to property. Now this relates to DeShante Asbury, the Lexus that he was in possession of during the time. You heard testimony that he rented a vehicle, and that was his vehicle at the time. A person commits criminal damage to property when he knowingly and without authority interferes with any property in a manner as so to endanger human life. And he absolutely did that. He shot twice into that vehicle in close range of both of those people, killing one of them. And then the last one is possession of a firearm by a convicted felon. Now you have two of those. And that's count 16 and count 17. For a possession of a firearm by a convicted felon, you must establish one, that he possessed a firearm, and two, after having been convicted of a felony. I read you off two separate felony convictions today. And reading out those felonies that were included in those convictions. And that is the basis for the count 16 and the count 17. If you find that those felony convictions that I read out in open court are convictions, then the other thing that you have to establish for 16 and 17 is that he had a gun. Now, at this time, I'll explain this a little bit later. At this time, I'm going to allow, to take a break and allow the defense to come forward with their closing, and then I will return to you and finish out my closing.
Go ahead, Judge.
Just one approach.
Can you take that down?
Good afternoon. It's been a long call for you, and look at your life. She was gonna come back because that's what the state is to do. And she's gonna exercise that. Occasionally the state will wait or open it. Pencil open. They still get the last word. They still get to speak to you last. And this is typically the way it goes. I get sandwiched in the middle. And I get to argue on behalf of someone and you have to my client. Only in the middle, and you'll get your fellow last. Not good. There are a couple of things, just to begin, that I want to mention to you that is premised on the state's case. The state tells you, it has told you from the beginning, that I wish I could remember all the 4 A's, but aggressive was one of them. And yeah, my client's aggressiveness was what began to set the tone for that entire day, July 4th of 2024. But they show you one video, and in that video, they show you this huge young man, Mr. Houston. I think she said he weighed 287 pounds. I wouldn't dispute that after seeing the video several times. And he was also 6'4". The witnesses mentioned this, I hope you remember it, and the state mentioned it in their open. Mr. Houston had playfully, apparently, already thrown Anthony into the pool. So Anthony's talking to him. And he's telling him, he's trying to pull him down to the pool so he can return the favor and throw him in. Now, there's no malice involved there. In fact, you don't see it in the video. That's something you get to see, you can't see it. That there's not a hint of anger or malice. And the only person, as lead detective Preston conceded, the only person to ever put their hands on was the person who led him down the, and I'm talking about Anthony, led him down the hill. In spite of all of the nasty words and the recriminations that this man, Mr. Houston, is throwing at my client, he acted, he wasn't dismayed by any of it. He just stood there. Occasionally tried to nudge him down there because he was going to throw him in the pool. He couldn't get down there. He couldn't lift him. Him and 3 other people couldn't lift Mr. Houston. But it was also my client that when somebody was talking to him from the bottom of that hill near the pool, they said, "We're just playing." And they were. They were just playing. And there's no indication that they were ever doing anything else. But this is what the state's case is premised on. And my client was so upset because he was being made to look foolish in front of someone that he would then kill Mr. Houston and Mr. Leonard for whatever reason. And yet that's not what they had fixed. And I hope you do. If you don't remember, you haven't made notes and it's not in your head. I hope you do look at it, because the only person that's touched, and he's not touched forcibly, but led down the hill, is my client. And he doesn't seem particularly mad about that either. They go down the bottom of the hill where the pool is, talk about it. He was the one that got thrown in. he wasn't gonna be able to lift Mr. Houston and carry him down. So, cool. Now, that brings me to, I segue into the two-gun theory. Old enough to remember it, I don't know that any of you. We have the soul assassin theory. Got grassy knoll theory. At my age, there have been enough political assassinations and enough conspiracy theories to write a library full of books, and they've been written about. This is the two-gun theory. What I was thinking about during talk. This is something the state keeps saying, but they never prove. And here's how they say that they prove it, I think. My five friends made in words on no shirt all the time. He's been thrown into the pool. You never see a gun. You never see a gun on him. You don't see where he can put it. And then there's a security guard, among 6 security guards apparently. There's a security guard who had taken his gun according to Roland. Marquez. He says, I don't remember who it was, but he said he couldn't give it back or not to give it back. He says he took it from my client. Not one gun, 2 guns. So even though there were 6 security guards, you had the promoters on the stand, you could ask them questions, and you did about who these security guards were. They didn't know, didn't care. Only Rollo Dukes seemed to think that that had happened to begin with. And where he came up with that is anybody's guess. But there was no gun that was taken by a security guard that the state proven. I mean, the state can't prove that it was a security guard. The state can't prove there were 6 security guards. But it hasn't proven there were 6 security guards. But they certainly haven't shown and they haven't proven that the security guard took a gun from my client and never gave it back. To leave him with a second gun, and it's their theory that there are 2 guns that you never see. You've got video of my client, you'll probably see some more during the state's closing. You've got video from the state of my client in dripping wet swim trunks the first time after he'd been thrown in the pool, and no shirt. And testimony was he didn't have a shirt, and he never put a shirt. So where are the 2 guns? Where would the 2 guns have been? Have they been hidden? He didn't go into the pool with the guns in his pocket. Nobody saw him with a gun. Nobody ever said they saw him with a gun at the party. And speaking of party, reason I made a point of emphasizing to you in the opening that this wasn't like a church social. That this really was a gangster disciple gathering. And the gangster disciples are a criminal enterprise. And the day to celebrate was 7/4, and that's what they were doing. So yeah, there may have been some perfectly innocent people there accompanying other people that were part of the criminal enterprise, part of the gangster disciples, but this was not a party for the timid. Guns were apparently locked away in cars because that was the policy, a good idea. But everybody at some point had that place. And remember that after this gathering was finished, they were cleaning up. Those security guards were long gone. We had a witness to testify. There were no security guards. So anybody inclined to get a gun from their car or anywhere else could have done that. And probably did. That's the 2-gun theory. Where is the gun on my client? Like I said, videos, testimony is he's thrown in the pool, then it gets wet, can't use it. There's no evidence that he's got a gun protruding from his person somewhere. And nobody ever even produced a name, much less a security guard who had confiscated the gun from my client. Now, to take it one by one. Mr. Leonard just like Mr. Houston didn't deserve to get murdered. Both of them were shot, murdered by someone. State from the beginning has come in and said that it was my client because at the verdict, he's the one that's not there. So there are several people that say it's this guy who's 5'6" or 5'7", like 5'6" or 5'7". Anthony, would you just stand up for just a second, please? Anthony is closer to 6 feet tall. But have a seat, thank you. Then the law enforcement folks who were, I will admit, overmatched, called out in the middle of the night and stayed there until 3 hours after the scene came up, processing the crime scene. They started looking for someone in really quick fashion. They were able to find through the TZ or TEZ social media. That isn't like a lot of criminal social media where you've got the bag of money that you just stole from the bank in one hand, the gun in the other. People do that. It's just your regular social media, and this is him, my client at this party. I don't know why everybody thinks that's kind of thing reporting, but that's what it is. Pointed out, that's the guy who's here, that's the guy who left. We don't know exactly when he left. But I want to remind each and every one of you that Martez, known as Rollo Dukes, when he testified under oath here, did not point my client out and did not say that my client shot anyone. That was his sworn testimony. The testimony, which wasn't testimony at all, that the state wants you to focus on and to remember, is a video of Rollo speaking to one of the detectives. It was Detective Thomas, the male Detective Thomas. And you look at that video again if you need to, but think about it and ask yourself if he was as intoxicated as somebody could be, and he told you in his testimony, when he was testifying on the witness stand, that he was drunk. And he was really drunk. So you've got a very, very drunk Martez Dukes rambling and going on and on and on for 10 minutes or more about what may or may not have happened that evening, or whether he was involved. Because he had evidence, and because it was his birthday. And he made a point of telling them it's his birthday. Black Death was his day to celebrate, but they had already celebrated. And he went on. His sworn testimony was from the witness stand under oath, and he said he didn't see anything. He certainly didn't point my client out as shooting. The second murder that happened in this dark parking lot. The question was, and the best witness of the trial, in my estimation, was young Mr. Asbury. Mr. Asbury was a bright young man. He came in here under difficult circumstances and testified about what happened to his friend Polo. He got emotional. At one point, but was able to finish his testimony. He did well. And as was demonstrated, he had to take his friend and make that decision to take his friend to the hospital instead of waiting on the paramedics to get there and take him in. I guess that's the only hope that Polo would have had to have survived his gunshot wound. He got in there safely, where he was interviewed in the parking lot by now Detective Sergeant Walker. She had been investigator Thomas, and she testified. And in that testimony, he said himself several times that it was very dark, and he said it from the witness stand. But here's the thing: standards that you're going to be charged with, the standards that you're going to be informed that you are to follow, is beyond a reasonable doubt. You have to find any defendant in our country, our judicial system. And you'd have to find Anthony guilty beyond a reasonable doubt. Now, what is a reasonable doubt? The state told you one explanation is good enough, except that another way to look at it is the doubt of a reasonable person. Honestly seeking the truth is what's crazy. And as reasonable people go, I mean, I know that all of you probably assume that you're reasonable people, and we think you are too. There's something sure. You have to find my client guilty beyond a reasonable doubt. And Mr. Asbury was very honest, very candid, and his testimony was as cogent and concise as anybody's that we heard. And he also seemed to have no dog. I mean, you know, he was, if he was drinking, he wasn't drinking a lot. He said he had a shot. Asked him if he had a shot. He said, well, I had a bigger shot. So, I think he told him the truth. Mr. Asbury said, when he was shown those that photo line, picked out number 8, he said, it's 90% sure. And when he was on the witness stand, he was asked if he was still 90% sure, and he was still 90% sure. Reasonable doubt. Good work. Reasonable doubt is a steep hill to climb. It's the highest legal standard that we deal with in our system. You have to find my client or any defendant in this country guilty beyond. 1 out of 10 doesn't sound like much, but it's not nothing. We've had weather forecasts. My lifetime. 10% chance of rain or snow. They're rain or snow. Doesn't mean 90% itself is enough to create reasonable doubt in your mind, and that's the standard that you're going to be asked to apply in this case. There are some peculiar lay witnesses. And one of them was Mr. May, who flew in from Detroit. And I think he was brought in just for entertainment. Right. Campus. He didn't want to be here. The state made a point of telling me he didn't want to be here. He made a point of telling me he didn't want to be here. And he had absolutely nothing to tell you once he got here. You could identify my client, but he didn't tell you that he was a shooter. He didn't tell you that he shot him. He told you that he stole his keys. My client stole his keys. Not on the video. It's any much discussion about stolen keys. Stole his keys, and he had a gun. He would have shot my client. I don't know that Anthony took anybody's keys or not, but it didn't seem to be an issue at that gathering that day. Mr. May got on the witness stand and just entertained you. And as the state said, he had come all the way from Detroit to do it. He got a paid for round trip to there's people in Atlanta. Remember, he had a Mercedes that parked there July 4th, 2024. He knows people. He said he got a free round trip ticket from Detroit to Atlanta to come down and visit and hang out with his friends. And then he put on a show for you about how much he didn't want to be here. The state was his setup man because I asked. And they did shoot my client if he had a gun because my client stole his keys. So that was just for entertainment value. I would not consider anything, I would urge you not to consider anything Mr. Mason against my client because he didn't have anything to say that had anything to do with my client. Myers, both Miss Myers, the daughter and the mother, both gave statements at the scene. Both of them didn't see anything. These people should be taken for their word. They never recanted that. They never said later on if they saw something that gave any detail or heard anything that gave any detail. Alcohol should be figured into this equation because everybody was drunk. I mean, everybody was drunk in this place. They had alcohol for $40. You can get in. You can get in and be there from 3 until 9 o'clock or so. And drink. And if you have any doubt, if there's any doubt left in your mind about what kind of gathering this was and what was likely to happen, nothing good could have ever come from it. There were guns, there were lots of alcohol. And if you think that anybody there really respected anyone, particularly women, when you're listening, when you're watching the videos, listen to me. I'm just like, really listen to this. I know that we, and I'm not being kind of, I'm not being foolish, and that's what we could be using. But that was the reason that these folks were celebrating 7-4, so that they could carry with this philosophy that you can treat anybody the way you want to with guns, money, and treating women poorly are all okay in that world. Celebrate that. Nobody there was celebrating 4th of July. I would urge you to take that into account, take into account the alcohol, because there was plenty of alcohol. And everybody there was drunk. Look at Mr. Rollo Duke's video again if you have to. And watch the rambling. Remember, he told you he was drunk, and then just ask yourself, would you believe anything Mr. Rollo Dukes told you? He apparently wasn't drunk when he was in here and under oath told you he's. So, in addition, Mr. Asbury telling you it was dark. He had trouble seeing that he was certain of the person that he picked out, but only 90%. 90% certain is not enough to convict my client or anyone else. The standard is beyond a reasonable doubt. He wasn't the only one to talk about the darkness. Everybody talked about the darkness, and they weren't provoked. It wasn't like, I cross-examined them and said, no, it wasn't dark out there. They just brought it up. It's dark. We couldn't see. We only see when we saw the car's headlights. We could only see when the police cars were illuminating the parking. The law enforcement witnesses said the same thing. Detective Precedent said the same thing. It was very dark. So that's where Mr. Asbury was with Mr. Houston in the car, waiting on Dan or Mr. Leonard, when he says that he noticed his shoes, not faces, and it was so dark that the only thing that illuminated his car were his headlights that went off in the other direction. And then he candidly told you, when he circled number 8, the photo lineup, he was only 90% sure. What's interesting about that is no matter how many times it's been spoken to, prepped, or anything from this trial, he still told me the same thing when he testified yesterday. So, nobody saw my client, according to sworn testimony, shoot Mr. Asbury, the only witness, credible witness, to Mr. Houston's shooting. It's no more than 90% sure. No more than 90% certain. The judge is going to give you several charges and give you several pages of charges after the state concludes, after the state concludes. It's called a charge to the jury, but on the last page or so, deep into, and one of the very last charges says essentially this. It's about deliberation. You go to the jury room, select a 4-person, and deliberate. It says deliberate. Pay attention to your fellow jurors. It says, listen to your fellow jurors. Have an open mind. It also says that if you have doubt and if you've formed an opinion, don't let somebody move you off of the opinion, just to be, I think, the language is congenial to your fellow groups. So be strong in your opinion when you reach it. But deliver it. Listen with an open mind to your fellow groups. That's what you're supposed to do. A closely held opinion before. Don't let that go. Just so you can get genuine. Hope you, I know that you're diligent and conscientious jurors, and saw you make notes. Saw the way you listen to the witnesses. Want to strike. I hope that you'll take all of this to heart. Not do the wrong thing. I hope that you will come back with verdict, quitting our fire. The gang charges I want to address is Councilwoman 2 of the 11. The only witness was really Detective Manson. Detective Manson said that there's an iron triangle and you have to fulfill those things. She also told you that just being a member of a gang isn't fine. Just being a member of a gang and committing a crime doesn't make you guilty of criminal gang. But in a kind of confusing way, she said that there has to be some nexus between the two, the three that form this tribe. And I defy anyone to say that it somehow furthers the goals of an organization, and Gangster Disciples and all the others are organized hierarchical organizations, just like IBM or Apple is. Difference is that they will resort to building means to get to where they want to go. If 2 murders were committed by a member of Gangster Disciples, it didn't do anything to further the goals of the organization. If anything, it set them back, and that would not fulfill the purpose of the statute that you'll have to decide. There's going to be a jury instruction on that also. So I urge you to also return the verdict of not guilty to the gang charges. Yes, thank you all very much.
Thank you, members of the jury, for your patience today and attention. We will resume with the state's final closing argument in the morning, and then from there I will charge you on the law that applies to this case, and you can begin your deliberations. And so I would say that we'll resume at the normal time tomorrow at 9 a.m. And whenever you're all here, we'll continue. I'll also note that since we would probably have you here, and from here we're on your time, that we were going to provide lunch. If you want to take advantage of that, we'll have some pizza here, I think starting around 11. Whenever we break for lunch, you can decide to work through lunch. You can still leave and pause for the hour. It's really up to you as a group. But I just want to make you aware of that so you can pack lunch or not. If you want, we'll have plenty of food here if you want for that. So please, as I dismiss you all for today, don't discuss the case with anyone, including amongst yourselves. Don't do any research about the case. We'll see you back tomorrow morning at 9 a.m.
All right, for the jury.
Thank you, Deputy Scott. Thank you, everyone. We'll be in recess at 9 a.m. tomorrow.
Got it.
We're off the record.
We got it.